Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, September 25th, 2019. The time is 9:15 a.m. and we are meeting in the hearing board room in Diamond Bar. We have a hearing board general meeting later on in the day in our schedule. We have one matter for hearing today, and that is Howard Industries, case number 6153-1 for an interim variance. And who is representing Howard Industries this morning?
Matthew Williamson with the law firm of Manat, Phelps & Phillips.
I'm sorry, can you repeat and spell your name for the...
Sorry,
okay.
It's Matthew Williamson, M-A-T-T-H-E-W, W-I-L-L-I-A-M-S-O-N, with the law firm of Manat, Phelps & Phillips.
Thank you, Mr. Williamson. And who is representing the executive officer today?
Mary Reichert on behalf of the executive officer.
Thank you. The request, again, is for an interim variance, and I do understand, Mr. Williamson, that you are aware of the elements that we need for good cause, since I've seen it in the petition. Is that correct?
I am.
Okay. And so what we will do, board members, is we will bifurcate today's hearing, and we will begin with a hearing on good cause and whether the good cause findings can be made. Before we start, though, I'm going to ask anyone who wishes to testify or potentially testify in today's hearing, and that includes, we did receive, even though this was not noticed to the public, one speaker card. So anyone who wishes to testify and also any who wish to give public comment, please rise at this moment to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. And before we begin with openings, we also received a comment letter. And at this time, I'll ask everyone to please make sure your phones are silenced. And that is on Lennox International letterhead dated September 25th, 2019. And we're going to mark that as P-1 for public exhibit number 1. And with that, I'm going to ask Mr. Williamson to begin with your opening on good cause.
Thank you, board members. Howard Industries is here today asking for an interim variance, which would cover the period of time from October 1st, when the changes to Rule 1111 that are impacting Howard Industries go into effect, through November 7th, when we have a regular variance hearing scheduled in front of the board. Again, it's a 30-day period of time in order to address compliance issues that Howard Industries is facing in regards to new ultra-low NOx requirements that are going into effect under Rule 1111 for residential furnaces that Howard Industries sells. Howard Industries is a family-run business. It's been in the family for 3 generations, 60 years. It's located almost entirely within the district. It does have one small warehouse in San Diego. It does do a very small amount of business in Ventura, but otherwise is again, almost extensively or exclusively within the district. It employs 75 employees. Many of these have been with the company for many, many years. Again, this is a company that has been in the same family since its beginning, has grown up from a small company, is now a significant presence in the HVAC business in Southern California. This will come up a number of times throughout the day, but it's also to remember that Howard Industries does not just sell HVAC equipment. Howard Industries is a full distributor of HVAC equipment. And what that means is they don't just sell the equipment and wave goodbye to their customers and they're on their merry way. It's not a Home Depot type transaction. What they do is that they act as essentially the local rep for their manufacturer of their HVAC equipment. In this case, it is American Standard, who is a subsidiary of Ingersoll Rand. And so they have to supply parts ongoing for their customers. They have to supply service. They have to supply warranty services. So this is a long-term relationship that they enter into with their customers. And again, their customers are not you and I, who are the residential homeowners who install the furnaces. It is commercial contractors who do the work and install the furnaces as part of either a replacement or a new build in the home. So moving on to the good cause elements, which I have and can put up if it helps. I certainly have it on my screen.
What do you mean you have? You have the...
Just the elements. I did it to help me walk through. If you guys would like to see them, I can share my screen with the rest of the crew. Walking through the requirements to show good cause for an interim variance. The first being that petitioner is in violation of, in this case, it's Rule 1111 of the district, or that such violation is imminent. As I alluded to, the issue that Howard Industries is facing relates to Rule 1111. And on October 1st, the requirements under Rule 1111 are that residential furnaces sold into the district have a NOx emission limit of 14 nanograms per joule. The current emission limit is 40 nanograms per joule. Previously, the district has allowed distributors and manufacturers to continue selling the 40 nanogram per joule furnaces within the district, but have required a mitigation fee. It's $300 or $350 in order to sell them. And what happens on October 1st is that mitigation fee is going away, and the rule now says you must sell furnaces that are ultra low NOx, which is that 14 nanograms per joule. I'm going to use this, and I assume the district will throughout the day. The term ultra low NOx is what I'm going to do to refer to the furnaces that are the 14 nanograms per joule, and low NOx is the 40 nanograms per joule, just so that the board is clear with the terminology there. The issue faced by Howard Industries is that over the past year and a half, they have been seeking out a source and a partner in order to supply them as a distributor of furnaces in Southern California with ultra-low NOx furnaces to comply with Rule 1111's new ultra-low NOx requirements. Unfortunately, their current manufacturer and partner, American Standard, has been unable to develop ultra-low NOx models in time. They've also reached out to other manufacturers that have ultra-low NOx models, but as of today, they do not have any agreement with any of the manufacturers to supply them with ultra-low NOx models. Some of the manufacturers haven't responded to our inquiries, so we don't know if it's a matter of the manufacturers don't have the supply of models. Some have responded and told us that they don't have enough models that they could supply to us in order to meet our demand. But the reality of our situation today is that we have not found a source of ultra-low NOx models that will get anywhere close to meeting our customers' demand in the next 6 months, and certainly not in the next 38 days. And so on October 1st, we are in a position where we are imminently going to be in violation of Rule 1111's ultra-low NOx requirements. Moving on to the second element, the circumstances leading to the violation could not reasonably have been avoided by petitioner or anticipated in sufficient time to provide for public notice of the variance hearing. In discussions with the district, I understand that they are opposing our variance petition, and this is one of the grounds that they are opposing the variance petition on. Excuse me, I'm going to get a drink so I don't start coughing. The district's position, as I understand it, is that because we have known about the lack of supply in the district of ultra-low NOx models for at least 6 months, and certainly have known about the Rule 1111 requirements for it since they were amended back in 2018, is that we've had plenty of time to evaluate the market, and that we should have therefore filed a fully noticed regular variance hearing with the 45-day public notice. But the reality is that we have, it's true, we have known about this for quite some time. And I'm not going to get into it because I want to save this for it's much more relevant to the looking at the 6 variance factors. And I don't think I need to go into quite all of the detail here for the good cause portion. But looking at the last 6 months is very critical as far as our good cause for interim variance hearing. And in this case, back in June of 2019, we met with the district. I wasn't engaged as a lawyer yet. It was a consultant that worked with the company, Howard Berman, and the client met with the district. They were at a point where they realized that we're getting close to October 1st. Our current manufacturer is now telling us that we're not going to have models ready by October 1st. We haven't found anybody else that has models that they're going to be able to provide to us. We need to go to the district and we need to talk about what our path forward is because we have a problem. As a result of that meeting, I guess during the meeting, and based on the history of the client has previously gotten a variance under Rule 1111. Historically, they had a similar issue many years ago. And so their idea is we'll go to the district and we'll have a discussion again about variances. So they go to the meeting with the district, the issue of variance comes up, and the response from the district is, we ask that you not file a variance. We will oppose the variance. We do not want a variance to be filed and for other manufacturers, other distributors in Southern California to join that variance petition and have everybody pile on, and then we have a bunch of parties that are trying to avoid Rule 1111's new ultra-low NOx requirements. The alternative offered by the district is we can do this as an order for abatement. We would like to negotiate the terms of that order of abatement well in advance of October 1st. We can negotiate the penalty that you will pay for each furnace that you sell into the district after October 1st. And so we left the meeting in June of 2019 with the understanding that our path towards continuing to operate and avoiding issues with violations of Rule 1111 after October 1st of this year was an order for abatement. And we understood that the district was asking us not to file a variance petition. We proceeded, and in fact, I was retained following that meeting because my client realized they would like to have a lawyer representing them for the order of abatement portion. And so I engaged with the district, and we began discussions that were laying the foundation of the order for abatement. They had a number of questions about our operations. They had, raised questions about what increments of progress would look like. And while certainly the discussions were not always, perfect, and we never had 100% commitment or any, we weren't talking about commitment to an order for abatement. The discussions were productive until at least September, I believe it was September 6th. And in a phone call for the district, I frankly asked the district point blank, I said, it sounds like you guys are wavering on an order for abatement. The response I got from the district was, well, yes, we are wavering on an order for abatement. Again, that was September 6th. At that point, Howard Industries realized that they now had a compliance issue coming up on October 1st because it sounded like the order for abatement was up in the air. So if we look at the element there, the circumstances leading to the violation. In this case, the circumstance leading to the violation was that the discussions related to the order of abatement had broken down to the point where we realized we needed to seek alternative relief, in this case, an interim variance. So 1 week after that phone call, we filed our petition for an interim variance. I should also note that the Tuesday following that Friday phone call, so September 10th, we reinitiated very productive discussions regarding an order for abatement. And on September 12th, I in fact sent over proposed increments of progress to the district, and we negotiated those for the next 24 hours. And in fact, the recent discussions with the district have been that they are still interested in pursuing this as an order for abatement. So while it's true that we have known for a number of months that we are dealing with a compliance problem, the real moment where we realized on October 1st we are going to be in violation of Rule 1111 and we do not have a certain path forward was September 6th of this year. So we moved expeditiously to file our petition for an interim variance a week later and are now here 3 weeks later, 2 weeks later, in front of the board for the hearing. And I guess those points also cover the third element, is that we exercise diligence in both filing our petition, and we, in fact, got the first available hearing date to appear before the board. And then the fourth element under good cause, the denial of the interim variance will result, and in this case, it's unreasonable and unavoidable adverse impact to petitioner. The way that Howard Industries' client base works and their business works is that they have to enter into agreements with the various contractors, saying that we will have inventory and be able to supply in real-time inventory for you of the various furnaces that you need. And in return, they either give us an exclusive agreement that they will only come to us, or at least a certain percentage of their business will come to us. So if on October 1st, if we're not granted this 38-day interim variance, beginning on October 1st, we will not be able to sell furnaces to these customers. They almost immediately are going to walk away from Howard Industries. We'll be in breach of our agreement with them. When they go to a new distributor, they will have to enter into a new agreement with that new distributor, and they will then be very, very unlikely to come back to Howard Industries, certainly not in the near term, and in many cases, possibly never. So even the result of just a short 38-day shutdown of their business will be catastrophic to Howard Industries. And that is the critical piece here, is that we're not talking about a long period of time for this interim variance, 38 days. The harm to this company, it could put the entire company out of business. It certainly is going to result in layoffs of the vast majority of the 75 employees, many of which have been at the company for a long period of time. And so those factors together, we feel like the case for good cause here is a strong one. Thank you.
Thank you. Ms. Reichart, your opening.
Thank you. As counsel for petitioner mentioned, the district is opposed to the granting of good cause on this variance. I'm going to try to go through similarly to Mr. Williamson on some of the issues. As Mr. Williamson mentioned, Rule 1111, the final compliance deadline is approaching at October 1st. This deadline was initially, or the NOx limits of 14 nanograms per joule were initially set a decade ago. And we have done extensive research and investigations and demonstration projects throughout that decade. We have worked extensively with the manufacturers, distributors, everybody throughout the supply chain in order to ensure that we were pushing the technology forward to achieve those limits, as well as ensuring that there were still products available on the market. So due to those competing concerns, we did have an amendment that allowed for the payment of a mitigation fee in lieu of complying with that 14 nanograms per joule limit, and that was extended, and also a rebate program was implemented in March of 2018. After that date, after March of 2018, the district has never wavered that this was the final extension of the mitigation fee period. And October 1st, 2019 was the deadline that all manufacturers and distributors, anybody that is selling and installing products in the district, would have to meet that limit. We have never stated that we were interested, considering looking at extending that deadline. The board did direct us to come back in February of 2019 to examine the potential of a sell-through and bring it to Stationary Source Committee. The staff worked diligently and has continued. We have multiple calls every week to find the status of these furnaces and the compliant units. We came back to Stationary Source in February 2019 and told them we are on track. We will have units. The supply will be there, and there will be compliant furnaces to fulfill the market need as of October 1st. And the Stationary Source Committee declined to recommend a sell-through to the board at that time. So there has never been, since March of 2018, any indication that we would adjust this deadline. Howard Industries has been on notice since that time that this deadline is approaching. So while it is true, if they want to continue selling non-compliant products in the district, they would be in violation. They had plenty of notice to find alternatives to be able to sell compliant products. Additionally, as mentioned, they do have a presence outside the district. It is a limited presence so far, but they have not exercised a lot of effort prior to very recently to increase sales in their jurisdictions outside the district. They have informed the district that they are limited in the scope of where they can sell their products by Ingersoll Rand, who's the manufacturer of the American Standard brand. And it's limited to the South Coast District, as well as the non-district portions of San Bernardino and Riverside counties, Ventura County, and San Diego counties. So they can continue to sell their existing stock and any new stock in those areas outside the district. So they are not necessarily going to imminently be in violation of Rule 1111, as there are alternative markets for them to continue to sell if they cannot find compliant product. That issue of whether they can find compliant product and whether they have acted diligently to attempt to find compliant products, that will be addressed if as necessary during the good cause portion, and if we make it past that in more detail during the variance portion. In terms of the circumstances leading to the variance being able to be reasonably avoided, again, as I stated, the petitioner has known about this for a year and a half, and they did not begin these discussions until relatively recently. As council mentioned, that it's most important to look at the last 6 months, but our position is you should have been looking at this from the point where you knew that there was a deadline approaching. But even looking at the last 6 months, in this June meeting that council referenced, we did have a discussion about the options of a variance versus an order for abatement. There was a discussion about the concern the district had about filing a variance that could lead to the piling on of other manufacturers and distributors looking for variance relief. At no point in time did we say that they should not file a variance. We did ask that if they were going to file a variance, that they did not do it too far in advance at that exact point, but in enough time to provide the 45-day notice. So we said, if you're going to be going that route, please do it closer to the deadline so that once you file for that variance, you are right on calendar, right just before the deadline. There was never a point where we told them not to file a variance. We did tell them we would engage in discussions regarding an order for abatement, but that was not the only option, and we told them it was an absolute last resort and they should continue to look at all other options to come into compliance with that rule. We did ask them to get numbers together, look at sales, what type of units they would be looking at in terms of a variance or an order for abatement. We did mention that it had come up previously in the rule amendment that if there was a niche market, a very small market that was not able to be served with the current with the inventory that's available as of October 1st, one of AQMD staff did mention that potentially variance or order for abatement relief would be necessary, and that was really meant to cover a type of unit that's very unique and a very small quantity. And because of that small quantity, it would not have been cost effective for manufacturers to focus a lot of energy and research into developing it. And we expressed that to them, that this type of large 5,000 to 8,000 units over a heating season and even more over a year-long period was not the type of niche market that was really anticipated when that comment was made. In terms of what's happened after that June, and this, the diligence and the reasonably avoided, I'm going to kind of mesh those two together because I think they're integrally related. But that after that June 19th meeting, we expressed that we needed more information from them, and we, continue to engage in discussions. We didn't have another meeting until August. And at that meeting, we asked for an August 7th. There was still enough time to file for a properly noticed hearing at that point. We asked for a lot of information from them. We said that we wanted to know, let me go back for just a moment, I apologize. At the June meeting, it was the impression that the concern that Howard Industries had was that they could not obtain compliant furnaces after October 1st. Their main supplier, Ingersoll Rand, would not have compliant furnaces for them, and they were unable to get any other furnaces from any other manufacturers, so they would not have a furnace to sell after October 1st. And we were sympathetic to that, and we said, well, let's keep looking, let's investigate, please, let's figure out what we can do. Then we moved to the August meeting. At the August meeting, their story changed. They said, we're no longer interested in, we don't need your, any type of relief for compliant furnaces going forward after October 1st. They said, actually, we just need to get rid of our existing stock. We need to figure out a way to sell out our stock because at any given time, we have 5,000 units in stock. So the story changed, and that was very concerning to us. We said, wait a second, this is completely different from what you said in our last meeting. They had a different perspective. They didn't feel that way, but everybody that was at that meeting agreed that the story had all of a sudden changed to something different. At that point, we expressed a lot of concern about going forward with any relief because that is effectively a sell-through, which had been explicitly rejected by the board. We asked them to provide us with a lot of details, to give us information to help us make this decision. We said, please, we need, and we gave them a lot of, a list of things that we needed them to provide to us so that we could decide how to proceed. We did not receive a response to that request for nearly a month, until September 4th. A month went by, we were internally discussing and saying, well, maybe they figured out some other way. We haven't heard from them. Coincidentally, during that time, their distributor, Ingersoll Rand, had filed a petition for a product variance. The district engaged in discussions with Ingersoll Rand regarding that product variance, and it was ultimately taken off calendar on September 4th. And that evening was when we finally received the letter responding to all of our concerns. I don't know if that's a coincidence or not, but we were unable to engage in any further discussion with them about any type of relief because we were waiting for information. We could not decide whether this would be a viable option for an order for abatement or what our position would even be on a variance because they hadn't provided us that information. As Mr. Williamson said, we continued to have discussions over the last month. We continued to ask them to please pursue all options, contact all manufacturers, find other compliant products. There are, I don't have the exact numbers because they're constantly changing, but there's over 100 compliant models available from various manufacturers. There's plenty of models available. There are other manufacturers, and Howard Industries has a non-exclusive contract with Ingersoll Rand, so they are able to obtain and sell other manufacturers' products. And that is a new contract change that was negotiated this year. They are able to obtain other products if they were to have worked diligently and try to obtain those other products to sell. It is our position that they have not worked diligently. They've claimed repeatedly that this is a huge impact. It's going to put them out of business, that their business cannot sustain this, but yet they do not seem to have taken the actions that would be necessary to prevent that, and that could have been prevented if they had diligently began 18 months ago to look at alternatives and find sufficient supply. For those reasons, we think that that good cause is not warranted, that they cannot make the findings, and we do oppose good cause.
Okay, before we begin with the first witness for Howard Industries, a couple of things. First of all, we heard longer opening statements than I think I've ever heard in a particular case. I understand there's clearly a lot of background that both attorneys and both sides wanted the hearing board to hear. However, we do need to hear evidence unless the attorneys would like to be cross-examined. And so at this point, we're probably going to have to repeat an awful lot, but that wasn't argument. So that's number one. Number two, I heard misstated, I believe, on both sides, maybe inadvertently on one side, I don't know. However, I would like to be very clear for the board and for the parties, the element of good cause regarding circumstances beyond reasonable, could not reasonably have been avoided. The element states the circumstances leading to the violation, not the variance. The violation could not reasonably have been avoided by petitioner. So I want to be very clear when we receive evidence that we are looking for, when we're looking for that element, that we're looking for circumstances leading to the violation that would occur on October 1st. We have further defined that, just so we are clear on the parameters of it, in our guidance for the findings for emergency and interim relief, that the language here is intended to be stricter than beyond reasonable control, which we find in the 6 findings, because there is no notice to the public. And I just want to draw our attention again to the health and, not again, but to the health and safety code with regard to beyond reasonable control, section 42352.5, considerations we give. And that is that when we're looking at beyond reasonable control, which is a lesser standard, that we are looking from, in so doing, the hearing board shall consider actions taken by the petitioner since the adoption of the rule, regulation, or order from which the variance is sought. So I want to give a time and temporal boundary and understanding to that particular finding. And with that, Mr. Williamson, if you can please introduce your first witness for good cause.
Could I, before we step on, I just want to, I don't know, I think I was unclear, and I just want to confirm, when you were clarifying the second element, you just read the first half of the second element, and I think that the point that I'm really trying to make, and I will be making through the testimony, is that it's the second half of the element, which is the circumstances leading to the violation could not reasonably have been anticipated in sufficient time to provide for public notice of the variance hearing.
And you should know that we, as a hearing board, historically read them to both be required.
Sure.
Okay. But I appreciate
No,
that. And it was also Ms. Reichart. Ms. Reichart actually did state that element and use the word variance instead of violation. So I wanted to be very clear. Thank you.
I'm sorry, I also want to follow up, there's an or between those two words. And I have never been in front of the hearing board and had that read as an and.
Okay. So is it your, I mean, do we have to debate? Is it your feeling that the circumstances leading to the violation could not reasonably have avoided? So is it your position that a petitioner can come and have avoided those circumstances, but yet not reasonably have anticipated enough time to ask for a variance? It's or, because if you could reasonably have avoided it, then you didn't need to come and ask us for it in an emergency type of non-noticed proceeding. And if you could have anticipated with sufficient time to provide for public notice, then we wouldn't be here either.
Fair point.
Thank you. So you may present and introduce your first witness.
My first witness is Jeff Winter. Jeff, can you state your name for the record?
Jeffrey Winter, Winter.
And what is your role at Howard Industries?
I am Vice President at Howard Industries.
And can you describe your history at Howard Industries?
Howard Industries is a family company. My parents started the business. My mom is still active. My father just passed away. And I've been full-time active for the last 40 years.
And what does Howard Industries do? What's its business model?
We're wholesale distributors for heating and air conditioning parts, supplies, and equipment, as well as sheet metal and such.
And who are your customers?
Our customers would be C20 licensed contractors for the most part, the overwhelming majority of our business.
And what are the services that you provide to these customers?
We provide wholesale distribution supplies, we provide technical support for what we sell, and we provide warranty supplies and factory backup for what it is that we sell.
And describe your relationship with Ingersoll Rand or American Standard.
We've been Ingersoll Rand's exclusive distributor for American Standard product in Southern California for the last approximately 30 years.
And what is your, describe your relationship. How does your business model rely on that relationship with Ingersoll Rand?
They're our sole provider of unitary, meaning residential and light commercial heating and air conditioning equipment.
Like, can you service your clients without the support of Ingersoll Rand?
We wouldn't have a supplier for heating and air conditioning equipment, which is our core business, and it is what drives the supply business.
So is your business model dependent on having a relationship with your manufacturer of the HVAC equipment that you're distributing?
It is for us, and it would be for any like company to us.
Okay. Let's go into the 4 elements for a good cause. The first element, petitioner is in violation of a rule, regulation, or order of the district, or that such violation is imminent. Can you describe the imminent rule violation that you guys are facing?
On October 1st, the requirement would be to sell ultra-low NOx furnaces, which are 14 nanograms per joule. We currently don't have a source supply of that from Ingersoll Rand or from any other supplier, and so we would not have a product to sell we have 6 locations. We have a very small warehouse and sales location in Escondido, very tiny, and we wouldn't have a source of supply for our operation.
And you heard the district claim that in their opening statement that on October 1st, you actually could continue to operate in business in compliance with Rule 1111 by selling furnaces and other HVAC equipment outside of the district. Was that true?
It's true we could move out of the district. That's not our wish. To sell out of Escondido, which is a tiny facility, is not tenable or feasible. Everyone lives, everyone works in the other areas, and Ingersoll Rand is going to have product shortly. They just don't have right now. So to basically shut down the operation and move to a tiny space in Escondido, whose sales area is the size of this front portion of the council chambers, move 75 families there makes absolutely it's not a reasonable suggestion at all in any way.
Okay, and there was also, well, let's move on to the second element. Second element, as we were just discussing, the circumstances leading to the violation could not reasonably have been avoided by petitioner. We heard the district argue that you've known about this rule for years and that you haven't taken adequate steps to prepare for the rule. Can you give a high-level overview of the different approaches and folks you've contacted in order to source or find a new relationship with a manufacturer, et cetera, to remain in compliance with Rule 1111 beginning on October 1st?
Yes, so the council, if they could please indulge me for a moment, every brand has a distributor to it, typically, or a sales location. So you'll have a distributor, you'll have a brand. We don't sell multiple brands, typically not. Because of the relationship that I talked to you about before a moment ago with regards to warranty, regards to technical support, and ample and proper supply. And it's like having multiple car dealerships out of the same location. They typically don't work, so, but this is less so. So the district suggested, we've been one of the only, I want to say probably the only wholesale distributor that's been active and coming to all of the district meetings. When we became aware of it, I did not know about the AQMD, this AQMD regulation for 40 nanograms per joule till the mitigation fee kicked in, okay? And then I went to American Standard, Ingersoll Rand immediately, and they assured us that they would have furnace production by this date. They had various production hiccups with regards to intellectual property, with regards to testing, with regards to the similar problems that other manufacturers have. They didn't want to pull a product off the market like someone else had done that's here now for a short period of time and reintroduce. They didn't want to have overheating problems because there were fires that were created previously under the 40 nanogram per joule, historical issues. They didn't want to rush to market there. That's probably a good consumer thing to do and not to put lives at risk. On the flip side, we were faced with basically date changes that occurred over that time. So we have later, I guess for later presentation, we have where Ingersoll Rand gave us dates. They gave us first that they'd be in compliance. Then they started pushing off the production dates and so on and so forth. And here we are today because the dates got pushed off again and again and again for first manufacturing.
And what is their current estimate for when they will have an ultra-low NOx model ready for market?
So they manufacture furnaces out of Trenton, New Jersey, and those furnaces are supposed to be available to us by April of 2020. So that's what we're looking forward to, a nice, fine, safe product at that time.
So as you were having these discussions with Ingersoll Rand about their timeline getting pushed and issues they were having with production, what was your first move to look outside of Ingersoll Rand for an alternative source of ultra-low NOx furnaces?
So the district had continuously suggested to us that we, I want to say 2 years ago going forward, that we need to find another source. We explained to them what I explained to you a moment ago, that it's a relationship. It's not a polygamous relationship. It's a monogamous relationship, and one distributor, one brand. And we have an exclusive contract with American Standard. That changed, as the district said, in our contract in 2019. It became non-exclusive. That opened up an opportunity. So come February of 2019, we contacted a Lennox International division called Allied Furnace through a sister company called ADP. Okay, so we do business currently with ADP. ADP contacted Allied Furnace, and Allied Furnace is owned by Lennox. And they're also, they have a large offering of furnaces. So it seemed natural to get a branded product, an ADP branded product from Lennox for us. We did that in February. Lennox told us they were not interested in a relationship. Not Lennox, but Allied.
When did they tell you that?
That was in, we started this in February, so I would say about March. Then, and these are approximates, I could be off by, 15, 30 days here and there. Then I came to that meeting in June that we referred to, where the district talked to me about an order for abatement. And at the end of the meeting, Yang Rong said, why don't you talk to Lennox about furnaces? And I said to her, it's very funny that you should mention that, because, and I explained to her the entire situation. I said, I contacted Lennox through ADP and they turned me down. So she says, well, but they told me that no one contacted them to supply product. And I said, well, that's just not true. Why don't you go back and talk to them again on our behalf? Well, we can't tell, they always tell me, we can't tell people what to do. We can't tell them to sell you. But I guess she did, because mysteriously, the morning of the meeting that council attended with us, because at that time, before that, we brought council on to do this order of abatement.
You're talking about the August meeting,
The August
correct?
meeting, correct. So at the August meeting, that morning, before the August meeting, Allied reached out and suddenly became interested again in selling us furnaces, which was a wonderful thing. So when I came to the meeting, I brought that email with me, provided it to the district, and said, I don't need to talk to you about getting any sort of a delay in furnaces, because guess what? Wonderful things just happened, and Lennox is going to sell me furnaces. That was what happened, and that's why I didn't need it. It wasn't a turn of anything. I provided them with that email, and I was very excited and very happy that I wouldn't have to be here in front of you fine folks asking for any sort of a delay. And I provided that email.
A question there. What was your response when the district responded to our good news with, a ton of questions and doubt?
I'm not understanding. What do you mean doubt?
Well, as we heard from their opening statement, is that they were surprised and thought the entire circumstance had changed when we came in with this good news.
I don't know what I don't know what they're talking about. I know that I don't know what's being twisted, but I know for a fact that I was very excited to provide that piece of news. They then started getting all excited about the inventory that we had, because remember, we have inventory because we have to remain in business today, yesterday, the day before, and right up to the deadline, and hopefully, God willing, with a couple of extra weeks beyond with your help, so that we can get something a little bit more permanent till the April timeline, which is what we're looking for. I'm not looking for, pardon?
A question for you on the Linux discussions you were having at this time frame. Was this we're going to purchase 1,000 units and then our relationship will be over, or were you in discussions to enter into a full distributorship agreement
No, this was supposed to be a long-term relationship through ADP. Hopefully, I've been clear. So it's ADP to Allied to Lennox. They're all divisions that are owned by Lennox International. Lennox International has Lennox as a brand, and then they have Allied, just as much as Ingersoll Rand has Trane and American Standard. So you have Lennox International owns Lennox, they own Allied, and they also own a company called ADP that makes coils that go on top of the furnaces. I hope I'm not making you crazy here. So I do business with ADP. So I already do business with a division of theirs, okay? So I was looking to get a branded furnace permanently and full-time that I could sell with the ADP name on it, which would have been an amazing and a beautiful thing for permanent business with this manufacturer. And that's why it was the best relationship of all.
And why is that important to you to have a full distributorship agreement and have a branded product to be able to sell? Why is that important to your customers?
It gives them opportunity to sell in a broader market. It's non-opposed by Ingersoll Rand, so it would have been just the best of all worlds. Okay, it's like selling an accessory to a car, because a furnace isn't just. I don't know how much you folks use your furnaces, but I don't use them. It's an air delivery system. Okay, that's what provides the air for your air conditioning. Okay, without your furnace, it's like not having a charging station for your electric car. You need to have a charging station. You need to have a furnace to have air conditioning. Okay, and so. That's just the furnace section. The coil sits on top. It sits in a closet. No one sees the brand of it anyway. It doesn't make a difference. You always see the air conditioner outside and the thermostat on your wall. That's what everyone sees. So if I had the air delivery system with Allied, that would have been just fine. Everyone happy, and this is a long-standing and ongoing relationship. I told them I need approximately 5,000 furnaces to begin to fill my pipeline, and then approximately 2,000 furnaces thereafter per month. That was the ask. They said they need to talk to their master scheduler.
I'm sorry to interrupt you. That was your ask. Can you just give us a date so we don't have to come back and ask?
Certainly. That was my ask in right after that August meeting. So that was my August ask. Okay. They contacted me the morning of the meeting in August. Okay. We had a conference call the next week. I had a conference call with management by the name of Joe Leonard at Allied Furnace. We talked quantities. He sent me a paint sample of the cabinet, okay? He sent me some preliminary pricing, preliminary meaning not all models. He was excited, we were excited on a lot of fronts for something ongoing and permanent, which was really what we want, beyond this hearing, because we feel that the brand is a great idea, and thanks to the district for that, but that's where my thanks end. And we told them the quantities of what we would need. He said, he being Joe Leonard, said he needs to go to the master scheduler to determine if they can handle my volume. They came back to me and they said, we can only provide you 1,000 furnaces for the season. So the season, call it 5 months. I don't know. I know about you, but to me, a season is very short here for cold weather. But the season to them was 5 months. So 5 months, do the math. the thousands I'm telling you I need, 1,000 for the entire season, divide that by 5 is 200 a month. The numbers get absurd. And then the models of furnaces, because there's 5 different sizes. Once you do the math, it's like 10 of each size over 6 locations. Really? Do you think that's going to work? But listen, this is what I did. I told them, I'll take all 1,000. Give them to me now. I'll take them all now, right? And then they became, they sign off. Nothing from them. Quiet. Haven't heard a thing from them since. Okay? And by the way, they're supposedly here to oppose. But that was the conversation. It started off in February of 2019 by the suggestion of the district. We took their suggestion very, very seriously. We take everything they say very, very seriously and follow their lead in every which way, even sometimes to our discomfort and to our damage to our business, because they had us contact our competing brands and beg them for product, which I personally did, and didn't get callbacks from them for the most part. But then they ran around to my customers telling them, oh, by the way, Howard Industries doesn't have any furnaces. You should come to us for business. So they used that information against us. They're using it to this day to steal our customers away from us in the interim. Serious damage is happening to us through what the district is asking us to do as we speak right now.
So I want to go back, Jeff, to the second half of this element, talking about we could have reasonably anticipated the violation in sufficient time. And again, I think revisit the June meeting that you had with the district. And you heard Ms. Reichert explain her recollection, or at least the district's recollection of the meeting in her opening statement, although it wasn't testimony. And hang on, I'll get there. Tell me what your recollection of the statements made at the district regarding an order for abatement and a variance were.
You're going to love this. Phil Fine is at one end of the table. It's a nice long table, rectangular. Phil Fine is here. Mary's there at the opposite end, short ends of the table. Across from me is Yan Rong. What's this gentleman's name? I forgot.
Sean.
Sean Wang, and that gentleman over there. I forgot his name. Gary. Those 3 folks are across. Okay? So, and next to me is Howard Berman, and beside me is my son Jeremy. Okay? Initially started out the conversation by asking Mr. Fine, Dr. Fine, I asked him about the very specific furnaces, because it doesn't look like anyone's going to have them, specifically communicating furnaces, and would the district be issuing variances for them? Because those are the highest efficiency furnaces they're the highest, they support the highest efficiency condensing units, meaning if you want the best comfort and you want the highest efficiency, you need those furnaces, and they're the smallest volume, but they get you the greatest savings for energy. And the state of California is really big on it, and rebates, and consumers love them for comfort. It's just spectacular. And they said, we're not going to issue any variances till after the first of the year and on anything. And I said, well, you know, it's not going to be available for anyone, and no one wants to be in violation. And he said, well, we're going to look at it after that. And then we started, and then I talked about variance for ourselves, and he said, look, we don't want to issue any variances because we want to put the pedal to the metal. We don't want people piling on. We don't want people to think that they can get around this, because this has been going on for too many years. We've been lied to by many people. Quite frankly, had I known some of the things that I know now, I wouldn't have even gone down this road. I didn't ask for definition. I was here for a purpose. And then between Phil and Mary, they started talking about something called an order for abatement. I didn't know what the heck an order for abatement is. I'd never seen an order for abatement. I had no knowledge of an order for abatement. Mary was there. She was talking about it. She said she can control the penalty fee. She can control the timing. She can control, it's going to be done in this quietly. It's not going to be publicized. She's in control. I call her the queen of the order, because that's the way she presented herself. It was the most amazing, wonderful thing. She said it's not good for large companies because, you know, you have to admit basically that you're a sinner. Listen, I'm here because I'm going to be a sinner, and I don't want to be a sinner, and I don't want to violate the law. So, but they could help me with this order for abatement thing, and I thought that was spectacular. So I immediately went to get an attorney.
Hang on, before we move away from the meeting, I wanted to clarify a couple other things that the district said in their opening. Did the district in their opening said that they represented the order for abatement as being your last option? Was that true?
No, not at all.
And did they ask you not to file a variance petition during
Yes.
that meeting?
Yes, they told me they wouldn't support it. Yeah, that was something else that the district just said, which is totally not true. They didn't tell me to properly do anything. Only thing they wanted me to do was the order for abatement. They were very, very clear about that. They said a variance is a bad direction to go in because it's public and they don't want me to do that. Stay away from that, and they'll help me with the order for abatement. I felt so good after I left that meeting that they really cared about me and they were going to help me, and they said, you're different than everyone else and we understand that. They were so kind, you know, and then after I hired counsel, suddenly the district had amnesia. They didn't remember the meeting. They didn't remember anything.
One final cleanup on the meeting. We also heard in the district's opening that they instructed you that variance petition should be filed 45 days before October 1st. Is that true?
No such thing. Never happened.
So let's go back also to the August meeting with the district. We touched on this briefly, but the district in their opening represented that they were, you know, so shocked by the fact that we had found a supply of ultra-low NOx furnaces, and we're now just looking to deal with our current inventory, and they represented as we were asking for a sell-through, that at that meeting it was, we were informed that they didn't think an order for abatement was appropriate anymore. Was that discussed at that meeting?
The order for, okay.
This is the
First of
August
all,
meeting,
Yeah,
I'm
the
sorry.
August. So this shock, I don't know what they're talking about, shock. Allied reached out to me out of the blue, the morning of the meeting. You want to talk shock? I was the one who was shocked because they were quiet, they meaning Allied Furnace was quiet for months. And all of a sudden they woke up the morning of my meeting. Well, I don't know. I guess I was lucky. That's what I figured. Lightning striking in a great place. But the district, I brought it to them with honesty and integrity. I hadn't worked out a deal, but I brought it to them because I wanted them to know how wonderful this would be. I wouldn't have a problem anymore, and the only problem I would have, therefore, because understand that even if I found a manufacturer, Allied told me it would be at least 6 weeks before they could provide me with anything once they had a signed contract, meaning, you know, you got to go through pricing and ordering and paint colors and all this other stuff. So from the time that they had a bona fide order to the time that the units hit the door is 6 weeks. So we need to take that into consideration. Even if someone woke up this morning and could help me, you're looking at something close to 2 months on a good day of the week, okay? So, but I wanted the district to know, because I've always been forthright with them, I wanted them to know what was going on, and I brought that email with me to the meeting. They didn't ask me about Allied. Well, I guess they didn't know about it. They didn't ask me about it, but I brought it to them, and I said to them, here is this email, Allied's talking to me, but now I'm stuck with all this inventory, and I need your assistance with it, okay? They said they were not happy about the inventory, go sell it somewhere else, X, Y, you know, just a whole bunch of, we got into an enraged conversation. They got Mary got very, very excited. We said, look, we have to get rid of the product. If we sell it through Escondido, like they were suggesting, that branch is so tiny it's going to take 20 years to sell it. Mary said she doesn't mind buying an old 5-year-old furnace, by example. And I said, well, anyone else here probably would. Considering I'm not the only guy in town that sells furnaces, why would someone buy my old junk? That's what I said.
So Jeff, did you walk out of that August meeting thinking that an order for abatement was still the path forward, and that was the what we were negotiating with the district?
Absolutely. If at any time I thought that the order for abatement was off the table, I would have filed a variance. And we were basically, I don't want to use the word played with, but we were basically tickled and played with right up to when we filed the variance, right up to that morning that we filed the variance, and right up to even yesterday, talking about an order and this, and you know, this is always, we're always being put off and delayed and delayed and delayed and delayed. Okay? If I knew at any time that the order was off the table, I would have come for a variance. But it was always, the variance is not easy. This is a very, very difficult process. You want to know a lot of things. You have a right to know anything you want to know, but it's still a very difficult process, and it's not the path that anyone, any council would prefer. The best is to get the order, and that's the way it was presented to me. The order's the way to go. Order's the way to go. So in my head, they're talking order, I'll do the order. But when it looked like I'm never going to get the order, and I have 75 families to worry about and a business to run, I had to go for the variance, and that's why this was the last possible opportunity for us.
And the final thing I wanted to cover is the outreach that you've made to the other manufacturers. We've already talked about Lennox, but there are other manufacturers of furnaces. There are 4 of them. First, I wanted to just clarify a statement made by the district in the opening. They stated that while they didn't remember the list, because it does, I'll give them that, it constantly changes. They stated that there are well over 100 models of ultra-low NOx furnace on the market. Is that a fair representation of the ultra-low NOx model availability on the market right now?
I don't know all I can tell you is what's on AQMD's website. That's, to me, what counts, because I think the website is certified, but let the district speak to what their website states. You have 5 manufacturers with I'm going to throw you a number, 40 different brands, okay? Carrier probably has 8 by themselves. So if they have 4 furnaces, 4 furnace models, let's just say, so 4 times 8 is what? 32, right? So it's not that there's 32 models, and we clarified this actually at our last meeting with the district. They keep flipping it back. When they talk to Stationary Source Committee, they say to them they have thousands of models. But yet when they talk to me at the last meeting, they acknowledge the fact that one brand is talking about the same model again and again and again and again with a different name on it. Okay, follow me on that? So really we're counting the same egg 10 different ways, but there's only one egg. Okay, I don't know how many different models each person has because I'm not in your certification desk, but that's what you want to talk about is the manufacturer, i.e. Carrier Corporation, and not the different trade names under Carrier Corporation, but Carrier Corporation and how many models. And it's very clear if you look at the website, these models keep repeating themselves again and again and again, just different brand names for each one. So I don't know how many they have. That's not why I'm here today, because I'm here to save my own skin, no one else's. But there's 1, 2, 3, 5 manufacturers that the district asked me to reach out to my competing brands, which I did, head held high as best I could. I called them up beyond Lennox, okay? I called JCI, Johnson Control. I got the numbers, by the way, from Sean Wang, a very, very kind man. He gave me the phone numbers after he got permission from Mary to give me the phone numbers and to contact people at the different manufacturers because I didn't have, I needed to talk to these folks directly and quickly. This happened maybe 2 or 3 weeks ago. Something along those lines. Just recently to reach out to everyone else as if they were going to sign on new distribution anyway, because I already told you how distribution works. It's not just, selling a can of paint at Home Depot. This is in a very long and deep and continuing relationship. It's not something that someone's going to enter into for 4 months. But anyway, I called up JCI. I left a message for them. They never called me back. No, I'm sorry. They did call me back. I told them what I needed, and then they never called me back. I called Goodman Manufacturing. They did call me back. They sent me a non-disclosure agreement, which means basically that, they didn't promise me anything. They wanted me just to be negotiating with them and only them. And I can't do that because I'm in a pickle right now. So we can't play that. And I've never been given an NDA in the 40 years that I've been in business, to exclude myself from talking to anyone else without even a promise. So that's not really viable. I called up Carrier. Yesterday, they put me off again and again and again and finally told me to go buy from my competitor, distributor. So go buy from him. What should I do then? Buy from him and send my customers to him too? I have no ability, no continuing relationship with my customers. Basically, I'd be buying a furnace from someone like myself and resell it it'd be like my customer, I'd be standing in line with my customers. Okay, that's in essence what they suggested I do. So that's and they said to me in black and white, we're not interested in opening up any additional distribution. So that answers the Carrier question.
So Jeff,
And then
go
Lennox,
ahead.
and then Lennox, that whole discussion of the come and the go and the come and the go, and they're here today, so I'd love to hear what they have to say. But anyway, that's the story.
So Jeff, what have you learned in the outreach that you've made to these other manufacturers? I mean, just summarizing the readiness of them to supply to Howard Industries.
Phil Fine said it best. I've learned this is a dog-eat-dog business, and that's exactly what it is. Okay, no one's going to sell me a furnace because they would like me to go away and die. And I'm just not prepared to take 75 families and send them along their way. I don't think it's appropriate because we need a couple of months of leeway here. No one's going to get hurt. It's all good. There's no problem. I don't know why there's so much opposition to this day. Honestly, folks, I can't figure it out. If it's just for the purpose of being difficult, then they've definitely scored a big one here. But it makes no sense. No one else, by the way, has asked for a variance. Someone told me that. Who was it that told me? Maybe the district said it. Did you tell me? Someone told me that no one else is asking for a variance. No one's going to pile on here. I don't see anyone standing at the door, and you don't have anything on your registry. I'm the only one asking for it. So I can't figure out why it is that this little gesture can't be provided.
Jeff, let's move on to the third factor on the good cause, that we exercise diligence in petitioning for the interim variance. Again, you testified that when we left the August meeting that, while there were a lot of questions, the message you got from the district is that the order for abatement was still on. At what point did you realize the order for abatement option is not a viable option for us to be to avoid our compliance concern on October 1st?
There was still conversation. There was still conversation right up to the morning that we filed for this variance. There was still conversation going on, and to be honest with you, I'm not that dumb, so I said, you know what? This is getting us nowhere. I feel like I'm being strung along to and I couldn't believe this because I'll be honest with you, I'm still one of those guys that believes that government agencies are solid folks with great integrity. I mean, after all, there's no reason for them to be sneaky or anything like that. I mean, why would someone do something like that? And yet, strung along continuously, being asked these questions, which furnaces did you sell out of which location? How many did you sell historically over the last X number of years? I mean, what in the world does that have to do with 4 months? I mean, I'm sure you could justify any question in the world, but what does that have to do with the problem at hand? It has nothing to do with anything. Sorry.
That's okay. We just don't want to take up the entire day. So let's try to answer the question asked. We'll try to wrap this up.
I felt that was the case, that I wasn't getting anywhere that morning that we filed. And we told the district we're filing it. And by the way, they didn't tell us they were opposing it until yesterday.
And then let's move off to the fourth element, talking about the adverse impact to you that you would suffer if you're not granted the interim variance and required to cease selling furnaces at least until the regular variance hearing on November 7th. Describe what that would do to your business.
We wouldn't have an air delivery system. We would not basically be able to provide our customers with any heating or air conditioning product. So basically, we'd be out of business. We would not be able to take care of our customers at all. Our customers would, because it's not just that they like a gallon of paint, pony up to the counter and buy it. They meet folks just like yourselves. They need to write a contract. You sign a contract for a particular brand and a particular model. If I can't assure them for a product line or for a product, then they can't engage you in a contractual agreement, right? So they'll go to my competitor because that they understand. Okay. Even now, this is the late hour, but I haven't publicized my meeting with the board here. I've really kept it extremely quiet because I'm trying basically just to survive those couple of months once Ingersoll Rand has the product, because it's clear no one else is going to sell me anything, even though they play with us. No one else is going to sell anything. And once we get past that little bit of time, then the world will be a wonderful place all over again, and no one will ever have to see me again, and it's great.
And so at the point where you were to, either if we were able to negotiate an order for abatement and have it approved by the board, or you were able to Ingersoll Rand came up with an ultra-low NOx furnace that came out on the market a lot faster. If you had been shut down for that, up until that period of time, would your customers come back to you when you open up your doors again?
This is really strange because this is a very bad time to come out with an ultra-low NOx furnace for anyone because it's, first of all, it's at the beginning of the heating season, which is planning timing-wise for the district is kind of poor because if production isn't right, folks aren't going to have heaters. That's one thing. But for me, it's bad because this is the time of year the dealers sign on for the next year, right? October, November, December for the 2020 year, who's going to be their supplier. If I don't have a product to sell, they'll sign on with my competition, and I will lose them definitely for the year, gone. So I'll be gone, but beyond that, could be in perpetuity if they like what it is that they bought from someone else. I mean, basically, we've driven them somewhere else. They have no choice but to go there, like me or not. I have nothing to sell them.
So again, even a short closure over this 38-day interim variance window that we're asking for would have severe adverse impacts to the company and could potentially even lead to the company shutting down, correct?
I told the board, I met with the district in June, and I told them I cannot be illegal for any period of time because they were talking about the order of abatement and when and this and that and when should it kick in and not kick in. And I said there can never be a moment in time that I am illegal. I can't have that happen because there cannot be a point in time when I cannot provide product to the customer. It just can't. Once I'm out, I'm out.
I have no further questions.
Thank you. Before we begin with questions from the district, because I anticipate there'll be a lot of questions and also from the board, let's take our break for the morning. So let's take a little less than 15 minutes and let's please be back, given that it's a long hearing, it'll be a long hearing, to 20 of, so 10:40. We're off the record. We are back on the record. Ms. Reichert, do you have questions for the witness?
Yes, I do. Before we begin with that, I have a witness on good cause on a limited short issue, I believe, that needs to leave at noon for children's doctor's appointments this afternoon. So I just wanted to raise it. I spoke with petitioner's counsel, and he said that he would be open to taking witness out of turn. So I just wanted to put that out there, and we can watch and see how the timing goes leading up to noon.
Let's try that, but Mr. Williamson, will you anticipate any additional witnesses for petitioner on good cause?
One short witness, yes.
Okay. So why don't we I think that a good idea to watch the clock. I will watch the clock, and if I lose track on the clock, someone else can remind me to watch the clock. So how long do you think you'll need for the witness who needs to leave at noon?
Probably less than 10 minutes.
Okay, and then, of course, questions. So let's anticipate 20 to 30 minutes. So we'll make sure we stop by 11:30 and take that witness out of turn if we need to.
Okay, thank you.
But let's continue with Mr. Winter so that we don't lose train of thought.
Thank you very much. So I wanted to start with your involvement in the process. You said that you have been, or you first became aware of the AQMD when the mitigation fee became due?
Correct.
And so when was that?
I don't remember.
You don't remember? Okay. And so you said how long have you actually been working in the business?
About 40 years.
40 years? Okay, so were you working at the business in 1978?
Was that AQMD Part 1?
I don't know what that means, I'm
Is
sorry.
that Rule 1111 Part 1?
Yes.
Yeah, I was there.
Okay. So in 1978, when we passed the 40 nanogram per joule.
Is your microphone on? I don't.
I think so, yeah.
Oh, maybe just speak more
not good
directly
reception, yeah.
into the microphone. Thank you very much.
I'll move up closer.
That's better. Thank you very much.
So you said you didn't know about the AQMD until the mitigation fee kicked in, which was one of the more recent rule amendments, but you were around when the 40 nanogram per joule requirement came about in 1978?
I was referring to 14 nanograms per joule, not the 40.
Okay, but in 1978, when the 40 nanograms per joule came about, were you aware of that requirement and the transition into those
Yes.
those furnaces? Oh, you were?
Yeah.
So I guess I'm confused about, you said you were not aware of the AQMD before the mitigation fee, which
I didn't
is,
say that. I said I was not aware of the 14 nanogram per joule law.
okay. So you were not aware about the 14 nanogram per joule requirement until you had to start paying the mitigation fee?
We got notified about the mitigation fee. That's when I found out about it. The district
but
did
you
not
don't know-
notify distributors.
But you did not know when that was?
The district did not notify distributors.
Yeah, right, I'm asking though, you did not know when that was when you first became aware of the mitigation
I
fee?
don't recall right now when the mitigation fees needed to be collected. That's
Okay.
correct.
So when did you start becoming involved and coming to any district meetings or communicating with the district about the ultra low NOx new limit?
I immediately called up the district when I heard about it. I asked them about the mitigation fee. I don't recall who I talked to. A very nice gentleman. He explained all the background to me because I wasn't aware of any of it. He sent me some data. I forwarded that to Ingersoll Rand and asked them if they knew about it. I don't know to what extent, to be honest with you, that they knew or didn't know because this is some time ago. But I was pressing them from that moment going forward.
And when was that?
I told you it was at the time that the mitigation fees needed to be paid.
That's when you first contacted them, okay. And so, were you involved in the rulemaking that was passed in March 2018?
Was I involved in the rulemaking?
Did you come to any working group meetings? Did you attend any public workshops?
Yes, somehow I got connected up with Yan Rong, and I don't remember how that came about, to be honest with you. I don't know if I met them alone or if I met them with Howard Berman, because I needed to find a way to navigate the district to better understand the rule. I started attending the work sessions that Yan Rong made me aware of. I attended the Stationary Source Committee meetings, and I also attended a big council meeting. I don't know what you call those, but, where everyone is there, the very large room down the hall.
Governing board meeting.
Governing board meeting, yeah.
So would you say you were involved in at least being aware of and contributing to and commenting on and having meetings with the district at least by late 2017?
It was before the mitigation fee started to need to be paid, so from that time going
Oh,
forward.
so
I
even
can't
earlier
give you
than that.
dates. I
Okay.
can't give you dates, I
Okay.
don't have them.
We can establish that elsewhere. And then you did provide public comment at any of the public workshops
Many
or
of them.
meeting group
Many of
meetings?
them.
You provided public comment?
I did.
And you had meetings with the district
did.
throughout that rulemaking process?
I did.
And you attended the governing board meeting when the March 2018 rule amendment happened, where they've passed the rule?
I can't say I attended that specific meeting. To the best of my knowledge, I attended everything that I could. There was one that I attended by phone,
Okay.
telephonically, and I can't tell you which one was which, because it didn't seem to me to be relevant, but
Okay.
I attended them. I was
you
a good
were-
part, I was the only distributor who really participated.
So you were aware when in March 2018, that the rule was amended and set a deadline of October 1st, 2019 for the end of the mitigation fee?
Yes,
Okay. And you knew that as of October 1st, 2019, you would no longer be able to sell or install units that did not meet the 14 nanograms per joule limit?
correct.
Okay. At that point in time, did you engage with Ingersoll Rand regarding whether they would have compliant furnaces for use?
Continuously.
Okay. And what did they tell you?
They gave me calendar dates, and it looked like October was going to be the date that they'd be able to provide product. They gave me various models and dates and so on and so forth.
And how many models do you currently keep in stock?
There's something plus or minus 80,
80 models?
correct.
And how many total products do you typically have in stock at any given time?
Plus minus, could be any time, anywhere up to 5,000 furnaces.
Okay. And how many models did Ingersoll Rand indicate that they would have for you to begin selling in time for the compliance deadline of October 1st?
To my recollection, four 80% and four 90% furnaces.
So 8 total models
8 total models.
out of the 80 that you typically carry?
That's the problem with the district, it's not mine.
Would that have been sufficient for you to continue your business?
Unfortunately, that's the problem that the district is going to have system-wide. Everyone has the same problem.
I'm sorry, can you answer the question?
That is all that's being offered by any manufacturer at this time, very short versions.
Would you have been able to continue your business with 8 models?
I would be no worse off than anyone else.
Would you have been able to continue your business?
I imagine so. I wouldn't have been any worse off than anyone else,
So you would have been able to with those 8 models?
just as much as anyone else.
Okay. And when did Ingersoll Rand tell you that they were not going to be able to provide you with those models?
Let's see, do we have dates here? It started to swing out. I want to say, it looked like, I think, I can't tell you with certainty, but I believe somewhere around April of 2019, it started to swing out. Yeah, somewhere around April, it started, of 2019, the date started to really swing out where it was not going to happen. March 2019.
Okay. So let me just take you back a bit. Prior to 2019, did you have an agreement with Ingersoll Rand to exclusively distribute Ingersoll Rand products?
Yes,
Okay. And did you renegotiate that contract?
we got a new contract, and they took that out, not us.
They took out the exclusivity?
They always modify their contracts, and that seemed to have changed.
Did
I didn't
they-
ask for it to be changed.
You did not ask for it to be changed?
changed
Did they give any indication why they were changing it?
Nope,
Did you have any conversations with them about that clause?
nope,
Did anyone at your organization have conversations with them about that clause?
no. We wondered internally, but we didn't ask them.
So what was what did you wonder internally about why they took that clause out?
Same question you just asked, why?
Did you have any ideas?
Nope,
So you had no idea why they would take that clause out?
no.
Did you have any anticipation it could have related to the fact that they may not have compliant furnaces
Oh,
as of
not at all.
October 1st?
That's not why. You'd say, why are you going from exclusive to non-exclusive? It might be maybe they wanted to add some distribution in a territory somewhere or something, but nothing to do with furnaces. The furnaces does not rule the day as much as you might think.
So you've had this relationship with Ingersoll Rand for how long?
Plus minus 30 years.
And over that entire 30-year period, have you been required to exclusively distribute for Ingersoll Rand?
We've had a contract every year,
And every year, has it included a requirement to exclusively distribute for Ingersoll Rand?
except for last year.
Except for this
2019.
2019, the beginning of 2019,
The contract starts January to December.
January to December. So you said that you did not get an indication from Ingersoll Rand that they may need to push the timeline back until March 2019. Why did you contact Lennox in February 2019?
Because the district suggested to me that I find another manufacturer at least 3 different times, maybe more. They kept saying to me, you need to find another manufacturer. You need to find. So I take them seriously, and that's exactly what I did. I reached out. I thought it was an ingenious idea.
But why would you reach out if you felt that Ingersoll Rand was going to have sufficient product for you?
Oh, I think it's a great idea. I think it's good to have this branded product to support the coil manufacturing. I'm not doing it under the Lennox name. I'm doing it under the ADP name. I thought that's ingenious. I thought it's great. I think it's a wonderful idea. It's an air delivery system. It provides everything that the homeowner needs. It doesn't interrupt my air conditioning sales. I think it's perfect.
So you didn't reach out to them in an attempt to comply with Rule 1111, it was just to expand your business?
No. It took care of Rule 1111, and it's an ongoing relationship that continues on forever. I thought it was a wonderful thing because you're asking me, the district asked me to find another source. So who's going to sell me furnaces for 4 months? Really? Not really, okay? So this is something that could continue on in perpetuity that someone might bite into, and I thought it was a great idea. So I'd have ultra-low NOx furnaces. I'd have a relationship with the manufacturer going forward indefinitely. This is the best of all worlds. I don't want to give you credit for it, but it was a very good idea.
So you had testified that typically there's an exclusive agreement where distributors just supply one manufacturer's product. Is that correct?
Typically, distributors don't sell out of the same location more than one brand.
Okay, but when you started talking to Lennox in order to start selling the ADP brand, you were anticipating selling now 2 manufacturers out of the same location?
So that's why the district doesn't understand distribution. I'm talking about a furnace. I'm not talking about an air conditioning unit. It's a furnace. It's the air delivery system. It's not the complete system. It's not the condensing unit. It's not competing with American Standard. It's just the furnace.
But we're talking about furnaces here.
I'm not carrying someone else's condensing unit. I'm not carrying someone else's package unit. There's a whole industry behind all of this. You're just talking about the furnace, which is the air delivery system. I'm not leaving American Standard. I'm not taking on another brand instead of American Standard. I'm talking about just the air delivery system. That's all.
So, but you have furnaces that are American Standard, and now you wanted to add ADP furnaces, so you would be selling both types of furnaces.
Sounds to me like you're fighting the Ingersoll Rand contract and on their behalf, but they're okay with it. They don't have a problem with me carrying a different air delivery system as long as I carry their outdoor unit. So they're happy, so let's keep them happy. They're good. Don't worry about it. It's all good.
Well,
They're okay
I'm
with it.
trying to establish the fact that it started out that it seemed like you had presented the fact that it looks like typically distributors only distribute for one manufacturer, but you began conversations in February attempting to add a distributor or add a manufacturer, not replace Ingersoll Rand, but add one, so now you would have 2.
Okay, so an air conditioning system is made of different parts. The most important part is the condensing unit outside, and then you have package units that go on the roof. There's lots of different parts to an air conditioning system or systems. They're perfectly comfortable with another something for a coil. That's where ADP came in. And for the furnace, that's where ADP comes in. It's not unheard of in our industry, and they're comfortable with it.
Do you sell
It's not another brand.
Do you sell American Standard furnaces without the condensing units?
If someone has a heat only or they have a replacement, yes.
So that would be the same type of unit that ADP that you'd be supplying with ADP?
You see, ADP is not an equipment manufacturer because they don't make an outdoor unit and they don't make a package unit, so they're not viewed as an equipment manufacturer. They're a component manufacturer. That's the beauty of the whole thing. I would be able to accomplish everything. I'd make you happy, I'd make me happy, I'd make 75 families happy. Everyone would be happy with this type of a transaction.
I'm sorry, I just want to, because I have a lot more to cover, so I just want to be clear that there would be an ADP branded furnace that you could install, or an American Standard branded furnace that you could install. So you have two manufacturers, two different types of furnaces that you would be carrying and distributing at the same time.
They're not equipment lines. ADP is a component manufacturer, and you have to understand that. They're not an equipment manufacturer. There's a difference. They don't make a full line of equipment.
Right, but they are making you were trying to get them to make a furnace for you under that brand, correct?
Brand a furnace for me, not make a furnace, right?
Okay, so, in March 2019, you discovered that Ingersoll Rand may not make the October 1st deadline?
Correct.
And what actions did you take at that time to try to investigate other sources for furnace supply?
Well, I had the relationship going, the conversation going. It hadn't died yet till about, let's see, the ADP thing probably died somewhere between March and April. So that was the end of the road for that. There was a lot of pressure that we put on Ingersoll Rand as best we could for a furnace. A lot of yelling and screaming and carrying on. What can I tell you? I mean, you know, it was for us, we call it a lights out situation, so it wasn't a pleasant discussion, as you would imagine. As far as contacting other manufacturers, we didn't contact other manufacturers other than the Lennox. Remember, other manufacturers were not showing, well, you won't remember, but other manufacturers were not really showing their cards at all. Only recently have they presented themselves. They've been very quiet. Even the district knows that they've been very quiet all along, and I don't even know to this day what they do and don't actually have commercially available. So they weren't showing their cards, they weren't having conversations, and they weren't talking, and you know it and I know it.
Did you contact them?
Beyond Lennox, who had the best line and the one that you guys told me would sell me directly, not formally. And
Informally?
the result is the same.
Okay, so when you say you contacted Lennox, who did you actually contact in February 2019?
I did not contact Lennox directly, I contacted through ADP.
Okay, did you ever contact Allied directly?
This morning I contacted him.
No, in the initial talks, in February, March, April, did you ever contact Allied directly?
So Allied, who's a division of Lennox, was contacted by ADP, and we had a conference call.
Okay, and did you contact Lennox directly during that
Lennox
period of
Lennox
time?
does not sell to distribution. Lennox only sells to contractors, direct. So the path of travel would be through Allied, because Allied sells to distributors.
So you did
would
not?
know that. You would know that Lennox does not sell to distributors. They sell directly to contractors. Allied is owned by Lennox. Allied is making the furnace for Lennox in the Mexico factory, right?
So when you say they turned you down, in March 2019, I believe you said?
Right around there, March, April.
Can you tell me exactly what the communication was?
They said they don't want to sell us any furnaces.
They said it in
That's the way it was
person, they said it in a telephone call, they said it in an email?
It was at least a telephone conversation through ADP, at least. I don't recall an email. It's possible that there was an email, but I recall the telephone conversation.
And that was from somebody at ADP?
Yeah, my rep.
Did you follow up with Allied to find out why they didn't want to sell you any furnaces?
You want me, no, I never spoke to Allied at that point. Allied only came on later on, after you put pressure, well, after you guys started tickling them. Then they
I thought
started
you
calling.
said you had a meeting with Allied at that
That was
time.
later, that was in August.
So, so you never contacted Allied during that period of time to further inquire?
ADP is a sister division to Allied. Allied said no. You want me to contact Allied, who said no? If anyone has a vested interest in helping me, ADP would help me because it's their brand. And to prove it out, after you guys tickled them, they came to me in August. You just didn't tickle them enough because I'm here today.
So, How long does it typically take to negotiate a distribution agreement?
It depends on the manufacturer and how quickly they want to move, but typically you have to work out, well, in their case, there's no paint color change, so they would, let's see, I'm just thinking the shortest possible agreement time, what needs to be worked out. Pricing would need to be worked out, truckload quantities, warranty parts, tech support. If someone really wanted to get it done, you could probably do it in a week or two.
You could get a distribution agreement done in a week or two?
If they really, if someone really wanted to.
But what would be more
besides me,
typical?
I mean, I'm talking about the manufacturer. He'd really want to get it done. He could do it in a couple of weeks. If they really wanted to.
Okay, if it was more typical, how long would it take?
Oh, the dancing could go on for weeks. You could go on for a month or two. you
Okay.
know, back and forth.
And then, once you have that agreement in place, how long does it take them to actually start fulfilling orders?
So they told me, so we'll go by what they said, they, the manufacturer, they said it's, Allied said it's 6 weeks for manufacturing, and then figure it takes a week to get here from, or more, it's coming from Mexico, I don't know how long it takes. Let's say, give it a week, and let's say we give it to about 1 to 2 weeks to get here, so you're looking at about 2 months.
2 months after the order is placed, plus a week to a month, so up to 3 months it could take for you from the time you start a distribution discussion to when you could have product to
You
sell.
see it.
Till you'll see it. So the rule was passed in March 2018, and then you didn't contact anyone until February 2019.
Right.
Right? And then they turned you down, you said, in March 2019, and you knew that you have at least a 3-month lead time. When did you first start contacting other manufacturers?
Hang on, there are lots of questions there. It also misstated his testimony. He
Okay, so I'll go
testified-
one by
hang on,
one.
Hang on. He testified that he was having extensive discussions with Ingersoll Rand throughout 2018. So just to be clear.
Okay, so throughout 2018, you had conversations with Ingersoll Rand, but you didn't contact any other manufacturers to see about other possibilities.
That's correct, but I've already gone through this with you many times, and we're just spinning around, wasting everyone's time. The manufacturers are not looking for additional distribution. Distribution is not given out the way you seem to believe it is, and you don't understand the industry, and I've said that many, many times.
I understand, but anything you've said to me in a meeting is not before the board, so I have to establish all of the information before the board. So it's not because, when I ask you the same question I've asked you in a meeting, it's not because I didn't hear you, it's because I need to elicit that same information so that the board can consider it.
Okay.
So-
You have 5 manufacturers of heating and air conditioning equipment, 5 major manufacturers of heating and air conditioning equipment. They would want to enter into a distribution agreement with someone, let's just say me. They would want to enter into that agreement. If they did, they would want to have a nice long-term relationship, assuming that they needed additional distribution, which none of them need right now, and haven't needed in some time. So that they would have to be, it's not just Jeff begging, that doesn't quite pull it off. And the district suggested that I call every 15 minutes to these manufacturers and beg them for equipment, and that's just not going to go down that way, and I think you probably would agree, or any rational person would agree, that that's not the way it goes down. So, even if I contacted them 5 years ago, it's not the point. They need to be needing additional distribution for me to be a distributor.
Okay, did you contact or attempt to figure out a way to sell the products outside of the district? Outside of I'm going to cover the area that you're currently in contract for with Ingersoll Rand for the South Coast area. But did you investigate trying to sell the products somewhere else? San Joaquin, Northern California?
San Joaquin's actually
Do you
interesting.
understand the question?
You're saying, why am I not moving to another?
No, I'm asking if you have tried to sell your existing stock outside of the district.
We're not talking about stock now, we're talking about, I don't have a furnace come October 1st.
Okay,
That's
so,
what she's asking.
Oh, she wants to talk about the stock? Or
well,
she
let me
wants to talk
just
about-
clarify. Are you not seeking relief to sell your current existing stock?
One follows from the other. If I don't have a furnace, then I'm asking them to continue to sell the 40 nanogram per joule product for a certain number of months until such time as I have a 14 to replace it. That's the ask.
Okay. Have you looked at expanding your jurisdiction outside of the South Coast District?
So I don't have the wherewithal to physically do that in a very short order. Short order means you have to have a facility. We own our facilities. They're large facilities. All of our employees are within the district. You're asking us to move to another district because we don't have a furnace for a couple of months. I don't think that's really a reasonable request. Doesn't seem to make much sense to anyone.
Did you take any steps to begin reducing your inventory as the October 1st deadline approached so that you could, once you did find a product, you could start filling in and you wouldn't have extra product that you wouldn't be able to sell?
Yes, we normally carry 150 days of product. I've cut it back to 90.
When did you do that?
I cut it back about 2 months ago, right about 2 months ago, so I'd be holding it about 90 right now.
So how much stock do you currently hold,
I didn't count.
approximately?
I didn't count.
Okay.
So if 5,000 is 5 months, so let's say I have somewhere between 1 to 2, because you're coming up on a heating season and business has been pretty decent. So let's say around 2,000. Let's just throw a number.
You have
out.
2,000 units?
Plus or minus, about 2,000.
So-
Let's just say,
A 150-day supply is 5,000, but a 90-day supply is 1 to 2,000?
let's do the math, and maybe I did it wrong. So 5,000 is, so I need about 3,000. I take that back.
Okay.
I'm under
So-
pressure, no calculator.
Let's talk about San Diego. I understand you have what you said, tiny distribution center there?
Yep.
How big is the storage area? The
entire
warehousing
warehouse?
space?
I don't know, top of my head, is it 10,000 square feet, something like
And
that?
how much of that do you use to actually have furnaces, that you're storing the furnaces?
They measured it, they had about 300 square feet. I've been told they measured it. I was given the number 300 square feet. I didn't physically take a tape measure, I believe them telling me the truth.
Is that 300 square feet a limitation on how many furnaces you can sell down there?
It's a limitation on how many furnaces I can sell or how many I can stock.
How many you can sell?
No, why would that be a limitation, how many I can sell? No, I would
Have you not referred to the 300 square feet warehouse space in numerous discussions with the district,
Yeah, the
saying that that's
district's asked
all
me
you
to-
have
They've asked me
there?
to move them all down to
Let-
Escondido.
Let's try not to talk over each other. So Ms. Reichart will ask the question, finish it, and then Mr. Winter will answer, finish it, and we'll go back and forth.
Have you mentioned the 300 square foot of storage space repeatedly in your conversations with the district as a limitation on the scope of your potential to sell in San Diego?
The district asked us to move the furnace, or suggested, sorry, they didn't ask me to do any such thing. They suggested moving the product to Escondido because it would become illegal within the district. 300 square feet, and I have a couple of 100,000 square feet in the district, so it's not a match. And to be able to properly take care of any sort of volume of business, 300 square feet doesn't represent a lot of space at all, number one. And number two, we have a very small presence over there, as you would imagine, and not everyone is waiting for me to get there.
Do you have, I understand things have changed, but prior to any changes you've recently made in San Diego, did you have a sales team down there?
We had inside sales, 2 folks and a driver, and then we enhanced that to an outside salesperson full-time and an additional driver
Okay, and when did that occur?
within the last 2 months.
Within the last 2 months?
In the last 2 months, maybe 2 to 3 months. I don't have the exact dates.
Okay, and did you make any effort, did you, about further expanding your potential for sales in San Diego?
Once the volume picks up, we'll continue to do that. San Diego is not very viable for us. It's far away from our Riverside location. It's kind of isolated by itself. There's only one physical presence there. There's a lot of existing, very old distribution over there. It's 50, 60-year-old distribution down there. So for me to displace them, just because I'm in a hurt on ultra-low NOx furnaces, I don't think is very compelling to contractors.
Is there a reason you are not expanding into the rest of the square footage you have in that location to add additional stock?
There are tenants there.
I'm sorry, I thought you said that your space was,
Yes, so where would you like, what other
I thought
space?
your space was 8 to 10,000 square feet, but you're saying someone else is occupying that space?
No, I thought, that's a multi-tenant building. I thought you were referring to other spaces within the building.
No, how much is your space that you are
You know, off the top of my head, I believe it's 8 to 10,000 square feet.
So, but you only have 300 square feet for furnaces, so what about the rest of the
Well, you have
9,700 square feet?
So you have sales area, you have restrooms, you have small parts counter area, you have sheet metal, you have flex duct, you have registers, you have air conditioning units, not just furnaces, you have coils, and I go on and on and on and on. 10,000 square feet is a postage stamp. I think my sales area is larger in Culver City, so
Okay, so what about Ventura County? What is your presence in Ventura County?
we don't have a presence in Ventura County.
Okay, but you are authorized to sell in Ventura County?
American Standard will allow us to sell in Ventura County.
And have you made any efforts to increase your sales presence there?
Ventura County is not a viable area, and we don't sell much of anything there other than our contractors buying it in Van Nuys and taking it to Ventura.
Okay. I want to talk about when you started reaching out to other manufacturers. Have you reached out and contacted Goodman?
Yes,
When did you first make contact with Goodman?
when Sean gave me the phone number.
Which was when?
2 weeks ago, top of my head, maybe less. Don't hold me to it.
So sometime in early to mid-September?
I think so,
Okay. And why didn't you contact them prior to that?
because they have their own distribution. But, in doing so, I would harm myself because they would run around telling my customers that I need a furnace. But I did it because the district asked me to,
But because you need furnaces to sell, right?
because I need furnaces to sell.
Right. So, I mean, the district suggested that a way to comply with the rule would be for you to obtain furnaces elsewhere other than Ingersoll Rand, correct?
Correct. So not knowing the business that the district doesn't know, a manufacturer to sell me a furnace is not a furnace, and a furnace only, is not very viable, and no one's going to want to do it. But to satisfy the district, I did it with a full heart, and I did exactly what they asked me to do.
But you did reach out to Lennox to try to sell their furnaces
Through ADP,
through ADP.
through ADP as a component, not as a line of equipment.
But so it's not unreasonable for the district to say that you were already reaching out to one manufacturer to add to the types of, or the brands of furnaces that you carry, to suggest, why don't you look for other brands to carry as well?
Not listening, so I'll do one more time. ADP is a component guy. They make a coil, and they'll provide me with a furnace brand labeled from Allied.
But that brand
was
is,
allowed to happen, and it was not allowed to happen.
but that brand is not American Standard, correct?
It's a component. It's not American Standard branded as much as ADP coils is not American Standard branded, and American Standard's comfortable with that.
But
So
it is a differently branded furnace,
Yes.
correct? Just like Goodman would be a differently branded furnace.
But Goodman would need to want into that type of relationship, and Goodman would not want into that relationship as much as Carrier doesn't want into it, as much as Johnson Controls won't even respond to me, as much as, and so on. And
Okay.
Rheem, oh, by the way, I called Rheem too. They were number 6.
Okay.
Rheem didn't bother calling back.
So Goodman, you contacted 2 weeks ago. Did you contact them by phone or by email?
By phone, the phone number that you all gave me.
Okay. And what happened when you called them?
Who?
Goodman.
A couple of days later, the guy called me back. He knew me from all the meetings, which was very nice. They all know me from the meetings. And he couldn't help me specifically, but he referred I never spoke to the person, referred it to someone else who sent me a non-disclosure agreement.
Oh, okay. And so what happened with that non-disclosure agreement?
Nothing. I can't do a non-disclosure agreement. They didn't offer to sell me any furnaces. They offered me a non-disclosure agreement.
What's
That
a
means-
non-disclosure agreement?
Exactly that. You're an attorney. Non-disclosure agreement. I can't disclose in the agreement. So I can't talk to other people about what it is that I'm talking to them about. That would open me up, and I've never done that in 60 years. There doesn't seem to be a reason to, other than to lock me up and have a conversation with me and cause me more grief than I already have right now.
I'm sorry, it's your understanding that a non-disclosure agreement would prevent you from continuing negotiations with other manufacturers?
At the same time.
Did you consult with an attorney about that?
No, that's my own common sense. Did you read their non-disclosure agreement?
I have not read their non-disclosure agreement.
Okay, there you go.
If you would like to present it into evidence, we could take a look at it and decide.
It's irrelevant.
It's your understanding, is it your understanding that all non-disclosure agreements would prevent you from talking to other manufacturers at the same time?
No other manufacturer presented one. What does that tell you?
You've never signed a non-disclosure agreement?
Nope.
Have you ever seen any other non-disclosure agreements?
I've seen it for real estate.
And is it your understanding that typically non-disclosure agreements have limited scope in terms of the items that you can and cannot disclose based on the conversations you're having?
Correct.
Okay. So Goodman's was unique in that not only did it say you could not discuss the information that was shared during your negotiations, but you also could not continue to negotiate with other
I
manufacturers?
didn't read their non-disclosure agreement.
Oh, you didn't read their non-disclosure agreement?
correct.
So you don't know what was in it?
Do you know that they want to sell me furnaces?
I'm sorry, I'm asking the questions. I don't,
I'm not aware of
Yes,
the fact.
please, I'm sorry. It is correct that at this point, Ms. Reichert is asking questions, and if you could just answer them, we would appreciate it.
okay. So they sent you a non-disclosure agreement, and you didn't read it, and then you stopped communicating. Is that accurate?
They didn't, I asked them a question. I need furnaces. They did not answer the question.
They didn't answer the
Did
question,
not answer the question.
and they sent you a non-disclosure
Sent
agreement,
me a non-disclosure agreement.
and you did not read the non-disclosure agreement.
That non-disclosure agreement came a couple of days ago, and I was not going to read the non-disclosure agreement and go through a useless negotiation with them, as we all know would be a useless negotiation with them. Because all I need someone's assistance for is 4 months, and no one's going to enter into an agreement with me for 4 months.
Let me take a step back.
Please.
I thought that you had said that when you were negotiating with these other, or you were talking to other manufacturers, that you were interested in establishing a long-term relationship with them.
Only ADP. It's the
Only
one I said.
ADP.
That's correct.
So you
Which is Lennox.
are not interested in establishing a long-term relationship with the other manufacturers?
I don't need to. You asked me to find another manufacturer who will sell me ultra-low NOx furnaces.
But if the only way another manufacturer would do that would be to establish a long-term relationship, then why wouldn't you do that?
Because they won't. They have distribution already. You just don't know the business. I've told that to you many times. You don't know the heating and air conditioning business. You don't know anything about distribution.
Did you ask why Goodman sent you a non-disclosure agreement if they had no interest in working with you?
Did I ask Goodman why? Please repeat the question.
Did you ask Goodman why they would send you a non-disclosure agreement if they had no interest in providing you with furnaces?
They have a reputation for suing people. I'm not interested in going through a lawsuit with them.
So you did
Have
not
that
ask them?
baggage. I did not. Once they sent me the non-disclosure agreement, that was not a friendly welcome, hello, I'd like to do business with you. That, to me, was a trap. And I'm not going down that road to lock myself up with a conversation and then worry about how the lawsuit's going to follow up behind it. I'm not interested in that.
Okay. You said you contacted Ream. When did you contact Ream?
Same time, I called everyone at the same
2
time.
weeks ago. Did you contact them by phone at the number that Sean Wang gave to you?
Correct.
And who did you speak with?
The name that Sean gave me, I don't have it on me.
Okay.
The voicemail answered the phone.
That you left a voicemail at
I
Ream?
did.
And
Twice.
you left 2 voicemails?
I did.
How many days apart?
1 day apart.
You left 2 voicemails with the person that we gave you, or Sean gave you, and then they did not respond?
Correct.
Okay. Did you follow up or try to send an email or contact anyone else?
I didn't have an email, but since everyone else replied, well, not everyone else, well, Johnson called.
So you didn't follow up with anyone else or send any emails to them? Okay.
They didn't feel like it.
Did you contact Nortec?
That wasn't one of the names you gave me, so, or I didn't ask. I didn't know that they had a furnace. They're not on your website.
Okay. Did you contact Johnson Controls?
I did.
And and that was the same time frame 2 weeks ago?
Nortec's not on your website. And I think at the meeting, not I think, I know, at the meeting, the last meeting we had, when was that? Last Friday. At that meeting, you said that Nortec is a small player and so on and so forth. You didn't really have much excitement for
So
them.
you didn't contact Nortec?
Right. I mean, you didn't think it was a good idea either. You felt like they weren't much of a play, and they don't have any furnaces listed on your website.
Did you contact Johnson Controls
I did.
2 weeks ago
I did.
by the phone number that Sean Wayne gave you?
I did.
Do you remember the person's name you talked to?
Nope. But he remembered me from the meetings.
Okay. And so you actually spoke with him, you did not leave a voicemail?
He called me back.
He called you back?
Sure did.
And what happened during that conversation?
He said, I think he said he would refer it to someone, and he didn't do anything, probably, because they don't need me. So, there you go.
So on the phone, he said he would refer it to somebody?
He said he would refer it because he was just the legal liaison or the fellow in charge of codes, or he wasn't a fellow in charge of distribution.
Senator?
Madam Chair, if you want to continue the cross-examination, but the district said that a witness.
Yes, I am, thank
10
you.
minutes.
I am keeping my eye on
If
the
you're going to recess
time.
at 12:30, 10 minutes, is all you're going to need.
Yes,
Got to do it right away.
that's correct. What I'm going to ask, thank you, but I have been keeping an eye on it, but really what I want to know from Ms. Reichard is how many more questions you
Well,
will have for this witness.
I'm finishing up this section. I might be able to finish up in 10 minutes.
Okay,
let's
let's
try.
try.
Okay. So they referred, Johnson Controls said that they were going to refer you to somebody else, and that was at the first time you spoke with them?
The first time they called me back, yes.
Yes. And they, and then did you hear anything back from them?
Nope,
Did you call them back?
nope.
And then you also called Carrier 2 weeks ago?
Understand they have distribution.
I'm
York
just
has
saying.
distribution.
I'm sorry, I'm trying to get through.
And I'm trying to tell you, York has distribution.
So you contacted Carrier 2 weeks ago?
I did.
On the phone with the number that Sean Wayne
Actually,
gave
it
you?
was somewhat unique, because I had his card from one of the meetings, he had given it to me, so I reached out to him by email.
And was that around 2 weeks ago as well?
This fella.
Was that around 2 weeks ago as well?
Yes,
Okay. And what did they reply to your email?
yeah.
And what did they say?
I'll let you know tomorrow, I'll let you know tomorrow, I'll let you know tomorrow. I think I have 3 or 4 of those. And then yesterday, he said they are not interested in any more distribution, and he said that you guys called him as well.
So they said they're not interested in distribution.
They are not interested in any additional distribution.
And did they offer you anything?
They offered me to buy from my competitor.
They offered you a sub-distribution agreement, is that
No,
correct?
you said that. That's your word. They did not say sub-distribution. How would you know that? Who said sub-distribution?
I'm asking you, did they offer you a?
used the word called sub-distribution.
Yes,
How
and
would
I
you know
am-
that? They didn't offer me sub-distribution. They said that you can buy it through Sigler, who is their distributor, just like Howard Industries for American Standard. They said I could go buy from their distributor in the market, which means like my contractor customer, we both stand there together side by side and buy it. That's not a viable solution, and they know it, and they said so. That's why they were very clear, no additional distribution.
So it's your testimony, they did not offer you a sub-distribution agreement?
I don't know where that word's coming from. They never said so.
Do you know, is that a word?
Sub-distribution is probably a word in the dictionary, but they never offered me one.
Is that a word in your industry?
Not that I'm aware of
Not
sub-distribution.
that, sub-distribution is not a word that you're aware
I
of.
don't know what
Okay,
sub-distribution
wait,
is.
again, please, finish the question, then finish the answer, so we are not talking over each other.
So sub-distribution is not a term that you are aware of being used in the furnace sales and distribution industry?
Not that I'm aware of.
Okay, so what exactly did they offer you?
They offered me to buy from my competitor.
They offered you to buy from a distributor
Yeah.
and then sell their product.
Well, I'd be buying it from someone just like myself.
Wouldn't that give you product to sell?
That would give me product to sell? Yeah, I mean, I could buy it just like one of my customers. I guess that would give me product to sell.
So you could sell that compliant
I
product?
wouldn't be able to sell it.
Why?
Because my cost would be the same as my customer.
But
Maybe on a good day, who knows what price they would charge me.
But you'd be buying in bulk, couldn't you get a discount by
I don't know
buying
where
a
you
lot?
got the bulk idea from. They didn't offer me any bulk ideas, and also they didn't offer me any technical support and any warranty parts, and on and on and on. There's a whole lot that goes into the distribution business, which you're not aware of.
They explicitly told you they would not offer you a warranty?
No, I didn't say that. Again, distortion. The warranty would be handled by the manufacturer through the distributor. Since I'm not a distributor, I would have to go to that other distributor and rely upon him. That's not viable. Anyone knows that that's not viable.
So they told you they would not do that? I'm sorry, they told you that?
They told me what?
That they would not offer you warranty support?
No, they said they would not offer me any distribution. They're not looking for distribution. We need distribution. We need someone to sell me a furnace, someone meaning a manufacturer.
So where are you getting the idea that they would not offer you warranty support?
I didn't say that.
You said that you'd have to go through the distributor to get warranty support.
That's what I said.
Okay, so they would not offer you warranty support directly.
That's right,
Where did you get that idea?
because they told me to buy through the distributor.
Did you ask them if you would have direct warranty support?
As a matter of fact, in my email, surprisingly you don't know that, in the email it said to them, as a distributor, I would need warranty support and I would need technical support to properly take care of our customers. and they replied back to me, we are not looking for any additional distribution. So anyone knows, everyone in the business knows that if you need warranty support and technical support from the manufacturer, that's called a distributor. And they are not looking for additional distribution, i.e. not looking for me.
Okay, so did you contact the distributor that they suggested you buy through?
You're kidding.
I'm not kidding. Did you contact?
You want me to call my competitor and ask to buy?
Okay, again, please, I think this is argumentative. Just answer the questions.
Madam
No.
Chair, I
Senator,
know what you're saying, but some of these questions have been asked and answered already based on how I'm listening. Or he's explaining that if he buys, if he cannot become the distributor from the company, he has to buy from his competitor, and they will not give him a service contract. So therefore, it doesn't make sense to engage in it. That's
okay,
it.
but wait, let's not testify for petitioner or for the witness, but are you asking about a different distributor? or
No,
are
I'm
you at the
asking
same-
about the distributor that Carrier referred them to. Did they contact them?
No, I did not contact my competitor.
So you did not contact the distributor
now-
that they referred?
Now it has been asked and answered.
Okay. Were you aware that Ingersoll Rand, via their Train brand, filed for a product variance?
Yeah, yes, they told me about that.
They told you about that?
Yes.
And did they make any representations to you about that?
What's the representation?
Did they make any representations about what would happen with that product variance and how it would impact you?
No.
Did you discuss it with them in any other detail?
I asked them to ask for a variance on the ultra high stuff that I told the committee here about, in order to sell the highest efficiency air conditioning units, just to ask for that.
So you asked them to add to their petition the communicating furnaces?
No, I asked them to file a separate variance to help us out on that very, very small part of the furnaces that's not being,
Oh, I'm sorry.
sorry.
Did you read the petition?
No.
Okay. Did they communicate to you when they decided to take that petition off calendar?
No.
They didn't?
Nope.
So it was a coincidence that the letter answering all of our questions from August 7th came in the same day?
Yeah, one thing has nothing to do with the other. I was actually hoping to be in the gallery listening to their testimony.
Can you tell us why it took you nearly a month to respond to the questions we had for you in the August meeting?
I'm not aware of questions that we didn't answer. That's surprising to me as well.
Why didn't you answer in the month of August?
I didn't have questions to answer.
Did you, after,
Okay, wait.
sorry,
Wait,
let me clarify. After,
Take it step by step, but
Yes,
you know what, maybe
I
we
know.
need to, I think we might,
that's
is this
fine.
the last line? of
I don't know,
questions?
probably not.
Okay, then I'm sorry to be so disjointed. I think it's best to continue on a line of questions, but we don't want to lose any witnesses. So let us ping out of order for a moment, and we will return once we're done with that witness.
Brief moment off the record, please.
Yes, we're off the record. We're back on the record.
Thank you. This witness needs to be sworn in.
Okay, I was going to ask that. Can you please rise?
The district calls Yanrong Zhu. Can you please state and spell your name for the record?
Yanrong Zhu, Yanrong, that's first name. Last name is Zhu.
And did you take the oath?
Yes.
And what is your position here at the district?
AQ specialist. I worked on the rule amendment for this Rule 1111.
And were you present at the June 19th meeting with Howard Industries?
Yes, I was there.
And did you take contemporaneous notes at that hearing?
Yes, I have notebook here.
Okay. And do you have notes relating to comments that we made regarding the need for a variance or a potential need for a variance?
Yes, I have my notes here, and
Yeah, you can say that.
okay, I'm going to read what I wrote on my notebook here. So here, Mary suggested to get data ready for variance and with information for number of models and others.
And was there any information given regarding the amount of time necessary to file a properly noticed variance petition?
On the other part of this note, yes, I also have what Phil suggested under this suggestion, and he mentioned, as Phil Fine, he mentioned that he suggests the company to file variance, and then it has to be filed 45 days before.
Okay. And did we suggest that there might be other potential options other than a variance?
Yeah, here is also what Phil Fine said. I wrote it down, that the facility may need to consider variance or others to address the small portion of product. So I didn't say the facility, so may consider district probably is a district. I just said may need consider variance or others to address the small portion of product.
And were any statements made at that meeting regarding the potential for any rule amendments before the compliance deadline of October 1st, 2019?
Yes, this is also Phil Fine suggested that no rule amendment before October 1st, 2019.
Okay. And do you have any other independent
sorry.
I'm sorry.
Can I just interrupt for a moment? Because when you began your questions, you said the June 19th hearing, but this is a
Oh,
meeting.
my gosh. I am very sorry.
This is a meeting. Can you just please ask the witness just to explain the meeting and that this was a meeting?
I apologize. That was a misstatement on my part. This was a meeting at the district, held at the district with Howard Industries and representatives from them, as well as myself and district staff. Is that correct?
Yes, that's correct. This meeting was held on June 19th, 2019, 11 a.m. at the conference room CC2, and we, the staff included Phil Fine, Mary Rakers, and Gary Quinn, Sean Wan, and me. And the facility representative including Jeff Winter and Son, and also Howard Berman.
Thank you. Thank you for that clarification. I apologize for misstating.
Thank you very much.
Did you have any other recollection of that meeting regarding any indication that the facility should not file a variance?
And I can read the notes because I don't exactly remember exactly what we said. However, according to my notes, I said that so timing for variance and order of abatement. So which means we talk about the timing for variance and order of abatement, and yeah, regarding the variance of order and order of abatement, that's the only writing I have.
That you had on that? Okay. Thank you very much. I have no further questions.
Thank you. That was short. Mr. Williamson, do you have questions for Ms.
Yes, I
Zhu?
do. So, Ms. Zhu, it appears from your testimony that your only recollection of that meeting is what you have from your notes. Is that correct?
That's correct.
So you have no independent recollection of what was discussed unless it was included in your notes?
I don't want to provide inaccurate information, so I rely on my notes.
Okay, perfect. So you were referring to a variance in your notes, but what was the variance for that you were writing down in your notes? Do you recall?
The variance, I just wrote on variance.
Okay, so you don't know what the variance was asking for?
Oh, that we know is the variance for the Howard industry product.
For just specific products, or was it what we're asking for today, which is a broad variance?
And this is a statement, and I would say I'm not 100% sure, but it's for the broad products.
Okay, you're not 100% sure, though?
I'm not 100% sure.
Was there a discussion at the meeting about a much more narrow product variance being sought?
Yeah, that was the discussion.
And so you can't recall if the notes were reflecting that discussion or the broader discussion, correct?
I just want to be cautious.
But you can't recall here today whether the notes on that you're referring to here are talking about this specific product variance or the more broad Howard Industries-wide variance. That's correct, right?
Yeah, the variance must address the discussion.
But you can't recall which of those variances sitting here today. You cannot recall which of those variances these notes are referring to, correct?
I don't want to make that statement. I'm just providing my notes.
But you can't recall, your notes don't indicate, right?
My notes is indicating the discussion on that meeting day, and we are discussing the product availability, and also the inventory our industry have.
I appreciate what the notes say. I'm asking you, you cannot, sitting here today, tell me if your notes are reflective of a more specific product variance versus the variance that Howard Industries is seeking today. That's correct, right?
The note is not for the specific variance you are seeking today. It's for broad variance. I hope I.
We'll move on.
We were exploring possibilities. We are not providing specific suggestion on what Howard industry should do. So that's what the meeting was about.
What language in the notes do you have that reflects that?
Excuse me?
What language from your notes indicates that you were not providing direction to Howard Industries? Because as you heard earlier today, that's very different than what my client recalls from that meeting.
Because here I note so the discussion here, I put bullet notes, timing for variance and order of abatement. So we provide a timing. One, you should start to file order of variance, and one, you probably can think about order abatement. Just we provide all the options there for a company to choose. Normally, we don't tell company what to do.
So your note indicates that you discussed timing, and from that note, you infer that you guys talked about all of the options for Howard Industries and took no position on which route they should take moving forward?
We generally don't take a position, and then what the discussion is to provide information, because the facility will come to us. They don't know when they should file variance and what do they do if they want to do order of abatement. That's why we talk about timing. If they want to do variance, when they should start.
And I'm not talking about generally speaking. You're testifying today about a specific meeting that is contradicting testimony in front of the hearing board. I want to know what the basis of that testimony is, because you have testified that you're relying entirely on your notes for your recollection of this meeting because you're uncomfortable testifying based on your memory. What I'm asking you is, where in your meeting notes does it indicate that you guys gave a full array of options to Howard Industries and that you did not commit one way or the other to a path forward for Howard Industries following that June meeting?
I can provide a copy of my meeting note. Here, we presented both options here.
So the fact that both of them are mentioned is what you're relying on for that testimony?
Staff was trying to provide information for both options in that meeting.
Did you take complete notes of the entire meeting?
I have complete notes for the entire meeting, but my writing is brief. However, here.
How long was the meeting?
The meeting started at 11 a.m. I didn't know when it ended.
Approximately how long was the meeting?
I suppose 1.5 hours.
How many pages of notes do you have?
I have a little over 1 page.
So a little over 1 page of notes, and you think you reflected every discussion that occurred at that meeting in that 1 page, a little over 1 page of notes?
Objection argumentative.
Sustained.
Is it possible that you didn't reflect the entire conversation in that meeting in that 1+ page of notes?
This is paper notes, and we try to be brief and bullet the discussion.
I say yes or no question. Can you just answer the question?
I'm sorry, can you ask it again?
Is it possible that your notes don't reflect the entire conversation at that meeting and the little couple lines of notes you have from that meeting?
By my
It's a yes or no question. Sorry, I just want a yes or no.
Can I have just a brief moment?
Yes.
Could you repeat the last question, please?
In the one and a little, I don't know what it is, 1.5 pages of notes you took during that hour-and-a-half meeting, is it possible that the notes you took didn't reflect the entire conversation between the parties?
No.
Okay, sitting here today, can you say with certainty that the district did not ask Howard Industries to not pursue a variance petition?
The district, I'm confident the district didn't ask Howard Industry to only pursue, to not to pursue variance.
What makes you confident if you don't remember the specifics of the meeting from your memory?
Because I remember we provided details on what the facility needs to do if they want to file variance.
Okay, and do your notes reflect that the district agreed to pursue an order for abatement with Howard Industries?
No,
Do you recall that conversation happening at the meeting?
I recall the district staff presented both variance and order of abatement options.
Okay, what in your meeting notes make you think that the district did not decide to pursue an order for abatement at the conclusion of the meeting?
Because my meeting notes will write down all the conclusion or suggestion we make in any meeting. So that's why here, what Mary suggested, what Phil Fine suggested, I wrote them down. If we suggest a company to not to do something and to do something, for sure I'm going to write it down.
And there's no indication in there one way or the other in your notes?
My note I didn't write that the district asked the facility not to pursue variance.
But that's not the question I'm asking about. The district asking our client, asking Howard Industries to pursue an order for abatement as the path forward here.
My note didn't say that.
Okay, no further questions.
Can I just have one brief redirect?
Yes.
Council was asking you about the type of, actually, it's going to be a two-part question. The type of variance, do you know the difference between when he was saying a broad variance versus a product variance?
No, I'm not very clear, so he confused me, actually.
Okay. And then on your notes about the suggestion regarding a variance, could you read that whole section of notes again for us?
Okay, my notes anywhere related to variance
Well, just
or
the part where, just here where we were talking about the suggesting a variance and the type of information that they should get prepared for that.
Okay, it's brief, as the note says, Mary suggested to get data ready for variance. And that would include numbers of models, and
Okay.
yeah, that's all.
Okay, thank you. That's all.
Okay. Board members, any questions for Ms. Zhu? Mr. Balagopalan.
Ms. Zhu, you said you were the staff person who worked on the amendment to the rule.
Yes,
That's the March 2nd, 2018, or both, the July 6th, 2018?
yes,
Both of them, or just?
both.
Both. I'm a little confused on the timelines. Do you know when the compliance date was,
I'm so sorry to interrupt. I do have another witness that is going to step us all the way through all the timelines. I was trying to just bring this witness because she was the one that had the notes about this specific meeting that I needed to address some of the statements. And so I just brought her up for that limited purpose. But I will have another witness to talk through the whole timeline if that would be helpful. I'm sorry.
Yes, and if I probably should have directed, if we could just ask questions on Ms. Zhu's actual testimony, that would be the best use of her time for the next 15 minutes.
in that case, I don't have any question.
Anyone else have questions? Senator?
Your last statement, Ms. Zhu, is that in your notes it says, get ready for the variance. Did you say that?
My notes here didn't say get ready for the variance. My note said get data ready for variance. And we also, on the note, also suggested that may need variance or others to address the small portion of product.
Get data ready for the variance, which means that if you, interpretation from this point of view, if you apply for variance, you have to have the data to justify the granting of a variance.
Because when here my note also says that for variance, file 45 days before. So we presented both option variance and all of abatement, and the company needs more time to get data ready if they want to keep this option.
Right, so the district was, in your opinion, based on your notes, were mindful of the fact that the Howard industry would request a variance. Do you understand my question?
If you don't understand, ask for clarification.
I don't understand.
Based on your notes, statements you're making, if you're understanding, get the facts ready for a variance, that Howard industry was getting ready to apply for a variance, yes or no?
Yes.
They were getting ready to apply for a variance. The answer is yes, correct?
Yes.
Okay, fine. You didn't know which one was the regular or interim.
I don't know.
That was not specified. They said, get ready in 45 days. I understand you used the term, the timeline, 45 days. Is that correct?
That's correct.
Okay.
But by 45 days, were you referring to how long it would take once filed to receive a hearing? Or do you know from based on what your notes said?
I'm not very clear about the process, and Mary in the meeting said for variance they need to file 45 days before. So they need more time to prepare for the variance.
Okay, I just wanted to clarify. Senator, you may continue.
The only variance that falls within 45 days, it could be regular. All right, thank you.
Any other questions for Ms. Zhu before we let her go? Yes, Ms. Verdugo-Peralta.
Thank you, Madam Chair. In that meeting, were there discussions to the detailed specificity that Mr. Winter was trying to get across to us in regards to the differences of the product, the distribution, the type of distribution that he was discussing earlier? Were there discussions in that meeting about that, and so that everybody was on the same page or not?
And the meeting, Ms. Winter told us the total distribution area for this industry and for this company, and the site distribution warehouse size in Escondido, and he also said Howard paid mitigation fee to the OEMs, and they constantly have 5,000 units in storage, and the annual sales is 35,000 units. And also, he said they need more time, which means they need more time to have compliant units from their manufacturer.
I'm trying to get more to the point of did AQMD staff discuss with Mr. Winter what he was trying to explain earlier, the difference between the components versus the actual heating system? Was there any discussion like what has taken place today?
There was no that discussion in that meeting.
Any other questions for Ms. Zhu before we, Senator?
After sitting here this morning and listening to the respondents and the petitioner's statement, open and otherwise, and the cross-examination, and reflecting back on that hour and a half meeting, you think your minutes were in detail as they perhaps should have been to discuss what they referred to at that meeting?
Do you understand the question?
Yeah, so your question is if my meeting notes is in detail enough to understand the issue in that
Sufficient,
meeting.
right, I
Okay.
understand.
And I just want to clarify, do you consider these minutes or notes?
There's my notes.
All right, notes, whatever.
And it's sufficient enough to record all the concern and suggestions.
Both the petitioner attorney and respondent attorney referred, and Mr. Winter, referred to discussions that took place at that meeting, which is substantially different from what you're saying that you have fixed in your notes. Would you agree to that? Or did you cover most of the important detail?
This is my job to take notes and cover all the essential part as a rule writer. So I trust my notes.
In your opinion today, sitting there, you think in your notes you included significant points that were discussed at that meeting, yes or no?
Yes,
You do, huh?
yeah, I do.
Oh, okay, carry on.
Okay, let's not have side conversations, or well, let's give respect to each witness, please. Does anyone else have questions for Ms. Zhu? Mr. Balagopalan.
Ms. Zhu, during the meeting and that you had, was the issue in not meeting the 14 nanogram per joules only for the mobile home furnaces or for all the different types of furnaces that they sell? That you recollect? It's not in your notes, but
I recall they address there are certain models may need more time, like high efficiency cooling and upflow.
no, I'm not talking about models because the rule is very specific in Table 1 for mobile home furnace.
Yes.
So was the issue, the discussion that you had the meeting for was to address that they cannot meet the mobile home furnace standard?
Not in that meeting.
Okay.
But in previous meeting, we are already very clear. They have 90% of the sales on non-condensing furnace, 10% of the sales on condensing furnace.
And if, for the clarification of the board, what type of furnaces are found at mobile home?
Mobile home furnace is I don't think Howard Industry distributed any mobile home furnace.
Can I just, it's a separate category from condensing or non-condensing,
It's a
correct?
separate category, and it's separate from non-condensing and a condensing furnace.
So the deadline in the rule for the compliance date, October 21st, is for mobile home furnace, correct?
We're going to have another witness for that, or do you?
Yeah, we'll have another witness, but you're speaking about the October 1st, 2019 deadline?
2018. The NOx limits, the compliance schedule in Table 1.
In the rule, it says 2018.
That's without mitigation fee, and then company has 3 more years when they pay mitigation
Yeah,
fee to
but they
service.
did not choose to go with the mitigation fee. That was not discussed during your meeting on mitigation fee, correct?
It was it was analyzed during the rulemaking.
No, during your meeting.
No.
We're not talking about mobile home. Maybe I will provide more clarification when we go through the timeline and the difference between the deadlines and the end of the mitigation fee period.
Right. And when you say the October 2019, keep hearing that, the deadline, the rule says you have to pass through sell-through provision 300 days from the compliance date, which is October 1st, 2018. So that's 300 days, not 1 year, though. It's 10 months, correct?
That's, you're talking about the 300 sell-through day that, and a 2009 rule amendment that was posed, and for other than mobile home, all other units like condensing, non-condensing that our industry is selling, they already used that sell-through period. And they already used, and then after that period, we gave the option of mitigation fee period so they can pay a fee to sell non-compliant products. And then in 2014, we gave that option, and in 2018, we extended that option.
Okay, we'll wait for the other.
Yeah, Yan Rung is actually very adept at she can tell you the whole history of this. I just was having her here just for this limited scope, and I do have somebody else that will go through the whole history of the rule and how each of those amendments affected the compliance deadlines and the mitigation fee periods.
Okay, thank you.
Okay, Senator has another question for Ms.
One
Zhu.
final question from me. During this meeting, I got the impression that the district working with the respondents was trying to find a solution to the problem and making certain recommendations and suggestions. During this meeting, did the district suggest that there are 100 models available from other manufacturers to meet the requirements of 1111? That's a solid recommendation. It's stated here today, 100 models. Did you make a note of that, yes or no?
Not on my notebook.
Did you recall hearing it?
I don't recall. I don't remember.
You don't remember? All right, that's good enough.
And also, can I know also if how many number of models available in the market, and then it's the data we compile. I have the information in my file, and then if we talk about, I probably it's not in my note. I had to note how many models we have because that's the information we already have. We provide.
Well, did you provide it to the respondents at that time, yes or no?
We provide to all the provide that
My question
information.
directly to this respondent during that meeting,
To that meeting, I don't remember.
but you have that information available.
We have that information available. We provide to stakeholders all the time, and we have a website. We update it.
So you have no idea whether or not it was ever provided to the respondents.
We have later. Sean probably will provide testimony on that and how much effort we put out to provide information to distributors and manufacturers. We have many outreach to let them know.
So sitting there today, you're confident, based on your standard practice and procedures, that this information may have been provided to the respondents.
We made sufficient effort to reach out.
You don't have a timeline.
We will provide.
Thank you, ma'am.
Okay, Ms. Zhu has to leave in a minute or two. Does anyone have any questions on her testimony that must be asked of Ms. Zhu in particular? Okay, thank you very much, Ms. Zhu.
You left exactly the right amount of time.
We did. That never happens, but it did today. And so we will take this opportunity to take our lunch break because we have clearly a lot of additional testimony and hearing to go through. So let's take a 55-minute lunch break, and we will reconvene at 12:50. And we are off the record. We are back on the record, and we are back with Mr. Winter, and I believe Ms. Reichart is going to finish up your questions for Mr. Winter. Before we do that, I just want to point out that we're still in the good cause phase, and it is now after lunchtime. So if we could try and mainstream our questions to the best extent possible and not, or streamline is what I meant, streamline our questions so that we're not asking the same ones over again, and we try to get through this quickly. I know we have a lot of additional witnesses aside from Mr. Winter. So with that, Ms. Reichart, your questions that remain for Mr. Winter.
Thank you. I have one clarifying question I just wanted to make sure I understand. Council stated in his opening that you had been before the district on a variance for Rule 1111?
You said that was 1978. I don't remember the year.
No, that was the last rule, that was the first time that we passed that rule. Were you before the hearing board on a variance?
Yes,
And that was in 1978?
yes,
Oh, and so were you a part of that?
yes.
Oh, okay, so you were aware of the variance process and everything from that?
Well, it's not quite at all the same, I can assure you of that. They were delightful people in the legal department and did what they said and said what they did.
Mr. Winter, could you speak, I don't know, again, if you're not speaking into the
I
microphone?
apologize, you have to move up real close. I said that it's very, very different today.
Right,
back in
but
those
if you
days.
could answer the questions, please. That would move our process along a lot quicker. Thank you.
Okay, and so you were eventually able to transition to the 40 nanogram per joule units at that time?
Oh, that was just, we were a very tiny company.
Okay. I'm sorry, I'm trying to streamline. Let's talk about your Lennox communications. You said that Lennox contacted you again after having not been in contact with you in August, is that correct?
That's the day of the meeting, what was the date, August? The day that we met with the district, which was that August meeting.
Okay.
I don't have the date.
And what
Hopefully
was the content of that communication?
that Allied Furnace was interested in moving forward.
Okay. And there had been no contact between you or them since March?
I think I had pinged the rep back and forth a couple of times. I mean, they were pretty clear that they didn't want to. I think my last communication, although we jabbed each other here and there, but I think formally it probably would have been about April.
April was the last time you had communications?
Formal, and then, just have, because I deal with them on a regular basis, so we mentioned it in conversation that it would be a good idea back and forth, but, I don't know if that was necessarily taken to Allied. I think it was more of an ADP thing.
And so is your understanding they weren't relaying that
I
information?
can't say that.
Okay. Did you ask them explicitly to relay that inquiry, or can we still do something?
I don't think that was a good idea. I didn't think that was a good idea. Calling every 15 minutes is probably not a good idea. But they did reach back out again after the district called them.
And so what was the content when they reached back out? They said they were interested in the arrangement that you had discussed in terms of branding it under the ADP label?
Correct.
Okay. And what happened after that email?
We had I brought the email to the district and relayed that to the district, and then we meaning Allied ADP and ourselves, agreed on a conference call. The next week was the earliest Allied was able to have a conference call. We had that conference call where we talked about volumes, which was first order of 5,000 units and then 2,000 units thereafter. They told us about the 6-week lead time. We discussed, they sent me a paint color of the unit to see how it matched up to the ADP coils that I buy. Let's see, they talked about providing pricing. They told us about the 6-week lead time. I think I might have mentioned that a moment ago. And we agreed to reconvene.
Did you have any concerns about the arrangement after that meeting?
I thought it was great.
So you had told them the quantity you needed were 5,000 units initially and then 2,000 units at a later date?
Monthly,
2,000 units monthly?
right. Fill the pipeline and then keep filling.
Okay. And did you agree to a price at that time?
No, they were going to provide a price.
They did not provide pricing?
At that teleconference, no, they were going to provide it thereafter.
Okay. So what was the next communication you had with them?
We had a follow-up conference call where, let me see, wait, hold on just a second. Where we agreed that we were going to talk to, I think he was going to, wait a minute, I don't, did we had a, I can't recall if we had two conference calls or one, because the conversation is kind of melding itself. When we agreed to talk to the master, he said he was going to talk to the master scheduler as well. So I'm kind of thinking, no, wait a minute. Then they also sent me specification sheets on the product, Allied sent.
So at what point in time did they tell you that they could not supply you with more than 1,000 units?
A couple of weeks later.
And so approximately when?
Give it 2 weeks from the conference call. Within 2 weeks of the conference
So
call.
sometime in mid to late August?
I would say that's true.
And was that during a conference call, in person, on,
No, the rep called me up, the ADP rep called me and told me that they were not able to provide but 1,000 units. I think he told it to me in an email.
he sent you an email?
I believe so.
Do you have that email?
I believe so.
Would you be able to produce it?
I think so. I think if, I believe I'm correct, that there was an email that said we can only provide you with 1,000
Okay.
units.
And the reason I'm asking on this is because, so we have a letter, I don't know if you've seen the letter that was submitted to the board this morning, and from Lennox, and on page 2, it states that Howard Industries never indicated it would require more than 1,000 furnaces from Lennox.
Yeah, is this damaging? Would you call this damaging to my conversation?
I'm not going to
here?
answer your questions. Did you,
I believe this is very damaging because it's untrue and it's making people.
It's a comment letter, so we're not taking it as fact right now, but we're just going to, we will likely have questions based on it, and I believe it's public comment, there will be public comment on it later.
This letter is incorrect.
okay, so you disagree with that statement that you never indicated it would require more than,
I wasn't communicating with Lennox. This is a letter from Lennox. I know that they own Allied, but I wasn't dealing with Lennox. I was dealing with Allied. Remember, Lennox does not sell to distributors. Allied does.
so it states, the letter states, in its preliminary discussions with Lennox affiliates, Howard Industries never indicated it would require more than 1,000 furnaces from Lennox.
So this is wrong and damaging.
It is, so, but in terms of the first clause, the discussions with Lennox affiliates, would you agree you were having discussions with Lennox affiliates?
Correct.
Okay. But you disagree with the statement that you never indicated that you would require more than 1,000 furnaces?
That's false.
So you stated, you asked that you, for more than 1,000 furnaces?
That's correct. I stand by what I asked for.
Okay. And your testimony is that they responded, that the ADP rep responded on behalf of Allied, stating they could only provide you with 1,000 furnaces.
Totally for the entire season.
So, and could you tell us what the season is?
Well, I'm speculating that the season is 5 months.
Could
Could be
you,
6,
which months?
but I'm saying 5 months.
October
Well,
to,
the district says that the season begins October, so I'll take that as October, and I'll count forward till about April. So that's 6 months.
okay.
1,000 units for the season. That's the way they came back to me. Season.
So, mid to late August, the ADP rep came back and said, only 1,000 units. What was your response?
I was very unhappy about that because I thought I had something. Going forward. Clearly, very upset. They knew what my needs were, but I thought to myself it'd be better to take something than nothing. So I called back and I told the rep I'll take all 1,000 right now.
And then what happened?
They went silent.
So you called them, do you remember when you called them and said that?
Right after the email I'd say, let me think. It was certainly within a week of the 1,000 unit offer, within that week.
Okay, and then, so that would be very end of August, beginning of September?
I can't swear to
approximately?
an exact timeline.
Okay, and they went silent, you said. Did you follow up?
Oh, many times, continuously, right up to probably yesterday.
When you say continuously, how often were you contacting them?
All the time.
What, daily, hourly,
I can't
weekly?
give you daily, hourly, but anyone would say that something short of being called harassing.
Okay. Would you say at least 3 times a week?
I can't tell you exactly because I would be saying an untruth, but I'm telling you that they will tell you, they meaning ADP, that I was certainly consistent.
Did you email them as well?
I emailed, I texted, and I phone called. We have a
Okay.
very fine relationship.
And they never responded?
Who didn't respond?
ADP.
ADP responded, saying that they didn't hear back from Allied.
So every time you called ADP, they said, we haven't heard back from Allied?
We haven't heard back.
And you never attempted to call Allied directly?
Again, I'm buying this from ADP, who's buying it from their sister company, Allied. That's the tie, that's the connection, that's the brand. That's the
But you didn't
relationship.
try to directly buy from Allied?
That would be meaning that I would take on another, that was the discussion we had a moment ago before the break. That's a brand, and they're not going to sign on to sell me a furnace out of their brand. See, the beauty of this is that I can buy the component.
Did you ask Allied if they'd be willing to sell you their furnaces?
Well, we did have that conversation. I had the Mr. Joe Leonard on the phone from Allied, so I did speak to Allied, and he was perfectly content with selling it through ADP, so why would I need to get it from Allied if he was happy with selling it through ADP as a brand? I am buying it from him, but I'm buying it through ADP. And Allied would be handling for me the tech support, and I'd be getting warranty parts from Allied and all the things that I told you a distributor needs, or I told the district a distributor needs.
But you'd be going through ADP, not Allied.
Because of the ADP brand, ADP controls their own brand.
So is ADP is a brand under Allied's brand?
No, they're a sister company. ADP makes coils that go on top of furnaces, and Allied makes furnaces and coils and other such things as well.
But
So-
you were working through ADP, not through Allied?
Because I wanted the ADP brand.
Okay. But you didn't attempt to have a separate, independent relationship with Allied?
Don't need to. I spoke to the sales manager on the phone of Allied, and he was perfectly happy to work through ADP.
But then
I
once,
think we're going through in circles.
I
I
just
believe all these
wanted
have
to
been
make
asked
sure-
and answered.
okay. If you could just give me a few minutes, I'm just going to check and see if I've got anything I haven't covered.
Yes.
Thank you. I just had one quick question, I believe, one last question. Did Lennox ever give you pricing as part of the, or Allied or ADP as part of the, we can sell you 1,000 units?
They gave me some, yes, they gave me some pricing, not complete pricing, but some model pricing.
Did you agree to the pricing?
I thought it was a little high, but I agreed to take it.
You agreed to it?
I did.
Okay. And I would just request that if during a break, if you do have that email regarding the 1,000 units, if you'd be willing to share it with the board. And with that, I have no further questions.
And the answer to that is,
We have it, but the only copy I have is electronic on my computer. So I wasn't planning on introducing it today, but I got a copy this morning. So I can either send it and we can have copies, or we can at least look at it on the screen right now.
would that be
Okay.
sufficient?
Yeah?
Let's do that then.
Actually, and I found one more page of notes. At some point, you mentioned 4 months, there's just about 4 months. How long are you actually asking? I know that this is just the interim, but overall, how long are you asking for a variance?
I'm asking for the variance for at least as long as, at this point, either I can get a furnace or Ingersoll Rand comes out with theirs, which I believe is somewhere in the April timeframe for the 80% furnaces.
And by the way, we are going past good cause, I believe, with that question, or is
Yes,
there?
you're probably right, sorry. That was my question for later. So I will wait till we have the email.
Okay, so if we can get that email up.
why don't you walk them through the email?
This is an email that I received from Greg Jones, who's the ADP rep, who was dealing with Allied Furnaces. And it says as follows, to myself and to Jeremy, my son. Gentlemen, tried to call. I have heard back from Allied about the capacity allowance they think they have for this season. They have capacity for about 1,000 ULN furnaces this winter. Maybe a little more, but can't be certain. For the low NOx furnaces, there are no limits. Low NOx are the illegal ones, by the way. I'll know Tuesday to what degree that might change in 2020. And then that's enough?
Yeah,
Okay.
that's enough. Okay, thank you.
Oh, and also they talk about the pricing that Mary asked me about. As for pricing, the pricing is where it's going to stick. So there you go.
Okay, no other questions?
No other questions, thank you.
If I could have just a quick redirect, I know we're trying to do
Yes, why don't we
this
do
as quickly
redirect
as possible.
before we have hearing
Yeah.
board member questions?
But sorry, that's vibrating. Jeff, I wanted to, Ms. Reichert left off before your first break, raising an issue about delayed response in August, after following their August meeting, and then again has brought that up in the context of why didn't we reach out, or Howard reach out to other manufacturers, and why was there some delay with the Allied? What was going on in your life in August, and why were you delayed in providing responses to folks during that time frame?
So the reason is because my father was extremely ill. He was in the ICU at Cedars, and he passed away about 31 days ago. So I'm quite confident that that was the reason I was consumed and didn't get back. If there was something that I was supposed to get back to, I missed it, but I didn't remember about that being the case, and I apologize.
And I just wanted to also be clear, there was a lot of testimony that was offered about the, and questions that inferred that you somehow would, wasn't reasonable for you to not have reached out to the other manufacturers other than Lennox earlier than September. And I just want to be clear, because there was a lot of questioning back and forth, make sure the record is clear. Why is the reason, I mean, you've been in this business for a long time. You understand the distributorship model. What is the reason why you, to this day, continue to think that this is not a viable option and you didn't reach out sooner to those other manufacturers?
So manufacturers deal with, distributors carry a particular brand. It involves a very, very strong commitment and relationship with the manufacturers. Very rarely does a brand ever change distributors. It's highly, highly unusual. And it's one for one. You're not going to find typically multiple brands with multiple distributors covering the same territory. So, by example, Lennox is dealer direct, so they sell direct to the contractor. But let's talk about even the Ingersoll Rand model. They have a distributor for American Standard, and they have one for Trane. The Trane distributor puts his heart and soul, as American Standard does, as does the Carrier guy, in his product and his commitment and his financial investment in the brand. And to add additional distribution means that you're adding competition to his model and basically destabilizing his marketing efforts. So it's not a consumer brand that they sell through multiple outlets. It's just not handled that way. It's not like car dealerships on different corners. Furnace air conditioning product is very different. It's handled on a multi-branch operation, whereas a dealership is one dealership in a particular market. We have multiple locations. We're the smallest. You can have a distributor in our market that might have 20, 30 locations handling that brand. They're not going to bring in Little Howard Industries to undermine his 30-branch operation. Thank you.
Okay. I'm going to begin, if you don't mind, with board member questions. My biggest concern, just so I can frame the questions I'm going to ask first, is that we are here on an interim variance for this issue without public notice. So the first questions I want to ask, first of all, I think you mentioned this, but I might have missed it. When was it that Howard Industries hired Mr. Williamson?
Just before the August meeting.
Probably late July.
Matt feels it was late July. I know it was just before the August meeting.
Late July, okay. So As of late July, you were represented by counsel. And stop me if I'm wrong on any of my summary. As of August 30th, we just saw an email, you now knew that you would not have an adequate supply by ADP, an alternate vendor for the furnaces, correct?
Correct.
Okay. Why did you not file for a variance, a regular variance, so that we could have a noticed hearing? Given that all of these amendments and this rule has been going through a public process for years.
Correct.
Okay, so what?
Excellent question. It's because of the meeting that we had in June when staff told us that's not the direction to go in. We want you to go for the order of abatement. That's why I didn't file for a variance. Exactly the reason.
Okay, and then there was, we did have, I would like to hear your take on the testimony from Ms. Zhu. Ms. Zhu read to us from her notes where she specifically wrote in her notes, not just the words variance and who suggested it. In her notes, I'm paraphrasing, I hope I'm not getting it wrong, and tell me if you think I am. But she said Mary, Ms. Reichert, and the words 45 days. Is it your contention that though that is in her notes, that was not discussed during the meeting?
It was discussed, but in a different way. It wasn't discussed as something for us to do. It was something that we shouldn't do. And by the way, she also said, Yan Rong also said that she's not really familiar with the different processes for order of abatement and so on and so forth. So I don't know how copious her notes would be with regards to the differences and the subtleties between an order and a variance. So that's set aside, and I can't debate what she said because she's not here to defend herself. But we discussed it, but only in the variance, but only in the context of stay away from it, not go to it. That's how.
Good.
I'm sorry.
No, I don't
So
want to interrupt.
how we ended that meeting off was so I said to them, them being Phil actually, turned to him and said, so very clearly I understand that if I go for a variance, you will not support it, correct? Yes. So the only path that I have then is the order of abatement, right? Right. And that's the order, that's the direction we went in. And it was all and then I immediately went to find counsel. Manat was actually, there was someone that Howard had suggested, but she was too busy. And then there was another law firm, but the fellow had an illness in the family and couldn't do that. And so finally we found these fine folks at Manat. But that was the difference, thank you. But that was the difference in time between, otherwise we would have maybe gotten here sooner, but not for the fact that we couldn't find counsel quickly. And then we had to work through Mary totally forgetting the entire meeting and said she didn't know what we were
Okay,
talking about.
we're going past my question. Okay. What is the difference between, so let's say in order to have 45 days, well, let me start with a more basic question. You understand that it is the right of a petitioner to request a variance regardless of whether it's opposed by the district, is that correct?
Correct.
Okay, so you had that option at all times, you understand that, especially being represented by counsel, correct?
Correct.
Okay, so it is a choice, whether they oppose it or not, you understand it's always a choice, correct?
Certainly.
Okay. So what is the difference between now, or not even now, September 17th, which is a few weeks ahead of the October 1st deadline, saying, okay, we're still in discussions, because according to your testimony, there were discussions as late as Friday in regard to an order for abatement. So what is the difference between that and when you could have filed for a noticed hearing back mid-August, let's say?
So the reason we went down this path as a responsible business person is because the district presented the order of abatement to us as uncontested. And it was going to cost us money, but it was going to be uncontested, as opposed to this, which is a variance, which was going to be contested and battled, like what we're going through right now. So in the world of contested and uncontested, it's better to go in the world of uncontested, the path of least resistance. That was, I think, an intelligent decision to make, because why stir the pot? And it was presented to me that it was going to be done so peacefully and so kindly, and so all I have to do is say that I'm guilty of having these furnaces, and then everything will be good. That's the way it was presented to us. And then meeting after meeting that we had on the phone kept pushing kicking the can down the road. Well, we just have another question. Well, we just have another question. Well, and you can see how this goes, where it starts leading. Finally, we pulled the plug and said, this is just ridiculous.
But ultimately, you pulled that plug too late to have the public be involved in a hearing, which is what this hearing board and the Brown Act and what we generally want to see, except in an emergency where it cannot be avoided. So it seems to me, and tell me how I'm wrong, that it just came down to the October 1st deadline was approaching. You would have preferred to do it through order for abatement, but whether or not there was public notice and it was done on an emergency or not, that was a choice that you made just for ease.
Well, not a matter of ease. It's very disingenuous that the district kept kicking the can down the road, and leading us to believe that we would have an order of abatement. That's very bad and very wrong. They led us to believe that, and it's not right and it's not ethical to lead someone down that path.
Okay, I see an objection brewing, so.
Yeah, I would just like to object to the characterization and the value judgments based on our character. I think it's outside the scope of the question.
Okay. And I will agree, and you can speak from your perspective, absolutely. But this board does not know the reasons why an order was or was not ultimately agreed to between the parties. And so all I can ask is the questions of why we're here on an interim without notice to the public.
May I add?
Yes, please.
Phil Fine was very, very succinct. He actually couched it in a like, you're doing me a favor because I don't want other people piling on, was the words that he used. I want to keep the pedal to the metal. So you do this order of abatement. It's all good. Stay out of it'll be out of our way. We'll take care of you because we know you're different than everyone else. And there's lots of differences between us and the other distributors. You do that, and we'll take care of you with the order of abatement, and it's all good. So anyone leaving that meeting who has his head screwed on would say, here's a path of travel. It's being strongly suggested for us to take that path of travel, and that's the path of travel we should take. And there was no reason for me to believe.
How long were you in, all told, in discussions with the district with regard to an order for abatement or something other than a variance?
It was first presented at that June meeting, and then council picked up from there.
Okay.
And I
So
wanted to get it done right
let me
away.
ask you, June to September, June to August, you still had no order for abatement. Why did you think it was reasonable to believe that in the next month that you would have it?
It wasn't me so much. The council felt very strongly that the district was working in that direction, and that it's best to go the path of travel of least resistance. If the district is willing to support the order of abatement, then why go through a contested variance request?
Okay, thank you for your answers. I'm going to move on to another element that we need to look at, which is the unreasonable and unavoidable adverse impact, should we not have a hearing and grant a variance today. The question I have is, isn't it true that even if you received a variance to sell or distribute these furnaces that are not compliant or not the ultra-low NOx, that your customers cannot install them? Isn't that also, well, I'm looking at the rule. Isn't the rule on or after, well, this is October 1st. Do I have the right section, which is section E4 of Rule 1111? I think that is the relevant section. Am I correct? Is that the right section? It says, and disregard the date because I know the date has changed and we're going to understand that a little bit down the road. But a person shall not manufacture, supply, sell, offer for sale,
I think you mean C?
I'm sorry. I have really bad eyesight. I should probably have reading glasses. C, as in Charlie. C4, and I'll start again because I am sure everybody was very confused. A person shall not manufacture, supply, sell, offer for sale, or install for use in the South Coast Air Quality Management District these non-compliant furnaces. So even if we were to overcome the hurdles I see, but I don't know how my fellow board members and grant an interim variance for you to sell or distribute, et cetera, your customers are those who are the contractors who do the installation, is that correct?
Yes, they are.
So they essentially can't use it unless they also come and ask for a variance. So when October 1st comes and goes, isn't it true that you can't really sell it because no one could really buy it? Or do you know?
I don't know, but I would assume it would be similar to my previous 1978 variance.
I'm not familiar with the 1978 variant, so I'm not sure what that response it means.
Well, in the 1978 variance, I mean, it's this, I don't know if we're following the spirit or the letter, but at that time, we were permitted to distribute those furnaces, that the few that we had, and that covered the contractor as well. So,
That would not be the case here. And I just want to read the particular finding we need to make, which is a denial of the interim variance will result in the unreasonable and unavoidable adverse impact. So that's why I'm trying to understand. I do believe, but maybe you don't know the answer. But I just wanted to know if you knew the answer, and I believe the answer is they will also need a variance. So I'm not sure if denial of a variance will cause that impact, because no one can buy what cannot be installed, whether we grant a variance today or not. Okay, I'm just looking to see, I had some other questions. Oh, this is the question. You mentioned that there was a difference, and maybe if you could just elucidate this, between ADP and some of the other brands that were mentioned, which included Goodman, gosh, I can't even read my own writing, something with a C, Carrier, thank you. Those are 2 R's. Carrier, JCI, are they not, do they not sell component brands? Is that the difference?
so ADP is a coil manufacturer, coils and air handlers, but not a furnace manufacturer, and they don't manufacture an outdoor unit or a rooftop package unit. They're very, very limited in scope and not viewed as really as a competitor to an equipment manufacturer. They're a component fella. So by branding the furnace with ADP, that would pull it out of being viewed as a major brand competitor.
Okay. And the other ones that were mentioned, the other manufacturers, they don't have a similar either subsidiary, sister company related that is a component, that sells only components
Correct.
in that way? Okay. I'll go back in a moment. I'm going to allow my other board members to ask questions. Thank you for your answers. Anyone else wish? Mr. Balagopalan and then Ms. Verdugo-Peralta.
Mr. Winter, I had a question. You mentioned your supplier is American Standard. You have sole distributorship agreement with them.
Correct.
To your knowledge, did they apply and submit a mitigation fee and get it approved to sell non-compliant units until the September 30th?
Yeah, so our relationship actually is very interesting. Another unique thing, but the district said it's a distinction without a difference. We pay the mitigation fee at the time that we buy the furnace, as opposed to our competitors who pay at the time that they sell it to the contractor. So all of our furnaces in stock are mitigated furnaces. We've paid the mitigation fee to Ingersoll Rand, who in turn forwards it to the district.
Okay, so, all right, so that's why that's why I was confused, because of the date of the compliance. So the mitigation fee period ends September 30th?
Correct.
30th. So you've been paying to Ingersoll Rand, so Ingersoll Rand potentially would have applied to the district for the mitigation plan and paid the fee, and pays the fees?
Correct.
And, okay, so you were paying. So then so any unit you sell, you had to say it's non-compliant with the standard, basically?
You mean after?
No, during that period, you were under the mitigation fee?
Yeah, everything is mitigated that we sell.
So, okay. I think there was a provision in the rule that says that you have to put a sign or give a pamphlet to folks who are buying those units. Do you recall saying that this is not meeting the 14 nanogram
I believe the manufacturers need to put some type of a sticker.
sticker on there? Okay. So now the deadline is fast approaching, and there's no other option to pursue the mitigation fee. There's no more provision to continue with the mitigation fee after September 30th.
Yeah, so it would seem the district would have to send all that money back, right?
Okay. So, when did you find out to backtracking when Ingersoll Rand or American Standard indicated to you that they will not be able to supply compliant beyond this October 1st date?
Correct, so that they wouldn't meet their deadline for October. Just from some notes that I have here, it would seem that it's, I believe, I said it was around March, April timeline. I believe it was March.
March, April, okay. Yeah, you probably mentioned it before, okay. And so March, April, they pretty much, they were aware that they will not probably be able to manufacture units till late. No, you said, till next year, April, right?
Correct.
2020.
Correct.
Units that are compliant.
Correct.
With the rule.
Yes.
So at this time, do they have any units that have been tested and show demonstrating compliance to your knowledge?
Not that I'm aware of.
Not that, okay. So, so March, April timeframe, and so when you knew that, March, April timeframe, so that's when, and you had ongoing discussion with the agency regarding that, whether to get a variance and so forth?
Yes, that was the famous June meeting.
The June meeting, okay. And then you were led to believe, from what we're hearing, that an order of abatement may be pursued?
That was the requested path.
Okay. All right, thank you very much.
Ms. Verdugo-Peralta?
Thank you, Madam Chair. Mr. Winter, I understand your business because I worked for Edison and worked with all of the HVAC contractors on the rebate program. So I understand what you're saying in reference to getting the distributors, that's one segment, one part of it, as well as the distributors, then the manufacturers, the difference there. I understand what you're saying. My question is to you, how much time are you asking for?
We are total or just this variance meeting right now?
Well, let's say both.
So what we were asking for in our order for abatement is we asked that as soon as a model is made available, we would then discontinue, in other words, up to 12 months, but anytime an ultra-low NOx model is made available, we will discontinue the low NOx model of it. So it's an ongoing and continuous wind down. So it's not that I'm asking for a full 12 months, I'm asking for up to, I know that it's going to come sooner than that, way sooner than that.
How do you know
Are
that?
we going beyond good cause, the good cause findings?
I want to understand where they're coming from in reference to why they're even asking for this.
Okay. Okay, do you have the good cause findings in front of you?
I don't, but I know what you're talking about, but what I want to know.
Can we have them in front of us?
In
just so that we
reference to
know?
that is not only the time frame, but I want to know if you are aware of how many other companies are in the same boat as you are.
From what I understand, no one else asked for this, so I would say I'm unique and out there by myself.
And you don't know of any contractors, or I should say manufacturers, of when or if, I shouldn't say if, when they're going to be able to produce the equipment that you are in need of.
Yeah, they told us April, and I would hang my hat on that.
Okay, they meaning,
Ingersoll Rand.
okay. Thank you.
Yes, ma'am.
Board members, if we can make sure that we have the findings we need to make in front of us, please. And they are at the very end of our rules and procedures of the AQMD and tab number 2 in your binders, please. And they're at the very end, the findings for an interim variance. Okay, does anyone else have questions? I have another question, unless others do. Senator, you have questions, go ahead.
I have mixed emotions, but I ask the questions. I take notice of the fact, and I make a statement first.
Can we hold our statements for deliberation unless they frame your question?
Nobody is going to frame my questions henceforth. The question's been asked sometimes your answer was convoluted, but we're trying to get to why is there variance? And you were all over the place sometime. But let me just say that you made it clear that you'd be in violations by October 1st. Is that correct, yes or no?
Yes, sir.
That could a straight answer. That could have been done a long time ago. Why would you be in violation?
I have no product to replace it with.
You have no parts.
Yes, sir.
Is it clear that you stated why you would not have any parts?
My manufacturer doesn't have it.
Do you manufacture these furnaces?
No, sir, we're a distributor.
And you have to buy from someone as a manufacturer, is that correct?
Yes, sir.
Have you had problems having the manufacturer sell you these parts, these furnaces?
They had a problem manufacturing them, yes.
Repeat that again.
They have a problem manufacturing them.
Can we be specific on who they is? We have discussed several different manufacturers, and the particular manufacturer is important as to the question we're talking about. They, I assume from the answer, means Ingersoll Rand, but I don't know who we're talking about. So it
Right,
can be
did
very
you-
specific.
Customarily, ordinarily work with American Standard.
Yes, sir.
Or do they manufacture this type of furnaces, equipment, yes or no?
Their parent company is Ingersoll Rand, so yes, it would be Ingersoll Rand.
Are they able to manufacture those furnaces, yes or no?
Not right now, sir.
Did they ever give you an idea when they would be able to have them on the market?
Around April of 2020.
Around April of 2010. Were they given the same, to your knowledge, the same notice as Linux was given in terms that this would be a requirement come October 1st?
Yes,
But they have not done it yet.
they weren't able to. They had manufacturing considerations, issues, producing a safe product.
Okay. So you have to go elsewhere.
That was the attempt, sir.
That was the purpose for your meeting June 19th with the district?
The purpose was to find a path going forward.
To find a solution to your problem?
Yes,
You felt they were doing that in good faith, yes or no?
I did.
Okay. They offered you, they discussed the variances, yes, but they talked about order of abatement, is that correct?
Yes, sir.
Did they talk about using the word stipulated? One body in the back said yes, you haven't answered yet.
Well, my son went to law school, so he would remember those details. It took me a long time to remember the words order of abatement, so.
Well, given if it's true that the stipulated order of abatement was discussed, you may not be aware, but that might have been in your favor. Are you aware? Or are you not aware?
It was posed to us in a very positive way.
Which means they give you a specific time frame to be in compliance. Could be even up to a year.
That's right.
You dropped the ball.
No, we tried to get it, sir.
Why do you think you didn't get it?
I have no idea. They just kept kicking
All
the
right,
can down the
okay,
road.
Fine. Well, you're not going to be in compliance. And is this Linux? They're manufacturers and they also sell these products.
Yes, they do.
Will you consider them to be your competitor?
Yes, sir.
Or you have other competitors out there competing with you?
Yes, sir. 5 other manufacturers.
You tried to go to some of their suppliers to try and buy this equipment.
We did.
What was your response?
They didn't want to sell to,
Well, they didn't want to or they didn't? Would you tell me?
they didn't wish to add any additional distribution.
Would the answer be correct? They did not sell to you or did not want to sell to you?
They did not.
Well, say it.
Well, I think we've covered all of this. Did you have additional
No,
questions?
it's for my, I'm trying to clarify things that was mumbo jumbo early on. So they refused to sell to you, yes or no?
Yes,
Fine, that means that you in no position to these conditions for good cause helps answer those answers. That's answering some of the questions. Trying to determine what good cause is. Because nobody would sell to you.
that's correct.
And your supplier didn't have to provide for you.
That's correct.
Well, so what do you plan to do? I mean, wait a minute, they talked about a variance, yes or no?
Yes.
At the June 19th meeting.
The June 19th meeting, we came in thinking to talk about a variance, and they told us to think about order for abatement, not
You
variance.
mentioned that early on.
Yes.
The key word I'm asking, they talked about a variance, yes or no?
For me,
What were they talking about? The guy next door?
well, no, because there was a specific brand, specific furnaces that they talked about for everybody to help them with very unique and unusual furnaces that they might be offering a variance to after October 1st. But that was not for me. That was for everybody.
They talked about a variance for everybody.
For just a very specific and unique few pieces, just something very unusual, very specialized stuff.
What does it mean to you?
It wouldn't really help me much, no, sir.
What did it mean to you?
What it meant to me is that the ultra-high efficiency product might get a variance
After October 1st?
after, sometime after.
It has to be after, because
Well, it
their
could-
deadline is October 1st.
That's true.
Yes or no?
Yes.
You got to answer questions directly.
Yes, sir.
Okay, my final comment, a statement, not a comment.
Question, please.
Final comment.
My comment will be, we are rapidly running out of time. We're still in good cause, and we have, by my
understand that.
count, at least two more
I'm
witnesses.
asking questions relative to good cause right now. That's when I got the form right in front of me.
I'm just saying, you said you were going to make a statement. Please, let's not ask the same questions, and let's try to move it quickly.
Okay, my next question then is, why shouldn't we wait to have a public, why you couldn't wait to have a public hearing? You may have answered, but say it again, because I'm going to clarify it now. We're wrapping it up in my mind.
We were instructed to go for the order of abatement, which is the path that we were supposed to follow, and that's what we did. And it did not work out. The district kept kicking the can down the road.
And it would be a hardship in your business if this variance was not granted?
Massive.
Will you realize that if you, even though we're discussing an interim variance today, you're scheduled to have a regular variance, a regular hearing on November the 7th?
God willing.
Pardon?
God willing.
And that will give you, if you're granted today, this the interim, it give you about 43 days from now where you have a hearing.
To survive, yes, sir.
All right. This company, Lennox, if someone offered you 1,000 units, is that correct?
Yes, sir.
How many units can you sell between 9 and in the next 43 days?
Not even 1,000.
Not even 1,000?
No, sir.
Well, then fine. Take what can you take less than 1,000?
They're not willing to sell me the 1,000. They back down.
Well, then would you suspect that your competitors would like to see you out of business based
Yes,
on the
sir.
information you testimony?
Yes, sir.
Thank you.
You restated differently just now. Were you instructed by the district, or were you told by the district that they would oppose a variance?
I think the words are, in my mind, it felt like an instruction. This is what you need to do in order to get what you want.
But before I asked you, you understood, because you were represented by counsel, that it's your choice whether to come for a variance, timely fashion, so that we can notice the public and not just have a hearing without the public present when we could have if you had just filed a month before. Or you understand it was your choice?
Yes, ma'am, but the district didn't want us to notice.
Understood, but the district doesn't have the choice. You have the choice, correct?
Of course, I have the choice.
The other question I had that I had forgotten before was, I understood that you testified that, in your mind, the talks with the district were no longer productive as of September 6th. Was that the date that you gave?
Yes, ma'am.
Why then, if you needed to move forward in an emergency basis with an interim, did you wait until September 17th, which is 11 days later, to file?
Meetings kept continuing on with the district. They kept calling and asking questions, and
To be clear, we actually filed on the 13th.
I have a date stamp of September 17th. at 8:19, maybe, was that over a weekend and you filed and it did not get in on the correct time?
Friday,
Friday,
the 11th, 13th, sorry, thank you.
am I looking at the right?
Yeah, no, you're right, the 17th, it's dates.
It's date stamped as the 17th. Maybe you got it in after 5 o'clock on the Friday?
I don't know, I mean, I have an email, I think at 2:30 with a courtesy copy that went into the clerk, I don't,
Okay, well, we have it as but regardless, Friday was the 13th. I know we're closed on Mondays, so the 17th, I assume, was Tuesday. But why wait that long? Again, why wait that long? By filing an interim, you are telling this board that it is of the utmost importance to move quickly.
It is.
So why wait that long? In our guidelines, we say people who wait a long time, days even, are not considered to be filing with diligence. So I'm wondering
Council,
why.
council felt that it was fruitful, that the conversation with the district was fruitful, and that an uncontested order of abatement was a wiser path to take than a contested variance request.
Okay. Thank you. Mr. Balagopalan?
Mr. Winter, are you the sole distributor for Ingersoll Rand in the South Coast Basin?
No, we're the sole distributor of American Standard.
I understand. So Train is also, Ingersoll Rand sells to Train?
Correct.
And Train, and their distributors for Train?
Correct.
And you only carry American Standard is the only one you deal with, not Train?
Correct.
So are there units, do you know, that the Train is selling from Ingersoll Rand that is meeting the 14 nanogram standard?
Not that they don't have.
So none of the other distributors, then other distributors are in a similar position as you are right now? That
Correct.
as they will not be able to sell these units after October 1st?
Correct.
And, but you're saying you're in a unique position that you may, because you only handle Ingersoll Rand and not others, that you may have to shut down, is that what you're?
That's correct. We wouldn't have a product to sell.
What about your other distributors? Do they have different, how are they going to, do you know?
They have other they're they're a national corporation and they have other branch locations that sell other brands.
Yeah, we heard testimony earlier that Train came to file a product variance and they pulled it out. Have you had any discussion with American Standard trying to do something similar, filing a product variance?
They did it as a manufacturer, so they did it as Ingersoll Rand, not as Train.
Did they file, do you know if they had attempted to file a product
They
variance?
told us they were going to, and they did, and then they pulled it when the district told them they would not support it. They would fight it.
So they left you holding the bag? So it's,
Well, they weren't doing it on my behalf, either way. I wasn't asking them to carry my load, and their guiltiness does not help my situation. They would come here and ask you for a variance as a manufacturer who didn't do what they were supposed to do when they were supposed to do it. That's very different than myself, who's coming here telling you I am, you know, I don't want to use the word victim, but I'm a victim of their bad behavior.
and you're asking to sell, at least during the interim period, non-compliant heaters?
Correct.
Okay, thank you.
Senator?
You mentioned that meeting on June 19th.
Yes.
You mentioned some names like Howard Berman.
Yes.
Is that an attorney?
No, he's a consultant.
Was he ever an attorney?
I'm sorry.
1980.
I know the senator asked you the question, but please, let's. just the
1985.
When?
1985, he said.
He
He said Howard Berman was an attorney in 1985.
Not anymore.
No.
Was he ever a congressman?
No, very cute. Not the same.
All right, thank you.
Okay. Any other questions? So we move this forward. Thank you very much.
Thank you.
For your testimony. Mr. Williamson, you mentioned you have another witness on good cause.
yes.
Okay. Just to put a little perspective on the timing. So we adjourn at 4. And two members of the board have indicated that they may not be able to be here tomorrow, should we not finish today. And I know Tuesday is the date. Anyway, let's try our hardest to.
We're going to go, well, this will be fast.
Thank you very much.
Howard, can you state your name for the record?
Howard Berman,
And what company are you with?
E4 Strategic Solutions.
And what is your representation of Howard Industries involved?
Sorry, H-O-W-A-R-D. H-O-W-A-R-D. Berman, B as in boy, E-R, M as in Mary, A-N. E4, the number 4, Strategic Solutions, Inc. Welcome.
And you took the oath today?
Yes, I did earlier.
Briefly describe your representation of Howard Industries in this matter.
So I believe, I started representing them, I believe, January of 2018. I might have had discussions with them over the holiday season prior to it, and it was at the tail end of the amendments to the rulemaking. And about this situation, we were seeking a sell-through provision at that point. We met with staff after one of the workshops, and then from then on, it was negotiating either a sell-through or after the rule was adopted, how do we move forward?
Okay, and you were present at the June 2019 meeting between District and Howard Industries, correct?
Yes, I was.
Can you
Yes.
describe the discussion at that meeting?
Sure.
Thank you.
Sure, and it was around an hour, 20 minutes, hour and a half, and the purpose was to find the path forward. Dr. Fine was there, and pretty much everyone on the staff that was there, present as well as council. And the first part was spent, of that hour and a half, was spent focused on going over the business model of Howard Industries, that they are a distributor, not a manufacturer, that their long-term relationship, just like it was described today, is with Ingersoll Rand, and that they are in a box. They have no way to move forward. Dr. Fine, after we went through this, he asked some questions, said, we understand you're in a unique situation. We need to figure out a way forward. We then, as was talked about, we talked briefly, not for the rest of the time period, probably like 10, 15 minutes about variance. And as Mr. Winter said, it was regarding a specific technical part of it, not what we're talking about today. And so there was discussion on that. And then when we said, well, what else is there to do? Council suggested or brought up an order of abatement. I asked her at that time to describe to Mr. Winter and his son, excuse me, what that means. That, you know, going into, it's an enforcement action and there are fines involved, but it's a way forward. And so then in recapping, like half hour later, was we can go the variance, which would only give us a little bit because it was only discussed about one item. Dr. Fine said, we would prefer that you not go down that road because we're concerned it would open the floodgates to other people asking a variance. And we will deal with this, if that's how you go, we will deal with this when the rule goes into effect, October. Mr. Winter said, I cannot be out of compliance, period. And that's when the council said, then why don't we go down, excuse me, I'm fighting a cold. Why don't we go down the path of least resistance, and that's the order of abatement. And he said, sounds great. What is there timing involved, this and that? And she said, and when do we need to start? And so at that point, the meeting was breaking up. And before it broke up, I said, let me just recap, and just what I just said. You prefer we not go down the variance because of other issues, not because of us, but because of others. Mr. Winter said he believes you, he thinks you're being he appreciates everybody being in the room together, and so we will go down the order of abatement. I turned to council on our way out and said, when should we start talking about it? And she said August. And that was it. I thought that was where we were going to be going. I then hooked them up through to council, and I just assumed that it was going down the order of abatement because that was the commitment.
So the testimony from the district earlier was that the variance was still an option at the end of the meeting. Is that your takeaway from the meeting?
It was an undesirable option.
Okay. And so the strong preference of the district was that we proceed down the...
Absolutely.
Okay. I don't have any more questions.
Thank you. Ms. Reichart, questions?
Thank you. I believe when you were referring to, we were discussing a variance, was it a group variance that you were, or a product variance?
My impression was, I'm sorry, my impression was that it was a narrow variance,
For,
a specific type of product that was far too technical for my
and do you
understanding.
recall if that was in response to the facility stating that Dr. Fine had made a statement about possibly a very limited variance before the governing board and stationary source committee?
I'm not sure I understand what you're asking.
Did the facility
What facility?
did Howard Industries, you or I'm not sure who, point out that Dr. Fine had referenced the possibility of a limited variance for the 2% of the market that may not be covered as of October 1st in a public meeting? Was that what that discussion was in response to?
No.
That
no,
was not what that
was
was in
not.
response to?
It was brought up as to what options are on the table. When a variance was brought on, it was then directed towards the very limited type that was discussed, not a broad one.
And your recollection was that the district would bring some sort of a variance action?
No.
Okay, so what was your recollection of why the district was doing a variance after October 1st?
I didn't say they were doing a variance. They said they would handle it come October 1st.
So we would handle, you said that,
Well, because they were referring to they were concerned about the floodgates of other manufacturers asking for a variance. And then there was a hint that there were some other issues with, and he didn't, rightfully so, he didn't say what, there were other people that they were concerned about. So for that reason, they, because it gives us the most flexibility, Howard Industries, and it would fit into how they'd like to proceed, obviously saying, as you pointed out, you could do whatever you want, but in Jeffrey's effort to cooperate, which has been the theme throughout the whole rulemaking since last January.
if you could just focus on
Sure.
your
We got
perspective, thank you.
we got to the variance part, talked about it briefly, and then got onto the order of abatement.
So do you remember the reference of a 45-day,
I remember,
period?
I believe you said it's in the rules about variances.
that you'd need to have 45 days advance notice?
I'm just saying, I remember you talking about the rules,
Right.
it's guided by that.
And August, say mid-August, would be 45 days before the compliance deadline, correct?
Okay,
Are you aware of the notice requirements for an order for abatement?
I am, and that's where, when you said August to me, we relied on your good faith.
And order for abatement notice requirements are significantly less than 45 days, correct?
We didn't go into that detail at
Okay,
that
so
meeting.
are you aware of the notice
I
requirements?
know there's a notice requirement, I don't know the number of days.
Okay. So do you recall a suggestion, as testified to by Ms. Zhu, regarding that you should assemble, or that Howard Industries should assemble the data necessary for a variance?
There was a request for data, yes.
Did you remember that in directly related to the variance?
I just remember it was a general request for information.
For information, and data and specifically numbers and numbers of models?
Various parts, yes.
Yes, you do recall that. Okay. And do you recall, as Mr. Winters testified, some reference to an order for abatement being something in private?
I'm not, it was discussed that it was between you, as the lead counsel on this matter, and Howard Industries, and that you would be able to negotiate with them all the aspects of it. There might be, we didn't go into the notice part, but that as far as penalties and all that, that you have control as
And that we'd
district.
present it to the board, and that the board has authority to issue the order as negotiated or make any changes as necessary?
Correct, but we would be there together, joint. There would
Correct.
not be a contested.
Okay. And do you recall the district stating that if we went with a variance, we would likely oppose it?
Yes.
Okay. No further questions.
Board members, questions for Mr. Berman? Senator, did you have questions?
Mr. Berman, you're not a congressman.
I'm not, although I got many phone calls asking, from Harry Reid, of all people.
Were you aware, based on the operation here with variances and Office of Order of Abatement, that the order of abatement could not be issued while you're in compliance?
Correct, and that it would be negotiated beforehand, but that it
I don't
would,
know about the negotiation.
but that would go into effect October
It
1st.
could not be issued
That was not discussed.
while you're in compliance.
I don't believe that came up during the,
That means you cease and desist
right,
until certain conditions are made.
right.
But they could not even, where they couldn't come to that kind of a stipulated agreement until it's filed. It got to be filed after you're not in compliance, and it comes before this board. Was that explained to you?
It was explained that it would go into, that
All right.
things would be worked out ahead of time, I'll put it that way. And then
But I don't
comment
know about that kind of arrangement, but apparently some clarification was made to you, I imagine.
Correct, and there was reliance on that statement, that that would be the way to go.
Well, then you, by filing the interim variance, that suggests that you preempted that suggestion.
I would have to defer about the variance to counsel and client.
Well, you heard the testimony that they felt that by Mr. Winters, that he interpreted some disingenuousness, and therefore they went with the interim variance.
Yes, I heard the testimony, and I know, what I know from my own involvement, let me phrase it that way, that when we left the meeting, we the client, Howard Industry and I, felt that there was an understanding to proceed a certain way, and that's how we would proceed. And then, lo and behold, I get a call shortly after saying, okay, we need a lawyer to get us through this. And then I'm assuming up until last week, when I got told about today's hearing, that everything was done. So, because that was the reliance that was confirmed upon at the end of the meeting.
Based on the discussions henceforth that I've heard as I interpret it, the district, in good faith, sat down with your company to try and work out a solution to the problem. And based on the testimony as I interpret it, they threw you a softball, you didn't swing at it. And I think Lisa Speck would have told you otherwise. Thank you.
I should have asked Mr. Winter this, but maybe you know. I'm not going to go back. Sorry, Mr. Winter. Let me see if Mr. Berman first knows. But we heard about a June meeting, and we heard about an August meeting.
Right.
Were there any other meetings
There were a number of earlier meetings. There was one meeting during the rulemaking.
before the June? I'm saying after the June meeting.
Oh, not that I'm aware of.
Okay.
I was not at the August meeting either.
Were there any discussions as to what an order for abatement might look like, or what the provisions would be? Was there any negotiations?
I am unaware of, except what I heard here this morning.
Okay. I wanted to ask that of Mr. Winter, but if anyone has questions for Mr. Berman before I go back to Mr. Winter, because, any other questions? Okay. Thank you, Mr. Berman.
Thank you.
Mr. Winter, I'm sorry to ping, I don't like to do that, but I want to understand if the wait was for this order for abatement, what indication did you have, other than the June meeting, that this order for abatement was going to move forward? Was there any discussion as to actual terms of the order for abatement?
So there was not a discussion of terms other than it would be handled by Mary. I felt very strong. She came across as being quote-unquote in control of it. Everyone meeting Dr. Fine.
But were there negotiations at all after the June meeting?
Of terms.
Of anything having to do with an order for abatement?
So right after that meeting, even though there was something about, let's get to it in August, I immediately went to get counsel to start on this process immediately. And so
Understood.
went to the first, went to the second, finally Matt immediately called up Mary and started to work on it, or to try to work on it, and this all got us exactly nowhere.
Okay. So you got nowhere. Was there any point between the filing in September or mid-August and the June meeting where you were on track? There was actual discussions moving forward so that you felt comfortable that come October 1st, there would be this order for abatement in place. Was there anything, movement towards that?
Yes, our council was filling out an application. It was a 7-page application. Am I correct? What was that 7-page?
The variance petition.
Oh, I'm sorry.
The question
To
is,
speed things up, the discussions that happened were extensively between Mary and I. I mean, I'm happy to answer questions under oath but we could spend a lot of time
I
trying
guess,
to.
as you can see, my hang-up on this
Yeah.
is, it's an important hang-up.
And again,
because
I'm happy to
we're
answer
talking
questions
about-
under oath. If
We're
that
talking
will-
about a rule, almost a rule exemption that we're asking for, for something that has been in public hearings for a very long time.
Yes.
And so it's very important for me to understand why it was reasonable to believe that you should not be filing for a regular variance 45 days before, knowing that it was 45 days before, so that we could have a noticed hearing, which is such an important issue. And so I wanted to understand what the reasonableness of that was, why it was that, other than the statements that you've stated that you believe were made, and Mr. Berman believed were made in the meeting in June, that you felt that very comfortable not filing for a variance as opposed to this order for abatement.
I can tell you that I spoke to counsel about this many times. I can tell you the counsel, and he's willing to submit himself to questions from the board. So he felt very strongly that the negotiations and the terms and discussions for the order of abatement were moving forward. I asked many times about that, and I asked many times, should we file the application for the variance? And many, many times, we're working on it, it's moving forward, we're working on it, it's moving forward. And the board, sorry, I apologize.
No, go ahead.
And staff knew what we wanted. They knew, because they were the ones who proposed it to us, and at no point did they ever say to us that, you're wasting your time, or we're not going to do this, or you're running out of time. They led me along.
But, okay. Ms. Reichert, and I'm trying to find the date. I can't recall when this was. I believe Ms. Reichert asked the question about this, or maybe mentioned in her opening, about a request for additional information. I believe it was in August. Did you ever provide additional information? I mean, any order for abatement, any conditions, any variance would require specific information.
Right.
Were you asked to provide it? Did you provide?
We provided them with everything except they wanted, which our system is an older system, it's approximately 30 years old, and they asked us for model numbers and quantities sold by location, which we told them that would have to be hand done. In other words, so this model, how many did you sell out of each location, and where did it get sold to, which territory? It was extremely extensive. 2 years of previous history. And we said, we cannot get that to you in a timely fashion. Anything else that they asked us for, we provided. Every single thing that they asked for, we provided,
Okay.
Madam
to the
Chair,
best of my knowledge.
Yes, Senator.
will they be required to provide an agreement on an order of abatement prior to the order of abatement being issued, which cannot be issued until after they're in violation?
First of all, that's not true. We have held hearings and ordered orders for abatement based on a knowledge that there will be a violation when it begins. However, what I'm trying to get at, Senator, is the question of whether or not the circumstances leading to this violation could have been anticipated in sufficient time to provide for public notice of the variance hearing, because we're still on good cause. So my question, I'm not trying to I want to understand what was reasonable about not giving a noticed hearing, why we're not on a noticed hearing. What suddenly came up that required us to have an emergency rather than a regular?
The only reason why I raised the question because the order of abatement is not applicable at this time, at this particular hearing with the interim.
I understand, and the rationale being given for not filing timely for a regular variance so that we could have a noticed hearing is because they were in order for abatement discussions.
Discussion, okay.
So that's why I wanted to ask that question.
We were deceived to believe that the order of abatement was being worked on and and that was the path of travel we were supposed to take. From that June meeting, don't do the variance is what we were told. This is not what we want. We want you to do the order of abatement. We'll work out everything with you and for you. So variance wasn't even on the radar. It was like, we'll do the order of abatement. We'll get you what you want. It's uncontested. I covered all that in the June meeting to the best of my abilities that this was the way to go. They told us this is the way to go, and that's what I did. And the reason this is important, as what you're asking me, is because I never envisioned, even 45 days ago, that I would be in this emergency situation but for the fact that someone didn't do what they said they were going to do. And that's why we're here. I would have gladly filed in its time. And I'm put in this position only because I was assured of certain things, really very specifically, and then it was just kick the can down the road. And finally, we pulled the plug on it.
Okay,
It could have been worse.
thank you. I appreciate your answer. Ms. Verdugo Peralta.
Madam Chair, I have a question. I believe Dr. Fine is in the audience, and since he's been mentioned so many times, is it appropriate for us to be able to ask him a question?
I'd like to have the petitioner present their case for good cause as they would wish to present it, so I don't, unless
The
there's...
district will be calling
And the
Dr.
district,
Fine.
oh, the district, okay, the district will be calling Dr. Fine. Okay. Are there any other questions, though? I didn't mean to call Mr. Winter out, but I did, out of order, but I did not ask those questions. Any other questions? Did you? No. Did you, Mr. Williamson, did you have any other witnesses on good cause?
I mean, I am happy to answer questions and give a statement under oath on the negotiations that occurred between Ms. Reichert and I. If there are no objections from the board, I will just do it, and Ms. Reichert can cross me. That's fine. But it sounds like that is Mr. Winter obviously was not involved in the discussions, and the negotiation was between council. So it sounds like that's a question.
Let's do this. Let's hold that because that's a little non-traditional. Let's hold that, and we'll hear from the district witnesses, and then we can make that decision once we hear their testimony. Does that make sense?
Yeah.
Okay.
I'm sorry, I was not planning on calling Dr. Fine, but because many things have been said regarding what he said in meetings, I've asked him to come down, but I do need a few minutes to talk to him.
Okay. Why don't we then take our break? Yes?
She has another witness, we can hear before Dr. Fine.
Well, she needs to speak to him
I need to
regardless.
speak to him regardless. So I can start another witness first. I can go over the background of the rule with one of my witnesses. I can talk about specific manufacturers and the compliant products that are available, but I still do need to talk to Dr. Fine before I present him. But since this was present on our, kind of what we're talking about now, I thought if you wanted me to go ahead and do him and address those issues, I can.
It's a good time to take a break. And if we did, how much time would you need? So we won't
10
take
minutes.
longer? Okay, so let's, would 20 after be okay?
I'll do my best.
Okay. all
Thank
right.
you.
So let's take a short break as our afternoon break until 20 after. We're off the record.
Do you want to ask them at the outset, or do you want to wait for after Phil?
I think your microphone is on.
Oh, it's,
We're back on the, no, we're not. Now we're back on the record.
okay, thank you. The district.
That was
is-
enough time?
Uh-huh.
That was enough time?
Yes, thank
And
you.
Do I have to swear in?
Yes,
Okay.
please.
Please rise.
Thank you. The district calls Dr. Phil Fine. Could you please state and spell your name for the record?
My name is Philip Fine, Philip, last name Fine, Fine.
And did you take the oath?
Yes, I did.
And what is your position here at the district?
I'm the Deputy Executive Officer. I lead the Planning, Rules, and Area Sources Division.
Thank you. Do you recall the meeting that was held at the district between Howard Industries and the district in June, approximately June 17th, I believe?
Yes, I don't know the exact date, but I remember that initial meeting that I was a part of.
Okay. And at that meeting, do you recall the district making any statements to Howard Industries that they should not file a variance petition?
No, I remember discussions about the pros and cons of variances and orders of abatement.
Can you discuss what you remember about those discussions about variances versus an order for abatement?
Yeah, I think the spirit of the discussion was, again, the pros and cons and the types of findings they would have to make for either, and the types of information that staff would want to see in order to potentially support any of those ways forward.
Okay. And at that meeting, did the district represent that we would certainly support and stipulate to an order for abatement?
No, I do not recall that. Again, we talked a lot about what could be in an order and what those terms could be and what findings, again, staff would want to see in order to support something like that. But it was all, we mentioned many, many times that this discussion was going down that road to gather information, but there was no way supported that, initially supporting that we would support it in the future.
And what do you recall was the ask of Howard Industries during that meeting? What relief were they seeking?
At that time, my understanding was that they did not have a supplier that with a compliant unit, and that as of the deadline on the rule, October 1st, that they would not be able to sell a single product. We talked about the work that they were doing to try to find products and the issues they were having with their lone supplier. But what was discussed was that they would not be able to sell a unit on October 1st because they would not have one.
Okay. And did you express that you felt that it sounds like they potentially had a unique situation in that they would not have any products to sell as of October 1st?
Yes, in that initial meeting, and there were other meetings, in that initial meeting, my impression was that they would not have a compliant product, and that would be unique because of their unique situation with having a single supplier, and that single supplier not being able to provide a compliant unit.
Okay. And then do you recall a meeting on or about August 7th where Howard Industries was there as well as their counsel, as well as staff and yourself on the telephone?
Yes, I participated as
Okay.
I was driving.
And what do you recall about how Howard Industries requested relief changed at that meeting?
At that meeting, I was surprised to hear that kind of the story changed a little bit. It seemed like that they were optimistic they can find compliant units. However, that they had an inventory problem, that they were not going to be able to sell through their non-compliant units, and they were looking for more of relief to sell through compliant units. My reaction was that's not that different from many of the other distributors that are facing the same situation, that have an inventory of non-compliant units that they're not going to be able to sell. So that was, my impression was that was a different story than I got in June when they were not going to have a supplier. So At that point, it seemed like they had become much more like some of the other distributors that did have this sell-through problem. So one of the things we discussed, and I asked them several times on that call, is this the new problem? Is it the new problem is that you have a sell-through problem, you have an inventory problem? And the answer was yes every time I asked that question.
And did you have something to add? I didn't want to. And did you ask for information at that meeting about why they actually were unique and not different from other distributors and suppliers in the market?
Right. So in some sense, we were advising them that if if you were going to make a finding, if you were going to get staff support for any action at the hearing board, then you would have to show us why you were unique, right? And otherwise, every distributor is in a similar situation. So we would go down the road of that next step of discussing what support or no support of an order or a variance might look like, but in no way did we ever commit to supporting it based on the information we had at the time.
And did we, at that meeting, again, tell the facility not to file for a variance?
I don't know, not that I recall.
Okay. And at that meeting, did we say we are definitely supporting and moving forward with the stipulated order for abatement?
No, in fact, it was the opposite. We expressed that we thought the story had changed and that working on an order, the path forward on working on an order, if there was going to be an order, was very different now because it was a different problem.
So as of at least that August 7th meeting, you felt that the district had expressed to the facility, to Howard Industries, that the district was skeptical, that they were in a unique position, and that we didn't think, or that we needed a lot more information before we'd be able to move forward with an OA.
I'm sorry, I'm just going to object because I've listened to 4 or 5 very long leading questions. She's testifying for the witness at this point, so just.
Thank you. Sustained, please don't lead the witness.
So now I've completely forgotten my question. See, I've got at that meeting, was it the districts? Did the district express, or did anything that you recall actually expressing to Howard Industries that? Or what did you express to them about what would be necessary for us to move forward with an order for abatement? That's my question.
Yes, so again, to me, it sounded like the story had changed, and we expressed skepticism in moving forward with an order. And what we said at the end of the call was that in order to make any case that we could even potentially support an order would be you would have to really show your unique circumstances. Because again, a lot of the other distributors had expressed the same concerns about sell-through. During the rulemaking, we had discussed this multiple times with the governing board about sell-through, and as a policy decision, the governing board had decided they weren't going to allow sell-through, or at least not beyond the mitigation fee period. So we expressed that, and we said, look, you need to make that case if we're going to support it, but we never said we would support it.
Did you feel like at any point you represented to Howard Industries that we were definitely going forward with an order for abatement?
No.
And
not in the 3 meetings I was in, no.
Okay. And did you feel like at any point you gave the impression, or at any meeting you were at, that somebody from the district gave the impression that they should not file a variance petition?
No, not in the meetings that I was in.
Okay. And then there was a third meeting that you attended, is that correct?
That was, I believe, last week.
Okay. And what do you recall about the information that was given by Howard Industries about the relief sought at that meeting?
Yeah, so it seemed like the story had changed back to the initial meeting in June, where now they were claiming that they did not have a compliant product. I know they had tried to find a supplier, and they had been working with their own supplier, and they talked a lot about that effort, but at that third meeting, it seemed like it was more like the first meeting, where it wasn't a sell-through problem, it wasn't an inventory problem, it was having a compliant unit problem.
Okay. So in your opinion, it seemed like they had flip-flopped several times in what their ask was?
Yes.
Okay. In terms of, you weren't here for some of the testimony previously?
I'm sorry, Senator.
Can you clarify flip-flop?
I'm sorry. How would you describe the position of Howard Industries in terms of their relief sought from meeting to meeting across the 3 meetings that you attended?
Right. So the first meeting, the impression was on October 1st, they would not have a compliant unit to sell, thus affecting their business significantly. The second meeting that I took by phone, that was no longer the case. They were going to have compliant units on October 1st. They just had a major inventory problem with sell-through. The third meeting last week, they told us that things had changed. They had tried to get compliant units. Now they cannot get compliant units. And now they need relief to be able to sell non-compliant units beyond October 1st.
In the period of time between the August 7th meeting and then when we received the letter from, that identified some of the responses to questions that were in the August 7th meeting, do you recall that letter being sent in early September?
Honestly, I don't recall.
You don't. During that period of time, though, in August, was the district working on anything with regard to the order for abatement, or were they just waiting to hear back from Howard Industries?
To be honest, I was not involved in a lot of those discussions. I know some of my staff might have been working with the legal office on some back and forth on information, but I really do not recall the specifics of what was being worked on by whom.
Okay. I just want to make sure that this is clear. So do you feel that the district in any way misled Howard Industries in telling them that we would certainly do?
I'm sorry, this is another very leading question.
Okay.
I'm not sure if she even said the question, but let's hear the question first, and then we can determine whether it's leading.
Do you feel like the district in any way misled Howard Industries to believe that they should not file a variance petition because we would certainly be pursuing a stipulated order for abatement?
Same objection, it's a leading question.
And how would it not be leading? I'm trying to understand how it is better framed. There is an issue. The question is, in his being part of these meetings, whether in his experience or opinion, they were misled. So,
Madam Chair,
yes.
she has to reframe the question to get the answer she wants, and he's right in my view.
Okay, well, I'm ruling on this, but I don't believe it's leading. However, is there a way you can be more general and ask the question in pieces? I don't know how else to ask the question, and I might ask the question as well.
Opinion was blah, 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 blah.
But that is how you need to ask the question. Leading question would be, so you believe this, right?
Right, yes.
That is a leading question. Asking,
But all she's doing, I mean, the only change is, she's saying, did you, rather did, right? Your suggestion is that did you would be leading, and she's just framing it more passively than that. She asked the question, it's fine, but again, she has been leading the witness through most of the testimony.
if you can think of a different way to ask it. I mean, the question, did you, in your mind, you can just say as to the actions that the district would take. Do you believe the district was misleading?
As to the actions that the district took during this negotiation, or this discussion, ongoing discussion with Howard Industries, do you believe that the district was misleading?
In my opinion, there was no misleading. Again, options were discussed, and pros and cons of options were discussed, and maybe in that first meeting, we were going to go down certain roads, but then the story changed. So in my view, we were very clear the whole time that there was no promise of support for any particular pathway, and I do remember us caveating our language and saying that over and over and over again throughout that first meeting, that we're willing to go down the path of discussing the findings and discussing the facts and discussing what it could look like, but we never said that we would support it that end product, whatever it was.
Thank you. No further questions.
Mr. Williamson, you may ask your question.
Okay, Dr. Fine, we'll pick up where you just left off. And you had expressed that at none of the meetings did the district promise support for a particular path. Is that correct?
None of the meetings I was in, that's correct.
Okay. Well, the testimony today isn't that we were promised support. The testimony today is that we were asked by the district, or that the district expressed a preference to go down one path or the other. So I will go back to the June meeting, and when I note that Ms. Reichert used that same promise of support language at the June meeting. At the June meeting, did the district express a preference for how Howard Industries would proceed between a order for abatement versus a variance petition such as what we filed today?
I mean, I would say preference isn't the right word. I think when we discussed pros and cons and we're having an open discussion, it did seem like an order might be a good pathway, but I don't think we expressed as staff a preference.
Okay, and why did you think that an order abatement was a better pathway?
Again, I'm not a lawyer, but my understanding of the findings that are needed for a variance and the types of things that could be done under an order, it seemed like the situation was more conducive to an order.
Okay, and I reached out personally to Mrs. Reichert when I became involved in this matter for the first time. She said she talked to you about the June meeting. Do you recall that discussion?
When did she talk to me about the June meeting?
It was probably late July, early August.
I don't remember.
When Ms. Reichert's response to me about the meeting was she couldn't remember anything about the early meeting, she was going to go talk to you. Does that ring a bell about a discussion you had with Ms. Reichert about the June meeting and what was expressed at that meeting?
I mean, there had been some very brief discussions in between these three other meetings, between me and staff and me and Ms. Reichert, but again, I don't have a strong collection. They were like, it could be like 20, 30-second questions and answers. I don't remember when they are. One thing I do remember is after the August meeting that I participated by phone, we did talk about, did everyone else just hear what I heard, which is the story completely changed, and everyone on staff agreed with me that the story had changed.
Okay, so when Ms. Reichert represented to me after I reached out to her for the first time that she had talked to you and that she could confirm that the district's preferred path forward was to pursue an abatement order, was that
Objection, he's testifying now.
I'm asking a question.
Can you restate that question? I'm sorry, because
Yeah. When Ms. Reichert said she had talked to you and could confirm that the district's preferred path forward.
Again, he's testifying as to what
that's not an evidence.
Sure.
Okay.
But I'm going to ask a question.
But you're
to
putting that
confirm.
into the record, and
My
you're,
question
as a
isn't
question.
My question isn't evidence.
But you're assuming in your question,
Okay.
facts not in evidence.
If Ms. Reichert had.
I'll direct the witness not
I'll
to.
move on.
It's very different. It's very different. I heard tit for tat down at the end. This is very different. We're not putting evidence into the record, either in questions or not.
I will move on because I think that this is something that's going to probably have to come in through my testimony anyway. This is an awkward way of doing it. Let me see. I also wanted to revisit the August meeting where you had testified that there was no stated preference on path forward by the district at that meeting. Were you present for the entire meeting? Appreciate I said present on the phone for the entire meeting.
Honestly, I'm trying to remember back whether I joined midstream or I think I was there for most of it, but it's possible I came in a little late or maybe I lost connection at one point in the call due to bad reception.
Maybe I think going through a tunnel, I think is what you said.
That's true. I did go through a tunnel, so I can't speak to that tunnel
so you
period.
weren't there for the entire meeting, correct?
I think I was off. Now that you remind me, I did go through a tunnel. I might have had to call back. Might have been 3 or 4 minutes. I was not on the call.
So you didn't hear the entire contents of the discussion at the August meeting, correct?
I guess that's true, yes.
Okay. And then another point that you've raised is that you guys at the August meeting had asked us to make the case about why we were different, correct?
I don't think we asked you to do it. We said that if you were going to go down certain pathways, that one of the things that you would have to do to convince staff to support that pathway was to show why you were unique, because staff was not going to support a variance for the entire industry.
Okay, and then we submitted a letter that articulated the reasons why we were different from the other folks in the industry, correct?
I do remember a letter. I don't remember the contents in detail.
Are you-
Counsel, that letter is, you had marked it as confidential settlement negotiations. Do you want to bring that letter in?
I'm not going to talk about the
Okay,
content
I
of
just
the
wanted
letter.
to make sure before you went further.
And are you aware of the district ever objecting or otherwise responding to that letter and claiming that we weren't in fact different from others in the industry?
I don't remember. I'm not aware if we responded or not.
Okay, no more questions.
Board members' questions. Mr. Balagopalan.
Mr. Fine, you mentioned on the August teleconference that the story completely changed. Do you know why the story completely changed?
I mean, that's probably a better question for the owners of the company. What I was led to believe in subsequent discussions is that at that time they had found a supply chain that they can sell. But it was very different than the first meeting where they said they would have no supply.
And were you aware that subsequently they testified earlier that I think staff had provided the name of that, I think it's ADP or Allied, and they were confident. I think they were optimistic at that time that they found ADP as a supplier for the coils, and then it subsequently fell through.
Yeah, that's possible. I don't, when I was on that call, I subsequently know that from our meeting that we had last week. But on that call, I didn't know the details. I definitely I posed the question to them, like, this is now an inventory problem, not a supply problem, and they answered that affirmatively multiple times.
So knowing what you know now, would you go back to what their problem is now? Is not it's probably both, the supply and inventory problem.
Yeah, so last week we did hear it's now a supply problem, which is a problem. But whether, we still have not expressed support or not support for any abatement order that could happen in the future.
And the rule provided 2 years basically of non-compliance by paying mitigation fee?
Yes. It changed multiple times and multiple rule amendments. But I think the last amendment allowed another close to 18 months from the previous compliance date.
And so they paid a fee in lieu of meeting the 40 nanogram standard.
If you only met the 40 standard, then yes, you'd pay a mitigation fee.
Okay, thank you.
Ms. Verdugo-Peralta.
Thank you, Madam Chair. Dr. Fine, to your knowledge, has any other company come to the district asking for similar relief in this capacity regarding this rule?
During rulemaking, yes, there was a lot of requests for sell-through periods, and there was a lot of doubts expressed by the manufacturers that they would have compliant products. That turned out not to be true. Most of them do have compliant products now. So I remember during rulemaking, there were a lot of requests and public testimony about adding sell-through periods, which the board decided not to do. Since that time, I think there have been, I'm not the best one to ask, but there have been at least one, maybe more manufacturers also talking about sell-through periods, but nothing formal that I'm aware of.
And nothing presently other than Howard Industries?
And you do recall the product variance that was filed and taken off calendar by?
Yes, I was made aware of that maybe 2 or 3 weeks ago, and then it was taken off.
Thank you.
Senator, did you have a question? Oh, did Dr. Bernstein?
The letter's been referred to by Howard, that is not in evidence, but it mentioned, and some terms and conditions of the letter was mentioned, which led me to believe that they were asking for something because they were uniquely different from the other suppliers. Did you find that to be the case?
In the first meeting, when we were discussing the order, it did seem like there were some unique conditions because they were tied into one supplier. At that time, I believe they had I was led to believe they had a contractual obligation with that supplier not to sell any other manufacturer's products, which I later found out that there was an out in that contract, at least maybe a newer contract. At the time, it did seem unique. They were tied to one manufacturer. That manufacturer, at the time, I was led to believe would not have compliant products. That did seem like a unique situation to me at that first meeting.
And they released them to do what? From the terms and conditions of the contract with that supplier. They released them to buy from other sources if they could.
I don't know the details, but in the meeting I had last week, that's when I learned that there was a clause in their most recent annual contract that would allow them to go to other suppliers.
They were released from the original contract. It's that simple yes or no answer.
Well, I'm not familiar with the contract, but they told me that they have the ability, and maybe even a little before that, I had heard through the discussions secondhand that they had had the ability to buy from other manufacturers, including Lennox and others, and that they were looking.
So that made them uniquely different from the other suppliers? What made them uniquely different from other suppliers that they're here asking for variance and other suppliers are not, although they're similarly situated?
Well, they're less unique if they can buy from every supplier. At the first meeting, they were unique because I thought they were tied in to one supplier.
Thank you.
Are you the appropriate witness? I did have a question with regard to the rule and whether if we were to have good cause to have make a decision today to grant an interim variance to allow Howard to sell, whether they would have any purchasers under the rule or whether they would not be allowed to use it.
Could you specify your question regarding the installation, because he wasn't here for that?
The question is, under my reading, and I just wanted to have a district person, staff member, explain to me what position we would be in after an interim variance, if we were to grant one. Under Rule 111C, as in Charlie.
1111.
1111C, as in Charlie, 4, which I believe is the operative condition or portion of the rule, subsection of the rule, that a person shall not manufacture, supply, sell, offer for sale, or install non-compliant. So if we were to give a variance to allow distribution and/or sale, would the rule preclude anyone to purchase or use it to install? That's the question.
I
Or
feel
would
like
a variance take care of that? Because I know legally that wouldn't, and then another variance. But am I understanding the rule right?
I believe so, yeah. It does prohibit all those activities, but it's a kind of a legal question of how far this variance could go, right?
Right, but I know how
Yeah.
far the variance can go. However, my question is,
No, the
does
intent,
the rule goes that far?
the rule does go that far.
Okay, that was the only question. Thank you very much. And then the other question, I think the senator asked a similar question, whether anyone else was asking for a variance or an exemption. But you mentioned that you believed at one point they were no longer unique because they still had the sell-through issue that I don't remember if you said so many other or all other have distributors have that. Is anyone else receiving an exemption of any kind for sell-through of their existing inventory?
No, not that I'm aware of.
Okay, thank you. Mr. Balagopalan.
Mr. Fine, so when they paid the mitigation fee, it sort of encompassed everybody, right? The installer and contractor, they all were exempt from the rule if they had
If the mitigation
fee was paid, so it covered during everybody down the line, essentially.
Yes.
Okay. One other question, do you have knowledge now where Ingersoll Rand is as far as coming up with compliant unit?
What I've heard through our previous meeting last week is that, yes, they will. Whether it meets it's right on October 1st or not, it might be a little bit after, and it may be only a couple units, but that came from what I heard from Howard Industries.
Okay, thank you.
Any other questions for Dr. Fine? Okay, thank you very much, Dr. Fine. Ms. Reichart, you have other witnesses for good cause.
Yes, so we were discussing about whether the board needs kind of the background of the rule and to understand how it operates and the mitigation fee option, not an exhaustive background, just because there were several amendments and mitigation fee periods and then amended it again, and there seemed to be some questions about that. So I'm trying to find out if you need that information for good cause or not.
I think the only part of that we would need is so that we specifically understand why they are in non-compliance as of October 1st, since when you read the rule, those dates are not there.
Okay, so I'm going to call Michael Kraus just to testify to kind of some limited aspects about the rule and the compliance thereof. Can you please state and spell your name for the record?
Sure. Good afternoon. My name is Michael, M-I-C-H-A-E-L, Kraus, K-R-A-U-S-E.
Thank you. Can you just take us through a brief history of kind of the amendments that have happened so that we can explain how those deadlines have changed and how the mitigation fee option, and I'm just going to let him just talk about, just a brief overview as opposed to guiding him
I don't think that's what
through.
the chair was asking for. I think they just want to understand the,
But the dates, you want to know how the dates, because the dates are different.
I do want to know the dates and how we should read this rule so that we understand what the operative date is. And also, Mr. Kraus, I'm sorry, did you ask
I
me to
know.
take the oath
I did
today?
take the oath.
And what's your position? I'm sorry, I didn't ask you that too.
No problem. I'm a planning and rules manager here at South Coast.
So can you just discuss the operative deadline and how that relates with the mitigation fee period?
Sure, not a problem. So, and I really feel like you guys are really up and already educated on this, but real quickly, the rule was established, adopted in 1978. We've been regulating furnaces here in South Coast for over 40 years now. In 2009, we then required those furnaces to be at 40, don't worry about the units, nanograms per joule, but we measured that out, and that's a nitrogen oxide emission limit. We're quite concerned about nitrogen oxides. It's a driver in our ozone concerns here in the region. Okay, so in 2009, we required facilities, and we gave them a deadline of 5 years to comply with a 14, so going from a 40 down to 14 nanograms per joule. And so they had this time frame, and that would mean that in 2014, those facilities would need to come into compliance. However, there were concerns about facilities being into compliance. So they approached us, and we went ahead and did an amendment in the rule of that year in 2014. And we went ahead and extended those compliance dates. In addition, because there was a concern about, I think someone used the phrase kicking the can down the road, that this might turn out to be the case. So we wanted to come up with basically a way to sort of disincentivize manufacturers from doing just that, okay? And one way to do that is to impose a mitigation fee. So we imposed a mitigation fee basically saying if a manufacturer is not able to comply with the 14, then pay us a mitigation fee, and we as an agency will use those funds for emission reduction programs out there and still try to achieve the nitrogen oxide emissions that the rule had originally intended to achieve. Okay, so that happened in 2014. I want to highlight to you Table 1 of the rule. Does everyone have a copy?
We should, yes.
Okay. So Table 1 is what was created back in 2014. That's on page 3. And what we did was broke out the different types of equipment categories under there. So we don't need to get into the weeds on that, but there was a series of compliance dates. The one compliant date I want to highlight to you is the second one at 2015. What you're looking at right now, when we amended the rule, we actually moved that to 2015. That was originally 2014, okay, just for historical sake. Now, we move on to a couple of years later, we did a 3-year mitigation fee. So basically, all of these dates, whatever they were, we said we're going to allow you 3 years to pay into this mitigation, but at some point, once again, not to kick the can down the road, but to have that final date. So what we did was we extended this date. Again, I'll just highlight to the second line, 2015. You had a 3-year mitigation, so 3 years these manufacturers. It's way lead-in time. They were paying this sort of money to help you bridge that gap, that time that you need to get that equipment, in production. And so that would lead us now to 2018. Once again, manufacturers came, I'm sorry, I'll real be quick.
Just real quick,
Sure.
where do we see in the rule this mitigation fee extension?
That is actually on the next page on table 2. Then you'll see that. However, initially, the wording you'll see under the table 1, that's where we list out those values. Okay, there's a certain amount that's paid per unit from the manufacturer.
Thank you.
Yeah. And they do that after the fact. So they actually go and sell the units and then they pay those mitigation fees. It's not something they would do necessarily up front. Okay, so in 2018 then, once again, the manufacturers were concerned. Once again, the staff reacted. We provided an additional year, but this time around, we constructed table 2, which you'll find on page 4. And again, not to complicate things, but we in planning love to complicate things when we can. We decided to sort of create a matrix and a tiered approach. So basically, again, continue to incentivizing manufacturers to get there, okay? And again, assuming that if they've got a more burdensome mitigation fee to pay, that's more the drive to get up to speed, okay? Ultimately, as you'll see on table 2, you'll see that deadline that everyone's been talking about, September 30th, 2019, ergo as of October 1st, to be in compliance, and that's where you're seeing the date that we've been discussing today. There are some little different dates. It has to deal with some different furnaces, but I don't think they're of concern to us today.
That's great. And this table that has all these different tiers and the phased-in compliance deadline, that was all based on feedback from stakeholders?
Absolutely.
And in order to...
Full public process.
Thank you. And the increased mitigation fee also meant to fund a rebate program to incentivize the purchase of compliant furnaces,
We did launch a rebate program that was for a certain amount of money for consumers and contractors. Just recently this year, the board recommended that we go ahead and just keep trying, keep getting the word out there. So we extended that rebate program to builders. That's already in effect as of now.
Okay, so just quickly, just because these are a couple of things that I think are important that we want to touch on. The board clearly heard plenty of public testimony at stationary source and at governing board meetings. There was a lot of testimony by manufacturers asking to allow a sell-through past this September 30th, 2019 deadline. Is that correct?
That's correct. And during the 2018 amendment, one of the directives the board had was to come back, and I think this was already noted before in somebody's comments, maybe your opening statements. Anyway, to come back to our stationary source committee and report on the implementation update. We did just that back in February. We did also talk about a potential sell-through provision. The committee was pretty clear that they would not support the sell-through provision for the fact is that we still had 8 months till this compliant date was going to come up. This was back in February. Compliant date was still October 1st. So their recommendation was, this is the sell-through provision time. We have lots of certified and lots of commercialized products out there. It's time to make that aware, time to take action. And so what we did was we went and turned around and we sent out an immediate compliance advisory, alerting people of, reminding them of the rule, giving them phone numbers, reminding them of the rebate program, the extension of the rebate program. Come and talk to us if there's issues. We were also instructed to go talk to the manufacturers, the 7 major manufacturers of the furnaces, on a monthly basis, which is what we've been doing, and getting progress reports from them along the way.
Would you say the governing board has given us a clear directive that they want this September 30th, 2019 deadline to stand?
Yes, there was not only just a clear directive from the committee, but procedurally what happens is the minutes from that committee go to the full board, which happened in March. And there was even testifying from some of the manufacturers about that, and the board made no comment, and therefore sending the message of...
In your opinion, has the district done a diligent job at informing and publicizing and ensuring that the word gets out about this upcoming deadline?
Excuse me, Senator.
Madam Chair, these dates are sounding good, but what do they mean in terms of the drop dead date, October 1st? There's
Okay,
nothing else for me. Only thing that I don't want to know about is October 1st.
Okay.
Thank you,
Drop
Senator.
dead date.
sure. Can I
let's
just
get to
finish
that.
my question, and then I'll make sure that that gets answered? Would you say that the district has done all it can to publicize and ensure that everybody is well-informed about this upcoming deadline?
I believe so, and so in reaction to some of the outreach, like we hear from a lot of the people's input on that, we've reacted immediately to that. For example, it's very
We're happy to stipulate to the effectiveness of the outreach.
Thank you. And then, just so it's clear, the final deadline for non-condensing and condensing furnaces to continue to be able to sell them and install them in the district while paying a mitigation fee, the final date that anybody can do that is September 30th, 2019. Is that correct?
That is correct.
So trying to sell or install or distribute a furnace as of October 1st would be a violation of the rule.
That is correct.
And we see that on table 2.
Yes.
Okay.
Or table 2? Is that the right table?
Yes.
And
table two is
where
legit.
do the appropriate furnaces fall on table 2? Just so we're very clear with regard to BTU, I suppose. They're
Right, so there's,
categorized,
right, so there's different sizes of those, and then again, they're broken up into different types of.
Oh, they're all
furnaces.
September 30th, 2019?
All of the sizes of the right,
Yeah,
condensing.
there are
and
2 other types called weatherized, or basically outdoors or mobile homes, and there are
The
different.
ones that, everything everything says September 30th.
Majority of those that
Okay.
are sold here, yes.
Thank you.
Okay, that's all the questions I have. As best I did, I tried to speed through that.
Thank you. Mr. Williamson, do you have questions for Mr. Kraus?
No.
Board members, Ms. Verdugo Peralta.
I have a question for Howard Industries. Can I ask that question or not?
Can we finish with the district witnesses and
Okay.
then we can come back if you need to? Any other questions for Mr. Kraus? Mr. Balagopalan?
And so, Mr. Kraus, so
Yes.
you're aware that Howard Industries has been paying the mitigation fee to, I think it's to, not Allied, I'm sorry, to Ingersoll Rand. Is that how they're doing that?
It's the manufacturers would pay.
So that'll be Ingersoll Rand?
That's
So
correct.
each time they sell they've been paying the mitigation fee?
That's as far as I'm aware, yes.
My next witness could answer maybe a little bit more about the mitigation fee if you do have
No,
questions.
that's,
Okay.
I think knowing that they paid the mitigation, that clears up the deadline, the rule
Yeah,
deadline.
they're in compliance right now.
Yeah.
Okay, any other questions for Mr. Kraus? Thank you, Mr. Kraus.
Thank you.
Okay, Ms. Reichart, your next witness on
Thank you.
good cause.
The district calls Sean Wang. Mr. Wang, can you please state and spell your name for the record?
Yeah, Sean Wang, SHAWN,
And did you take the oath today?
Yes.
And what is your position here at the district?
I'm AQ specialist. I am assisting with Rule 1111.
Okay, thank you. So I'm going to try to just touch on some important points here. First of all, just because we were talking about the mitigation fee, if a manufacturer has paid the mitigation fee and it turns out those units are not sold or distributed or installed in the district, what would happen to those mitigation fees?
It would be refunded.
Thank you. How many compliant units, do I have your paper? Do you have another paper? I have your paper. I'm so sorry. I'm stealing his. Sorry. How many compliant units are currently available on the market right now?
212.
Okay. And how many manufacturers are those from?
I think 5 out of the 7.
Okay, so 5 out of the 7 manufacturers currently have compliant units. Do you have some deadlines or some dates about kind of where compliant units were? So for example, when we presented to the Stationary Source Committee in February, how many, do you have that date for compliant units?
I have, as of the rule amendment in 2018, which is March 2nd, as of January 2019, August 2019, and September 2019.
Can you kind of take us through those numbers quickly of how
Yes.
they've grown?
As of March 2nd, 2018, there was a total of 22 certified units and 12 commercialized units. Commercialized means they're available for sale. As of January 2019, there are 176 certified units with 112 commercialized units. As of August 2019, there are 216 certified models with 173 commercialized models. And as of September 2019, as of today, there's 228 certified models with 212 commercialized models.
And all of these models are listed and available for anyone to look up on the Clean Air Furnace Rebate Program website, correct?
Correct.
And can you explain kind of how there's some overlap in these models, if there's some, where it's the same unit that may be marketed under different brand names and things like that?
Yes, there are manufacturers that sell units under multiple brands, and those brands share model numbers. They're marketed differently.
Okay. Do you know the number of unique furnaces that are currently commercialized by chance?
No, I do not.
Okay. You've heard testimony about that no one else is in this position. Have you received feedback from manufacturers or distributors, kind of about their status and why no one else has come in and sought relief from the rule requirements?
Yes, we have been in contact with all the manufacturers, and we've been told that distributors from other manufacturers have started to ratchet down inventory in anticipation of the October 1st compliance date.
And they haven't told you that any of the manufacturers are looking are going to have stranded inventory or leftover stock that they're going to be scrambling to come in and ask for relief?
Not that I'm aware of.
Okay. And how often are you in conversations with the regulated community manufacturers, distributors?
Manufacturers, we try to have monthly meetings. However, some of the meetings might be a little bit more than a month apart.
Okay. So you're in frequent communication, though, to get status updates from each of the manufacturers?
Correct.
And you, when Howard Industries has asked you for information regarding available models, about contact information for any manufacturers, have you promptly provided that information to them?
Yes, I have.
Okay. And what is to the extent you can, and I understand that some of this information is confidential business information, but what info do you have or can you testify to regarding Ingersoll Rand's plans for launching compliant furnaces? If you can. I don't know how much information you can share.
I'm not sure which is confidential. And
That's
which is
okay.
not.
Do they have any certifications that they've submitted or that have been issued yet?
Yes, we have received, we have 2 furnaces under certification for Ingersoll Rand.
So they've been certified, but they are yet to be commercialized?
Correct.
Okay. And we have no information otherwise that we can share about when those might be ready for the market, correct?
Correct, no
Okay,
other information.
that's fine. Could you explain just briefly why you can't testify about that?
We're not sure whether or not it's confidential information.
So have the manufacturers expressed to you that we should not make public certain information, and that's a condition on which they have agreed to discuss these specifics with us? Is that a confusing question? I'm sorry.
Yeah, can you-
Have the manufacturers, I'm sorry, have the manufacturers asked you to keep information confidential?
Certain manufacturers have informed me that certain information is confidential. I do not know about this particular case, and I'm just playing it safe.
That's fine.
They can't talk about it at all, and yet they give you total numbers of those that have been certified, which suggests if they've been certified for commercial use, then they're available. But now you can't talk about it because it's confidential.
Let me just clarify. So the certifications, those are public records, correct?
Correct, the certifications are public records.
And then there is a period of time between when we certify them to say that they meet the 14 nanograms per joule limit and when the testing is complete and the units are ready to be sold in the market. Is that correct?
Can you?
Sorry. So what is the certification certifying?
The certification means that they passed the proper testing to certify that they meet the emission limit. It does not mean that they are currently available for sale.
And how much time can pass, and if there's a range, you can express that range, between certification and when those units are available for sale?
It really depends. Some manufacturers will have it available to go the day the certification comes in, whereas others might need additional time.
Okay. Could we go off the record for just a moment?
We're off the record. We're on the record while counsel is talking with her witness. I've neglected now twice to say that we will not be having our general meeting today, given the timing and given that I don't know that we'll finish this hearing today either. And that will be continued to, I had a date, next Thursday, which is October 3rd, I believe. So we are going to continue our general meeting to then. Okay.
Okay, I have no further questions for this witness.
Okay. Mr. Williamson, questions?
Mr. Wing, you had testified about the number of models that are currently available certified in the district as being 228, correct?
Can you repeat the question?
You testified that the total, currently, September 2019, the total number of certified models available in the district, or certified models in the district is 228, correct?
Correct.
Okay, but you also had said you don't know the number of unique models that are within that number.
We can find out, but I don't have the number with me today.
And so what we're talking about with unique models, we're talking about the fact that a particular manufacturer may have 10, 15 different brands and market the exact same furnace with each of those brands, but give it a unique model number, right?
I think 10, 15 is a little exaggerated, maybe between 4 or 5.
How many scare your head? Okay, well, just 10, let's say 10, but again, the concept is that that doesn't represent, that 228 model doesn't represent unique models, correct?
Correct. They're not all unique models.
Do you know what the number of the largest number of unique models there are by any manufacturer outside of Linux?
No.
Can you just give us your best estimate?
I mean, if you have a good faith estimate you can give.
I do not have a good faith estimate.
Okay, you can't, you really don't, you just don't have any idea?
We don't have the, I don't have the numbers in front of me right now.
We've talked a number of times, and your testimony today shows that you're having regular discussions with the manufacturers. You said monthly. So you're sitting here today, you cannot, based on those monthly discussions, tell me the number of unique models that the manufacturers have currently certified?
You want to go off the record? Can we just have a minute? Thank you.
You can, and in the meantime, I'm going to say that we are not going to finish today. And we have not even begun to deliberate on good cause. And we have public testimony, which we will take before the end of the day. So we're going to need to discuss when we're going to have to continue this hearing.
But the reality is that the number of unique models available, ultra-low NOx models, is significantly less than 228. Is that correct?
if, to the extent that you understand what significantly means,
Can you explain what you mean by significant?
Much, quite a bit smaller, less than 50, we'll say.
I can't answer to that right now.
You have no idea.
It does cover.
I'll move on because we're running out of time. You had talked about the fact that the other manufacturers and distributors in the district are currently winding down inventory and that they're therefore not here asking for relief the way Howard Industries is, correct?
That's what I'm being told, yes.
Okay. Do you know how they're winding that inventory down?
All the information that we have is that the OEMs are telling us that their distributors are winding down inventory. We don't know how. That's their own business practice.
Okay. You are aware, though, that the other manufacturers and distributors, our primary competitors, all have significant presences outside of the district, correct?
if you know.
I don't know that.
You've had conversations with us about this fact, so I kind of don't believe that answer, but we'll move on.
Objection.
Sustain.
Did you review the September 4th letter that we sent to the district that contained information about the locations of warehouses with our main competitors within the district?
I don't understand what you mean by main competitors.
We provided a chart of our competitors and their locations to the district in response to a request from you to detail and provide information about the locations of where our competitors have warehouses. Do you recall that letter?
Yes.
And every single one of the competitors that is listed on that chart has a significant presence outside of the district, including nationally, across the entire western United States, or throughout California.
Objection.
Correct?
If you want to submit this letter into evidence,
The
then
letter is
is
settlement
privileged.
confidential.
Yes, but now you're
I can
asking
ask
him to
questions about
testify
portions of the letter.
so I'm free to ask questions about portions of it as well?
And Ms.
Are you
Reichert is
waiving?
correct. If you wish to discuss the content of a privileged letter, then
It wasn't privileged.
It's confidential settlement communications is how it was marked.
it's confidential, it's marked confidential.
You
So
can ask
if you wish
questions
to
about that portion of the letter, that's fine.
But if you're.
No, if you wish to discuss a confidentially marked letter, it becomes non-confidential and questions may be asked about it.
The portion of the letter that we're talking
can't
about.
pick and choose.
She
Either
can talk
it's
about the entire
confidential.
letter, that's
And
fine.
Madam Chair, we don't have the letter, so we can't talk about any portion of the letter unless you introduce your evidence. If you're not willing to do that, then you're off base.
It was settlement confidential, so I didn't print it out for folks to have as evidence. So I'm hoping that Mr. Wang will just answer the question because I think we can move along. Okay.
Perhaps if you can have Mr. Wang review it and simply answer a question, well, although it's marked confidential, so either it's not confidential or it's not.
Honestly, I'm happy to move along because I don't think that this is terribly relevant for the good cause. I think this is much more relevant for the 6 factors. So I don't need to harp on it too much.
Thank you.
I don't think I have any other questions. Thank you.
And I apologize. I had an exhibit I prepared in rebuttal to a point that was made during the petitioner's arguments, and in my rush to get through, I neglected. And I'm going to just quickly present it to the board and ask just a couple questions, and then we'll move on.
Okay, let's make sure that Mr. Williamson has a moment to review whatever it is. Okay, the board has received an email correspondence from Braden Cook to Mr. Sean Wang, and it's dated September 24th, 2019, and we'll mark that as Exhibit A for the district respondent. A as in apple.
Thank you. Mr. Wang, did you, have you seen this document before?
Yes,
And did you receive this document?
yes.
And who is this email from?
Braden Cook of Carrier.
Okay, and can you just please discuss what the email states is, what the email is communicating to you?
This email is stating that Carrier reached out to Howard Industries with a proposal that a distributor of Carrier is willing to sell Howard Industry and other distributors ultra-low NOx product through their brand, and that Carrier has given permission to that local distributor to sell ultra-low NOx products to other distributors through sub-distribution. This proposal was provided to Howard and allows them to have access with ultra-low NOx compliant products, and Howard Industries that responded with that they are not interested.
And was this, is this the sub-distribution offer that was referenced earlier in terms of Carrier's communications with Howard?
Yes.
Thank you. All right, no further questions.
Mr. Williamson, I may ask questions, and then Ms. Verdugo-Peralta.
Quickly, and you heard Mr. Winter's testimony about the fact that this sub-distribution agreement would not work economically for his business, correct?
Yes, I heard. Mr.
And you have no reason to believe that that testimony was false, correct?
No.
Thank you.
Ms. Verdugo-Peralta.
To follow on that thought, if you can extend it a little bit further, the objection to this was because of the fact that it was he would be like a same competitor buying the same product. Is that correct?
Be like a contractor buying it from another distributor.
No.
I'm sorry, we are on Mr. Wang.
Well, okay, Mr. Wayne, I can ask.
Mr. Wang.
I'm asking you the same question.
Can you restate the question?
As the Howard attorney just specified, and in previous testimony, they were saying that they did not want to do this as a sub-distribution distributor because of the fact they would be the same as going and buying something from a competitor along with the competitive value there. Is that correct?
If you don't
Do you
understand.
I think that was answered by Mr. Wang saying he was here and he heard the testimony and had no reason to believe that it was not correct. But that's the best of his knowledge.
He answered
We-
part of it, not the extension of it.
Well, we heard that testimony from,
Yes, but I was asking him that, if he understood that.
To the extent, do you have any personal knowledge regarding the Howard Industries financial, whether it would be financially viable for them to enter into this agreement?
No, I don't have any information on that.
okay. Senator, did you have any questions?
On this same issue, Mr. Winston was drilled on this with questions asked and received. Same thing. We've heard all the evidence related to this. It won't work for respondents, period. I understand.
Okay. Any other questions for Mr. Wang on any of his testimony?
I do.
Mr. Balagopalan.
Mr. Wang, you mentioned that, is it 5 out of 7 manufacturers producing compliant furnaces? Is it testimony?
5 out of 7 have commercialized units.
Do you happen to know the names of the 2 that are not having commercial?
One of the 7 do have certifications, whereas the 7th, we did not receive any.
And so Ingersoll Rand is not in the 2, right? So they are in the,
Can you restate the
so
question?
the 5 that are selling certified units includes Ingersoll Rand, even though they have just a couple of units?
No.
So
Ingersoll Rand has certified units, but they do not have commercialized units.
Oh, I see. What's the distinction between the two?
Certified means that they passed the emissions test. Commercialized means they're available to the public for sale.
After they had passed the tests, basically.
Correct.
So Ingersoll Rand has not put it into a commercial sale at this point, but they have 2 units that have passed the test.
Correct.
Okay, thank you.
Okay, any other questions for Mr. Wang? Okay, thank you, Mr. Wang. Ms. Reichart, did you have any other witnesses on
No.
good cause? Okay. Ms. Verdugo Peralta, did you say you had a very important question for good cause you still needed to ask of Mr. Winter, or?
How many units does Howard Industries have right now in stock that you either need to sell by October 1st or that you're asking for this extension of time?
Correct. So the premise for the extension of time is because I don't have anything to go forward with. But in inventory, I'm speculating about 2,000 to 3,000 units that are not in compliance. Everything I have is not in compliance.
Okay, any other questions? Okay, Mr. Williamson, I would really hesitate to asking you to testify. I think we get into a very uncharted and dangerous territory when we ask the attorneys to testify. That will open you up to questions beyond that which you wish to testify to. Also, it allows you more of an opportunity to essentially allow in more argument. I would hesitate. Are you still prepared and you'd like to testify? Because if you do so, you're opening up a can of worms, I believe.
I don't. It'll work. It is a delicate thing, but I'm just very concerned about the comments and questions that have been made about the discussions that were happening from August to September and about why Howard did not file a variance in August. Frankly, I almost a number of times had to stop my client because some of the questions that were being asked were getting into very close to attorney-client communications. But the reality is that the discussions were non-privileged discussions between Ms. Reichert and myself. And I sense that the board is focused on why that August date was passed. And the answer in my mind is in the discussions that I was having with Ms. Reichert and frankly in my experience of negotiating abatement orders. So that's kind of my critical thing, but if you guys don't think that that is something that is worth our time to go through because it's not an issue, I'm happy to not testify about that.
I think there is a very important issue. It's one of the most important issues, well, not one of the most, but it's a very important issue to me. However, I will then need to ask you how many times you've appeared before the board, what your experience is with variances and other questions to make sure that we're complete. So we would go beyond, I think, what you wish to present to the board.
And I'm wondering if there's a way to do it that would be, if we're not finishing today anyway, perhaps that Ms. Reichert and I could discuss, and maybe there's a way to do it that would kind of limit the expansion of the questioning. Because I appreciate your points, but.
Is it based on notes you have, or is it based on memory you're going to be?
It's the last 2 months. It hasn't been 2 years.
Do you make notes of all the conversations, telephone calls you make?
Typically, and I typically throw them out shortly thereafter.
Okay. Senator Head.
You're an experienced attorney. That's why you're here. Think about that. You have a closing statement to make. I'll wait your closing statement
The closing statement can't mention things that are not in
I
in
understand that,
evidence.
but based on the lengthy discussion that we've had, including office order of abatements and so on, he can comment on that and his position as it relates to the variance request. I don't understand, this guy doesn't understand where you're coming from. I mean, I've heard this over and over and over again since 9 o'clock this morning. I'm not that dense. Thank you.
The issue is that there are, Mr. Williamson is stating that there have been other discussions where other staff members or members of Howard Industries have not been present. Is that what I'm understanding? Between yourself and Ms. Reichart, so no one else could testify to them?
Phone calls.
Phone calls, or just the two of you, or?
I guess we have, a lot of it is email. I know, I guess phone calls and email. That's what I'm thinking, is go back and look at it, and there may be a way to, I'm just concerned that the impression that the board has gotten is that there was just this silence, because again, Jeff, or Mr. Winter was not the person who was engaged in the discussion, and Dr. Fine was also not engaged in the discussion, so.
Could we have just a couple minutes off the record, and maybe
I
if
think that
could
would be
figure-
helpful.
Yeah, okay.
This is a
'Cause
very
maybe we could
important issue to me.
stipulate to something simple.
Yeah, let's do that.
Okay.
All right, let's try and just take a few minutes, because if we can make a decision on good cause, I'd
Before,
like to
just
do that.
wait, before you go off the record, be mindful of the fact you're losing 2 members. They won't be here. You be mindful of that, you understand?
Okay. We're off the record, hopefully, for not too long. We're back on the record. Have we
Yes.
reached some understanding?
And I'm going to
Thank you.
try, and Ms. Reichert, I'm sure will correct me, that the stipulation is that during the, was it August and September period, or late August?
Well, after September, because
Sure.
August
So,
was
yeah,
silent.
so during September, the attorneys for each of the parties remained in active discussions, exchanging information, responding to questions from the district. the goal of which was to work towards a possible order for abatement.
I'm sorry, that was, the stipulation is that that was after the September 6th date?
Correct, or the
September 7th, whatever that
Or
date was.
September, yeah.
On the record was a date of September
September
7th.
What was the date of the letter? After September 4th.
So the stipulation is that August 7th, there was a meeting. After the August 7th meeting, through September 4th, there was no communication.
I mean, there may have been a phone call, but there was not.
I think the stipulation is
really limited
from
to
the
it.
September, we sent a letter on September 4th. And following that letter, the attorneys for each party were in active discussions, responding to questions from the district and discussing related issues towards the goal of negotiating a stipulated order for abatement.
And let me go back, towards the goal of
Yes.
discussing a possible order for abatement.
Okay. Okay,
I understood that before the break.
okay,
Thank
thank you. Well, we didn't have exact dates, and that is helpful. Okay, I'm going to ask for, please, oh, sorry, we have a public member who wishes to give. Is he left?
to go? Do you want closings and then public comment?
Yes, just because he's not, Mr. David Winningham for Lennox International is not here.
We're going to
Yeah.
go look for him.
Let's do closings then first. I usually like to have the closings after, but given the time. Okay, Mr. Williamson, please, more brief than opening, thank you.
I'm going to go quick through the first one. We are all in agreement that beginning on October 1st, I'm going to turn my microphone on. The beginning on October 1st, Howard Industries is going to be out of compliance with.
I'm going to stop you because I believe that the public, so that way you have a say after. Let us do that. Okay, I'm going to call a member of the public, Mr. David Winningham for Lennox International. Mr. Winningham, if you could come to this podium, please, and if you could turn on the microphone there. And you indicated that you do represent a group or organization, but a company is not a group or organization. Beyond that, do you represent a group or an organization?
No, I do not.
Okay, then I'm going to give you 3 minutes, but first, did you take the oath today when I administered it?
Yes, I did.
Okay. Can you state and spell your name for the record, please?
David Winningham with Lennox International, DAVID WINNINGHAM.
Okay, and Mr. Winningham, we will now give you, do we have that ready, Madam Clerk? 3 minutes for comments.
Much of my comments are summarized in the comment letter that you received, but I will go specifically to a couple of key points and not restate what has already been discussed thoroughly today. The variance request mischaracterizes the efforts of Howard Industries to acquire compliant furnaces from Lennox affiliates. Howard discussed the potential of a Lennox affiliate providing compliant furnaces under the ADP umbrella. We've discussed that today. But to be clear, ADP does not manufacture furnaces and has never competed in that space. And that is a significant business departure from ADP's kind of business strategy. While there have been discussions towards that, usually the onboarding of a new customer is a fairly significant process. There's usually some initial meetings, which are kind of scoping meetings to say, hey, we've got an interest here, we've got an interest here on this side. And after a couple of discussions, there's some determination, usually the parties go back and evaluate, does this make sense for us to go forward? And I think that's kind of the point where those discussions were at. The normal process under our kind of business umbrella is once you've kind of reached that point, usually there's a non-disclosure that is put into place, and then you work through the terms and issues related to the matter. Granting this variance isn't just about, what we're talking about here. The market in general and manufacturers have resisted this rule for the last 10 years. And it has taken significant prodding, dispelling of various issues over the course of the last 4 years in particular, since the mitigation period has been in place. A vote to grant this variance is going to continue that belief that manufacturers and/or distributors can continue to kick the can down the road. While there is a mitigation fee and a rebate plan in place, the numbers have proven it's not been successful in moving towards compliant product. The rebate plan started last March, and only 11% of the available funding has been used to date. That's only about 650 units. So the market needs certainty, and manufacturers need certainty to continue down investing in this path. We have invested significantly, and basically we've got a barn full of product that has not moved. Thank you.
Thank you. Mr. Williamson, any questions for Mr. Winningham?
I do. I have a couple questions, and I apologize. We just got this letter this morning, so again, I don't have copies of a couple documents that I'd like to show. But I wanted to visit some of the claims that you made in your letter to the board today that claim that there are false statements from Howard Industries in the petition. First of all, having listened to any of the testimony today, do you think that any of the statements that you've made in your letter are incorrect?
The statements in my letter are from the collective feedback from my internal team to me on their perspective of those discussions.
Okay, did they talk, do you know for a fact if they talked with the folks that we were talking with at Allied and ADP?
Yes.
Okay.
Those specific folks.
Okay. Did you confirm that they were accurate before you included them in the letter to the district?
I inquired as to their accuracy to the people that were involved in the discussion.
Okay, I would like to show you an email first. It is if I get it up there, it is an August 7th letter from Greg Jones, who is our ADP rep, to Jeff Winter, obviously, who's sitting next to me, letting us know in August that we got a call from Allied this morning looking to see if you were still interested in ADP badged furnaces. Does that seem consistent if we didn't have previous discussions with ADP and Allied prior to August, as you claim in your letter?
I believe there was one prior discussion that, from the feedback that I've gotten, ADP services Howard regularly, and they have an ongoing business relationship, and I'm sure that there are discussions that weren't specific to furnaces that are an ongoing part of their business. There was an inquiry that Jeff had alluded to that came through the ADP channel that, from what I'm aware, really didn't move anywhere at that point in time. But from the parties involved in the discussions directly with Jeff, what I presented, what was presented to me.
Okay, but again, I asked you if there is any incorrect information here. It sounds like what you're saying to me is that, having listened to the testimony today, is that you don't have any reason to disbelieve Jeff's testimony that there were conversations that happened between Allied and Howard Industries prior to August of 2019. Is that correct?
No, I think what I heard from our internal team is inconsistent with what I heard.
Is inconsistent?
Yes.
Okay. But you don't have any reason to disbelieve Jeff's testimony today, correct?
No.
Okay. And then you also, down further in the letter, say that Howard Industries never indicated it would require more than 1,000 furnaces. Was that, again, a discussion with your team and diligence that they'd conducted?
That was directly from their discussions in regard to their immediate requirements for the upcoming fall.
Okay, but again, you don't have personal knowledge of this, right?
No.
Okay. So I'm going to show you another email. This is again from our ADP rep, Greg Jones, to Jeff and Jeremy Winter. This says, tried to call, I've heard back from Allied about the capacity allowance they think they have for this season. They have capacity for about 1,000 ULN furnaces this winter, maybe a little more, but can't be certain. Again, this is a limit that is being stated by Allied, not Howard Industries. So what is the source of the information, the belief of your team that Howard Industries didn't demand more than 1,000 units?
From what I was told in our internal discussions is the 1,000 units was Jeff's requirement back to the team for the short-term time period of this fall.
But do you know if that was based on Jeff's request after he was told that he could only get 1,000 units?
No, I was told that that happened prior.
That happened prior?
At Jeff's suggestion.
Okay, and do you have any reason to disbelieve Jeff's testimony that he in fact asked for 5,000 units with a 2,000 units per month going forward?
I have not heard the 2,000 unit per month, and what the 5,000 to 6,000 was estimated to be their annual quantity.
Anyway, again, sitting here today, you don't have any reason to disbelieve Jeff's earlier testimony that he was requesting 5,000 units followed by 2,000 units every month thereafter.
Only that is inconsistent from the information that was provided by the Allied and ADP people who were involved in the conversation.
And do you know who the people that you were talking with at Allied and ADP as their source for that information were?
Yes.
Who?
Tim Orr and Joe Leonard.
Okay, thank you very much. No more questions.
Ms. Reichart, do you have questions?
Can you briefly discuss the impact on the market of if this variance were granted and these furnaces, non-compliant furnaces were allowed to be sold?
Well, it would be
I know it's a public comment, but this is expert testimony about the dynamics of the market in a variance. I'm not sure that this is the witness to do that.
Based on your experience,
The question was again, I'm sorry.
how would allowing the non-compliant furnaces from Howard Industries to be continued to be sold past the October 1st deadline impact your sales of compliant furnaces? I'm rephrasing.
Okay, there's no objection to that, is there?
No.
Okay.
It would negatively impact them. It has been proven by the non-movement of compliant product in the market today that even with the rebate and the mitigation fees in place, that compliant product isn't moving in the market. And it's my understanding that there is the mitigation fee would not continue, that there is a calculation based upon emissions, which would likely be a reduction from the current mitigation fees and provide them with a competitive advantage.
Thank you. No further questions.
Board members, any questions for Mr. Winningham? Mr. Balagopalan?
So, Mr. Winningham, so if Mr. Winter was now to reach out to Lennox and ask for units to be, so they can distribute, was that something that Lennox would entertain?
We would entertain the discussion, but I think we need to understand the current situation here also. That we've somewhat got a trail of information that is being used to perpetuate a cause and, you know, a leverage to move towards that.
Mr. Winter mentioned that even, let's say there was, hypothetically, there was some kind of arrangement, it'll take several months before everything can be ironed out in a contract, and the legal aspect of it.
You know, just to briefly, I would say we're open for discussion.
Okay. Thank you.
Dr. Bernstein?
Thank you. Thank you, Mr. Winningham. I have a question. Apparently, there's some recalcitrance to coming into compliance. So there's been a problem selling compliant furnaces to date with the ultra-low
I think that there is a perception largely, you know, that kind of generated from the manufacturers and the distribution chain, a resistance to move to the ultra-low NOx products because it's new and different. It's been a difficult road. We, as I spoke earlier, we have a significant investment here, and we have yet to see significant movement in the market. I've had several discussions with South Coast staff in regard to, why things aren't moving. In the rulemaking process in 2018, we had advocated that the mitigation structure that was finalized was not going to be sufficient to move the market, and that even with the rebate plan, as it progressed through the increased mitigation fees, that moving compliant products would be difficult. And we presented that information during the course of the rulemaking process.
But let me just clarify one other thing, if I may. Thank you for your indulgence. And yet everyone along the entire supply chain understood that the rule was changing and that 10/1, 9/30, 10/1 was going to be a hard date.
Correct.
And so manufacturers still continued to sell product that they knew was going to be non-compliant and still continued to manufacture those products.
Correct.
So it seems to me that the entire chain is to fault with what's happening right now. Because what else would be the incentive for people to become compliant?
There has been several factors. As the rule was kind of promulgated in 2009, it was changed in 2014-15, and again in 2018. You've got a history here of it moving down, kicking the can down the road. So it's created uncertainty in the market and a disbelief that the rule is actually going to go into effect. And a positive ruling here is just going to perpetuate that momentum and perception.
Okay, thank you.
Ms. Verdugo-Peralta, and again, we're running very late, and so let's take any good cause questions we have.
Thank you, Madam Chair. Do you know the difference of the price between the compliant unit and the existing non-compliant unit that the Howard Industries is proposing that we allow them to sell?
Again, does this have to do with beyond, well, I'm sorry, with good cause to have a hearing in absence of notice to the public with any of the?
Well, I think this is a base question for them to want to sell the units versus going into possibly a more expensive unit.
Okay, well,
that's
that's
the
not an
ultra-low.
issue, again, we're just running out of time. So is there a particular finding we need to make that has to do with price differentials?
I think it's a base question.
It's not for a good cause, but okay.
A general statement, pricing is confidential, but the ultra-low NOx products will be more expensive than the products that are on the market today. That may change over time. As volume ramps up, South Coast estimated in their kind of analysis that the consumer cost differential was $500. That's.
I fear we're getting into exactly why this probably should not be being heard on variance, which is we're getting into rulemaking questions. So I'm going to hesitate to do that. That is not our area of expertise or our jurisdiction. Any other questions for, I'm sorry, I forgot your name again, Mr. Winningham, on anything on his testimony and related to good cause findings?
Right, been some discussion about Howard Industry being negotiating with your firm, Lennox, for 1,000 units.
Yes.
Are you aware of that?
Yes.
But you have not said yes or no to the request for 1,000?
No, we have not said yes.
Are you likely to say yes or no to the 1,000 units?
I cannot speak to that. That's a business decision that will be made by others.
All right, then is Lennox in competition from the standpoint of selling these furnaces with Howard Industry?
They are a competitor in the market today, but they are also a customer of ours through ADP, and we value their business.
If you value their business, then maybe you'd be inclined to sell the 1,000 units?
I can't speak to that one way or the other. That is a business decision that will be made upon the business case as presented to the people that make those decisions.
Well, after today, maybe hopefully that'll happen. But let me just say that the winter season is 5 months, and Howard Industry talked about they need from 5,000 to 8,000 units during that time period, and that they need a cushion of 1,000 units. If you don't get that cushion, then you may be selling that 5,000 to 8,000 units. That's competition. And I don't think we're in the business of deciding which competitor is going to prevail. We got to deal with what's before us. All right, thank
Yes.
you, Madam Chair.
Thank you. Okay, any other questions on point? Okay, thank you very much for your testimony, Mr. Winningham. Okay, given that it is now less than 5 of the hour, we will not be finishing. So let's talk about our next steps. I understand that 2 board members are not available all day tomorrow, some of the day tomorrow. Can we continue this tomorrow? Because the due date for being in compliance is Tuesday, October 1st, and it is a Jewish holiday. So I think the only option we have is to continue. Are the parties available tomorrow?
Yes.
Yes.
Okay. We're going to have to continue, no, we'll have to continue it to tomorrow. We have a lot. Okay, we have 3 minutes. Okay, no, 4 o'clock. Ms. Verdugo-Peralta, are you able to be here for some of tomorrow? It is a hearing board day.
Yes, yes. We had a medical appointment in San Diego. I would have to have that canceled.
We could also continue, unfortunately, with 4 board members, but I think we will need to complete this hearing, and it has to be, can't be Tuesday. I am right about that, correct?
Yes.
Okay, petitioner cannot be here on Tuesday, given the holiday. We should probably be dark on that day anyway. So we will have to continue to tomorrow. We'll start first thing, and hopefully we can get through it very quickly. It depends on how we rule with regard to good cause.
I can do a closing in 5 minutes. We have talked all day long about this. If we can at least give it a go and stay a little late
In
tonight.
2 minutes, because then we have to hear from Ms. Reichard as well.
I can be quick.
Okay. Let's try our closings, starting with Mr. Williamson, but I anticipate we might have lengthy deliberation.
Okay, so I will skip over most of these. The first element of a rule violation being imminent, we have discussed. It will happen on October 1st. The circumstances leading to the violation could not reasonably have been avoided by petitioner. We have discussed extensively the efforts by petitioner to find an alternative source of units, work with their current manufacturer to obtain a source of compliant units. And then finally when those passed didn't seem to be working, to meet with the district. And the parties have a difference of opinion about what was said at those meetings, but Howard Industries left the meetings with the understanding that the preferred path forward was an order for abatement that should be negotiated, and the district did not want to pursue a variance. Relying on those representations, that is what Howard Industries did until the order of abatement appeared that it was not going to be negotiated and agreed to in time, at which point they filed for the interim variance petition. We think that was reasonable steps on the part of Howard Industries and justifies a finding of good cause for holding this on an interim basis. We also, as we discussed, filed the petition a week after the talks appeared to be breaking down, and in fact, we continued the discussions on the order for abatement right up until we filed the petition. And finally, we talked about the harm that the company is going to suffer if the interim variance is not granted. As Mr. Winter testified to, even a short shutdown will result in clients being driven away from the company very quickly and would likely lead to a shutdown or near shutdown of the company, laying off most of his 75 employees. For all those reasons, I think there's clearly good cause for this to be held as an interim variance. Thank you.
Thank you. Ms. Reichart.
Thank you. For me, this case comes down to too little, too late. Petitioner has had more than enough time to take actions. They delayed and delayed and delayed. They didn't start contacting other manufacturers until 2 weeks ago, which is obviously way too late. They should have acted more diligently, and to the extent that their business was in jeopardy, I would have expected them to have acted sooner. And I don't honestly understand what happened, why they did not. They were involved in the process, they were aware of the impending deadlines, and for whatever reason, they just chose not to take action. Just because, so in terms of the finding of that the variance could not have been reasonably, or the violation could not have, the violation could not have reasonably been avoided. I do not think that petitioner has shown that. I think that they have failed to act diligently to obtain other products and to find alternatives. In terms of exercising diligence and petitioning for the variance, they saw another, their manufacturer filing for a product variance, holding a place, which they then took off when they determined it was not viable. Just because the district informed them that they would likely oppose the variance does not mean that they were not well within their right to file that variance, even while discussions regarding a potential order for abatement were still ongoing, and we never instructed them to the contrary. Furthermore, we never told them that we were fully on board and we were going to move forward with an order for abatement. We were merely continually trying to gather information and determine if an order for abatement would be warranted. Finally, I think that Ms. Prusek makes an excellent point that I'm not sure that this variance would even provide the relief that they are requesting, in that, and it would not alleviate them of the adverse impacts, because installers are not covered under this variance and may not be able to actually purchase the products to install after October 1st. For those reasons, we oppose a finding of good cause.
Thank you. Board members, let's start discussion. We'll see how far we get. I think this is a difficult matter, and I do not believe we can find good cause for a number of reasons. I do believe, well, obviously, violation would be imminent. That is not in dispute. And I do believe that we heard even from district staff that at certain points, they even thought that this might be a unique situation, Howard Industries. And I do believe that the up and down and the flipping and flopping we heard about had a lot to do with their attempts and false promises, and I don't want to say false, but promises that fell through eventually for one reason or another, or maybe they were never actually a meeting of the minds. I don't know, I don't have enough evidence one way or the other, but between thinking that maybe they do have a supplier moving forward of furnaces and then believing that they did not have. So I can't say one way or the other. I don't know if I have enough evidence regarding reasonably have avoided the circumstances leading to the violation, but I cannot get around the fact that this is a hearing without notice to the public of a matter that has been heard over and over and over again by the governing board, through working committees, publicly noticed hearing after hearing after hearing with regard to the same issue. And now we're being asked, without public notice, to do something to the opposite. And I don't believe that it couldn't have been anticipated in sufficient time to provide for public notice. I understand that we heard there were discussions. I do understand that we heard that there were discussion of possible orders for abatement. However, as of August 30th, they knew that there was definitely not going to be any ADP units available. They did not have the proper anything available. They had not spoken to the district since the beginning of August. August was completely silent. And I don't believe that a placeholder for a noticed hearing was something that was unreasonable. Absolutely something that should have been done. And I think the results, if we were to hear this matter without notice, just completely goes against the rulemaking process of the district. And I don't believe that, nobody told them they couldn't do it. We heard testimony, in fact, that they always knew it was their choice. It was just they felt a better choice not to file, but here we are. They don't have an order for abatement. It's in advance of the October 1st deadline, and yet we're here, but we're here without public notice. So I cannot make that finding. And diligence, I don't believe that we can make that finding. Our guidance says that petitioners who take days or weeks to conduct testing programs, attempt remedies, confer with vendors, consult experts, meet with attorneys, and so forth prior to filing for a variance are not usually considered to be exercising diligence. And so even if we were to say, they believed that prior to the very beginning of September that that this might be fruitful to go a different way, by September, I don't know if it was 6th or 7th, I can't recall anymore, we've heard so many dates, that they then knew they had to file, they still waited till the 13th, the 17th, it's state stamped the 17th, but I understand the 13th was a Friday and they attempted to get it in. But regardless, I don't think that's diligence, given the circumstances we're talking about. This is not an explosion or something that happened on an emergency basis. This is something that was pending and there for a very long time. And then finally, I do find that there is an issue. Again, the finding we need to make for good cause is a denial of the interim variance will result. So it's a denial by us of an interim variance in an unreasonable and unavoidable adverse impact to petitioner. But again, even if we were to find good cause, hold a hearing and actually issue an interim variance, the only relief we would be able to give is that you could sell it. But we cannot give relief through this variance for anyone to purchase it or install it. So there's no one to sell it to. That would have to be a separate variance request, which is not before us. So it's not as a result of any denial of an interim variance today, I don't believe. I'll open it up for additional thoughts. Mr. Balagopalan.
Yeah, I think it's unfortunate that Howard Industries here is one of the manufacturers, Ingersoll Rand or Train and what's the other facility, it looks like Train submitted a product variant for whatever reason they pulled it out. They are the ones who they had a contract obligation to supply the furnaces, and they were aware of the timelines, because this had stretched on for many years. The rulemaking allowed multiple mitigation measures, paying the fees, and extended the time frame. So Train or Ingersoll Rand should have been here asking for a product variance if there was some difficulty in meeting the standards or the emission limits, but we don't see that. It appears, they have a couple of units that have been certified, but maybe production is low. So, it's hard to say whether now Howard unfortunately is holding a inventory that it needs to sell, and it cannot sell because it doesn't have the distribution extensive compared to the other distributors. But so it's got a number of 2,000 to 3,000 units in the warehouse that they cannot push out. But unfortunately, the rule doesn't allow. I think the rule did provide sufficient timeline, sufficient time frame to come into compliance. So by not taking advantage of it, I maybe don't know whether Howard was still buying units, or trying to sell the existing inventory, and maybe anticipating they could get any further extension. And I think the other point that Ms. Bruzak said is, even if we give an interim variance, it doesn't address some of the issues regarding the contractors who are going to install it and the mitigation fee, and all of that had to be crafted out. In 2015, 2016, when it was the compliance date, and it was extended with the mitigation fee, so there was a fee that was associated with each unit that whoever was selling that unit had to pay because they were non-compliant units. So with the interim, I don't think we can craft any of that, and so then it would essentially allow Howard to sell units that are non-compliant at a competitive advantage over their competitors. So I don't think, that's probably something that we should encourage or allow, because the rule is very clear. So I think I would support not granting an interim variance.
Finding good cause. Senator.
I've been in a different meeting since 9 o'clock this morning, and the message I got is quite different from what I've heard so far in the closing. They will be in violation, no doubt about it. It is a hardship. They have 7% of the revenue would be lost. Closing of the business. 80% of the employees would be without a job. Did they make an effort to try to be in compliance? They've been meeting with the district. They've been talking to suppliers. Every door they try to open is locked. I mean, I don't understand where we're coming from at this point in time. Even some of their competitors, who are also distributors, won't sell to them. As the gentleman just testified, yes, he knew everything else. He was their spokesperson today. We've been in negotiations for 1,000 units, but I can't guarantee we're going to sell them to them. Because if they did, they would be in compliance by tomorrow. And they're refusing to do that. They refuse to acknowledge here today that I represent this company, and they will Lennox. And Lennox, I can't say that it's a business decision. Yeah, a business decision to be made against their competitor. They hold all the cards in their hand. That's not fair to me. I mean, either we're going to apply fairness or we're not. If you're not, I'm not part of the deal. I cannot be part of that deal at all. Howard must be given an opportunity to be competitive in this market, in this state, in this district. And we cannot allow their competitive to run them out of business and say, we don't see that's happening at all. That you had an opportunity to be in compliance. You have not had an opportunity to be in compliance. Have not. If anybody believes that, show me, based on the discussion that we've had, that they've had an opportunity to be in compliance by October 1st. In fact, the district been talking to them about it and been suggesting there may be another way out. Order of abatement. But I don't think the respondent understood that clearly, because you cannot issue a notice of order of abatement until you are not in compliance. But they were preparing you to get ready when you're not in compliance to work with it. Now, what we have here today, if you grant this variance, you have 40-something days, I mentioned 43 days before the regular variance. If you had an order of abatement, it's essentially the same thing, except with an order of abatement, you have to report. When you have a regular variance, you have to report progress that you're making. It's called
Increments of progress, only for ones over a year.
It's called increments of progress, which is the same as the variance, because if you have a stipulated condition, the variance, the stipulations say pretty much eventually, because you get an extension, the time you think you'll be in compliance. If you're not, you come back and ask for an extension. You come back here, you ask for an extension. I've never seen them deny an extension yet. So it's essentially the same thing in the back door. And I would say that, I'm with vote for the variance.
Senator, we are not voting for a variance. The question right now is whether there's good cause to proceed without, there was no notice given. Let me just finish. There was no notice given to the public. Okay, whether or not they're being treated fairly, whether there's competitiveness, that's with regard to a whole different issue. That is with regard to something You could apply that to the circumstances leading to the violation could not reasonably have been avoided by petitioner. That's not the grounds on which I feel we have not heard sufficient evidence. It is, or anticipated in sufficient time to provide public notice of the variance hearing. The question is whether or not they knew they had the choice, they hired an attorney to represent them back in July. By mid-August, they had to have filed in order for us to be hearing by now with notice to the public, a noticed hearing. And that did not happen. So the question is there good cause to proceed because that didn't happen? This is not, I submit, this is not the situation where there's a power outage. This is not a situation where there's an explosion no one knew about or there's a test that suddenly someone failed. This is a situation that everyone has known has been coming for quite a long time. And now we're hearing it as if it just happened and it's an emergency. And so as a result, there's no one, someone heard from the public, but there's no public notice as there has been for the rulemaking which we're being asked to undo, essentially. And so it's for that reason, not for any other reason, not for competitiveness.
I'm glad you mentioned it because the public did testify. You asked for public comments, public testified.
Yes, one member of the public knew about it. There was no public notice given.
Well, at least the public a representative was here representing the public.
Be careful. Be careful how you vote based on your feelings about a particular case. Because what you're saying is, if the public happens to hear about it, public notice is not important. It's not a requirement.
I'm careful at all times, but let me just say this to you, Madam Chair. That card that was filled out by Mr. Winningham, it says public. That your yellow card, so he wants to speak for public comment.
So what's that? What are you trying to say?
I'm saying that the public did comment.
The public did not receive notice. One member of the public came and testified. There was no public notice given. That's why we're deciding whether there's good cause based on the findings we always need to make.
Madam Chair, in my opinion, even if the public were here, even if they received notice, and this same testimony was presented for this body, I don't think it would change one vote one way or the other.
You cannot say that. That is disregarding all public testimony. Please don't say
I
that.
said, I don't think, and that's my opinion, and I'm sure everyone here have their own opinion. I just don't honestly believe that anything would change.
Senator, I'm sorry, we're trying to determine good cause. I can't let us as a board make those kinds of statements because what you're saying is public notice doesn't matter. And that we're asking whether public notice was not given. This is an interim. We have established findings we need to make. Let's just stick to that, please. Other members wish to be heard. Ms. Verdugo-Peralta.
Thank you, Madam Chair. I think that this is really a travesty of what you're having to go through here. I sympathize with the facts that you have presented in regards to having to deal with the manufacturers and the distributors and all of that sector. I also think that there was a gross breakdown of communication between the staff and Howard Industries. Who's at fault? I'm not really sure. I see fault kind of on both sides. I think there should have been much more discussion, and if you knew that this company was going down this path and possibly not going to do the right thing here, I think it was incumbent upon the district to contact them. Also, I think it was also incumbent upon Howard Industries to keep them apprised of what was going on much more regularly than did occur. I understand that there was a death in the family, my condolences for that, but somebody in the company should have picked up the ball and talked to the district about it. The fact that you took the time to hire an attorney and come down this path does make me believe that you had every good intention of trying to be in compliance. The only sticking point I have, there are actually two sticking points. One is the fact that this has been a rule that has been 10 years going down the road of trying to bring all of these companies into compliance to produce a piece of equipment that's going to be utilized by the public, that's going to be much more energy efficient and obviously reduce emissions. The other sticking point I have, that even if we were to grant this, that the installers are not covered and they cannot purchase it. That, to me, is the number one, and the one reason only I can hang my hat on not to grant this. If it weren't for that one point, I would have been totally sympathetic and supported Howard Industries on this. But because of the fact that, and I'm hoping that this is totally correct, that the installers cannot be covered and that purchases cannot be made, that is the only reason that I cannot support it.
Dr. Bernstein.
Well, first of all, I want to thank all my colleagues for their comments. This is probably the most difficult case that I've been having the ability to have the opportunity to address since I've become a member of this board. And so I'm going to limit my comments to a couple of issues. It is my opinion that there were circumstances that led to the violation could not have been reasonably avoided, given the nature of the business, that Howard Industries has a sole source of product, that apparently all attempts that were made were found on deaf ears to try to give supply so that Howard Industries would be in compliance and be able to sell the most recent iteration of the furnace with its appropriate emission standards. There also seems to be some confusion, more so than I've ever seen, between our staff and Howard Industries with regards to discussions of how to proceed, whether it be with an order of abatement or whether it in fact be with a petition for an interim variance. Enough confusion that delayed the process. All those elements put together, in my mind, did in fact substantiate and delineate circumstances that would in fact have delayed a sufficient time and decrease the ability to anticipate the sufficient time to provide for public notice. In addition, we mix in, and my deepest sympathies, a loss of a parent during this time frame, and it just seems to me that there's enough evidence that has been presented to me that there's been due diligence beyond in attempting to become compliant with this rule. And I do, in fact, believe, it is my opinion, that there is enough evidence and that good cause, according to the requirements, does exist, and to grant good cause in this to go forward with a moniker of good cause. So thank you.
Board members, I'm definitely hearing that there is a lot of sentiment from many of us that the not reasonably have been avoided, which is very similar to beyond reasonable control that board members are feeling, and based on the testimony today and the evidence today, that Howard Industries is between a rock and a hard place, and as Senator said, not treated fairly. Others have voiced it indifferently. I do want to just hone it in and see where we're all, and then maybe I'll make a motion. But with regard to filing with sufficient time, again, remember that is the central issue here right now, which is define good cause, which is whether or not, knowing that the October 1st deadline was not a surprise. So knowing that it was coming up, were they diligent in filing? I say I can't find that. I'd like to hear if there's any other thoughts on it. I've heard both ways. But I do think I'd like to reiterate, as Ms. Verdugo-Peralta restated, that one major issue is, and I know I just read the finding, but it's very important to think about this. There is a regular variance hearing November, I don't know what the date is, November 7th, thank you, where we'll be hearing, for sure, we will be hearing all the elements for a variance. The issue is between now and then, what is the harm? That's one of the things we have to look at. And what we heard was, as of October 1st, if they cannot sell, there is significant harm, and they may have to close down and lay off. And that is very scary sounding. However, can we today help them? And that is one of the elements we need to look at. And it says a denial of the interim variance will result in an unreasonable, unavoidable adverse impact petition. I think it's difficult, it's impossible to say that we could help with the variance, because from how I've read the rule, no one can install or use those. They cannot purchase them, or, well, they can purchase it, I suppose. There's no bar on purchasing. But it's not the same as a product variance, that it follows the piece of equipment down the road. This is different. This only applies to the person, to the seller, directly to the seller. So no one can install, and no one can file for a variance to install either before we hear this hearing for a regular variance. So I think that harm is going to happen no matter what we do today. Dr. Bernstein, you.
Thank you, Madam Chair. I just want to comment on the fact that we had a gentleman, Mr. Winningham came, who, in my mind, has been put in the position to not only represent the public, but represent the industry. And it seems to me that the history of industry is one of noncompliance. The industry continues to move forward. People are selling equipment, and people are installing them, knowing one way or another that these are going to be obsolete and they're not going to be compliant with the rules. So the business keeps going on. The testimony is that for whatever reason, the industry has not responded to be compliant no matter what has taken place. And so the harm is going to be is that, in my mind, is that you're going to now take someone who has the ability to do business because the industry is still supporting that business, and now put them in a position where they're not going to be able to do business because other people are still going to sell those non-compliant.
That's not correct, actually, because
Well,
we did
I
hear
don't-
there's no exemption being given to anyone else to sell after October 1st.
Understood, but I understand that. But the history is such that the industry has not been in compliance during this whole time, knowing the evolution of this particular rule. And so I don't see why that's going to change abruptly overnight.
Because there's a date by which if they sell October 1st, they're out of compliance and in violation. They sell before it, including now up to September 30th, they are not.
Okay, well, I guess that remains to be seen.
I think we
People have
also heard-
thousands of units that are
I don't know who
available for
wanted to
sale.
be heard first.
May I comment, Madam Chair?
And then,
Yeah.
Senator, I think wanted to.
As a regular variance is going to take place, hearing in October?
November
Sorry.
7th.
In November the 7th. And your same argument to deny the regular variance would be the argument you're using today.
No, we are looking at good cause, Senator, which is
No,
different
no.
findings.
No, you're saying that even if you gave them good cause, because you can't install, because there's no variance for that, and if it come November, you still can't install, so therefore you're sending a message, you really are sending a message, that come November, the regular variance hearing, those conditions are going to, 1111 going to be still in place. And you'll be denied the right to grant a regular variance knowing what those conditions are in 1111.
I am saying that there is no relief we can give them between now and November 11th.
I'm just saying that you can deny it then. I get, it's a given. If you use the same argument for the regular variance, but you can't install unless the variance has changed.
That's not true, because temporally, if we were to give a regular variance to sell, then those who wish to install can come then and ask us for a variance to install. But during the period between now and when a regular variance can be heard, which is the only relevant period when we're looking at the good cause finding with regard to that, we cannot provide any relief.
Why, you're gonna use, the argument you're using now is we can't show good cause. Even if you did, they cannot install or sell.
No, that's part of the good cause findings. Do you have the good cause findings in front
I
of
have
you?
right in front of me. I've been
You have the
referring to all
questions, but do you have the actual findings we need to make? Because number 4 is a denial of the interim variance will result in an unreasonable and unavoidable, those are the questions, but an unreasonable and unavoidable adverse impact to petitioner. So that means that a denial of the interim variance, us denying an interim variance between now and when a regular variance could be heard, just that period of time, that denial will cause the unreasonable and unavoidable adverse impact. And I submit that is not correct, because even if we did grant it today and found good cause to go to that part of the hearing, to phase 2 of the hearing, that there's nothing we could do to allow for the,
Well, when
they're
this
still
comes,
they're gonna suffer it regardless
regular
of whether we
variance hearing
grant it or
comes
not.
up, I'm gonna ask the district, if they were to enforce 1111, that part of 11 that says that you can't install, will it be allowed?
Wait, are you asking a question now?
Yeah, that's it now.
Wait, we already asked this question. We already asked this question, and the testimony has been closed. The question that was posed was, does the rule also apply to not allow installation? The answer was yes.
You would not, it would deny you the right to grant the regular variance for that purpose of sale, based on 1111.
Ms. Verdugo-Peralta?
Thank you, Madam Chair. One concern that I did not mention, and I really don't recall who said this, was the fact that it's a possibility that we would be undoing the rule. And that's not what we are here for. We're here to listen to the testimony from both sides. We don't make the rules, and we also cannot change the rules. Maybe we want to, in this case especially, but I don't think that that's our place. We don't have the ability. I don't think we should go down that road. I think we're going down a slippery slope if we do. Thank you.
Mr. Balagopalan?
Yeah, I agree with what Ms. Cynthia Peralta mentioned, because if we were to give an interim variance, we have to come up with a phase 3 mitigation fee, and I don't think we can do that, the board, come up with that, or have the expertise to come up with a mitigation fee, because that's the only way forward that they can, continue to operate in non-compliance by paying a mitigation fee. That is something that has to be, and we cannot craft the rule, we can amend the rule, and it has to be, and we don't have the expertise to come up with the dollar amount. That's something that staff will have to come out, taking different things into account. So, so that's a very slippery slope and a very difficult, condition, even if we were to say there's good cause and go to interim variance, to craft that condition, a mitigation fee, is beyond our ability.
I think I do think we're going beyond good cause, but I think the point has been made. Senator, do you have any final?
Well, I agree, there's no mitigation fee in the discussion. It's just an added comment that's not relevant at this point in time.
Thank you. But
Only thing I'm want to reiterate my concern for November. There's no reason in the world why you can't use the same argument to deny that variance because you can't install based on 1111. You almost have to deny it, that regular variance.
we would cross that bridge when we come to it.
Already crossed it today.
No, we didn't. All the determination that was made today, in my mind, is that we cannot, even if it's part of good cause. We can't find good cause because we can't give them interim relief between now and November, because while we could let them sell, no one could install or use it. So I don't know who they would sell to.
All I'm going to say in November, I told you so.
Okay. And I appreciate all of these comments, and I also appreciate where Howard finds itself. I do. And I think all board members have expressed that as well. But I am going to, since it is so late, I'm going to make a motion, and we'll see where it falls. In the matter of Howard Industries, case number 6153-1, I move that we sorry, it's such a late hour. I'm looking for the word, that we, not deny, but that we find we do not have good cause to hold a hearing in the absence of notice to the public for the reasons that were stated, and my motion would include, well, for the reasons that we were stated, that we couldn't make all of the findings that are required for good cause for an interim, and to hold that hearing, and that we dismiss without prejudice. That's what I meant to say. And we will still have that regular variance hearing on November 7th. Is there a second?
I'll second.
Mr. Balagopalan seconds. Is there a discussion on that motion? Seeing none, Senator, how do you vote? No. Dr. Bernstein, how do you vote?
No.
Ms. Verdugo Peralta, how do you vote?
Aye.
Mr. Balagopalan, you vote?
Yes.
I vote yes. Motion passes 3-2. So as a result, we will not have the hearing in absence of notice to the public on the interim, and we will be back for a regular variance hearing. And hopefully, other things can transpire between now and then. We are not having our general meeting. Obviously, we are past our 4 o'clock hour, and we did move that to October 3rd. And so if there's no other business, board members? Yes. Do you have your microphone on?
In all fairness to Howard Industry, the district will, you'll be in violation if you continue to sell after October 1st. The district can issue then an order of abatement, and you go back into discussion.
I don't think we should be advising anyone to violate, and I think Howard Industries was very clear they don't want to violate. But
Did you mean October 2nd? Because we're having hearings on the 2nd?
we also have a hearing on the 3rd.
Okay, I don't
October 3rd, Thursday. Okay. Yes, that's when the general meeting will be moved. We have no other business. We are adjourned. Thank you all for the hearing.
So we're not coming back tomorrow? We're not coming back tomorrow? Okay. Can I give this to you to give to Denise?